I think scholars can precisely debate the boundaries and membership and tenets of the so-called Chicago School of Antitrust, but I think it's an example of our commitment to interdisciplinarity. Now, it's difficult to identify sort of the precise origin moment, but I think the origin moment goes back to the early 1960s when an economist and later Nobel Prize winner, George Stigler, and a law professor, Edward Levy, and appropriately enough, later Attorney General of the United States, came together and taught a seminar jointly on antitrust law. I've had the privilege of meeting some of our graduates who were students in that seminar. And from what they tell me, that the faculty members alternated weeks in teaching. Stigler would teach one week, Levy would teach the next. And each week, one of them would come in and explain why what they had been taught in the prior week was wrong. So this seminar continued for many years with other colleagues, Dean Phil Neal, Ken Dam, and it is an example of our commitment to ideas and to discussion and to debate. Of course, we are also the home of the Journal of Law and Economics, which is a very important venue for ideas in antitrust law. Antitrust remains, of course, a vibrant field of scholarship among our faculty. Randy Picker and Diane Wood are co-authors of the leading casebook. Our colleague Adam Schulten has written about the connection between antitrust law and international trade openness. And of course, Eric Posner, whom you, I think, all know, but will soon know if you haven't met him, who is our Kirkland and Ellis Distinguished Service Professor, is a leading thinker in this field. And I'm very grateful to him for organizing this great conference. So I extend a warm welcome to everyone. It's great to see leading economists, practitioners, legal scholars here. Again, I think this is really in keeping in the spirit of our commitment to ideas and their impact on the world. My thanks to the Department of Justice and the Federal Trade Commission for being our partners in hosting this. I also want to welcome many of our students who are members of our Law and Economics Society and our Antitrust Law Society. And so I also note that this workshop is being live streamed, and through that, it's open to the public. So we encourage the use of the microphones at your seats during your dialogues. And I extend a warm welcome as well to everyone who is in our online audience. So again, it's a great pleasure to welcome you. And thank you so much for being here. I think we proceed directly into the first panel. Thank you very much.
So thanks very much, everyone, for being here, and to those online for tuning in. Again, I'm Susan Athey, Chief Economist at the Justice Department's Antitrust Division. And this is our last of three Department of Justice and FTC sponsored merger guidelines open conferences. And I want to it's a little sentimental because we've been a little bit on a road tour of sorts, getting feedback ever since we released the draft merger guidelines. And this entire experience has been really inspirational to me personally, and I think to a lot of us, about the antitrust community's commitment to this merger guidelines process. This project of having guidelines that help us that help lay out, how the agencies are investigating mergers is something that so many constituents care about. Just in terms of the comments we received, we got thousands of comments. We've actually looked through them all, believe it or not. We have distilled them, we have analyzed them, but also these events have allowed us to get really in-depth back and forth between experts and to move past just, the high-level talking points. So I think this has been a real lesson in how we can get a community engaged to try to get to the best possible product. So let me see if this clicker is now working. Okay. Was that me or was that someone else? That was you. Okay, very good. So we have a virtual clicker. Maybe I'll hold it in my hand as a security blanket nonetheless. So I'm going to start out by giving a little bit of an overview of a few issues, especially geared towards trying to set up some of the panels that we're going to see throughout the day. So I wanted to start with just the general framework of the guidelines, and they've been reorganized from the 2010 merger guidelines. They start out with an overview and then have a series of prima facie tests. They have individual frameworks, although even a specific merger might implicate more than one of those frameworks. For example, a merger between two firms that compete, a horizontal merger might implicate an analysis of the direct competition between the firms in sort of the short-term unilateral effects, as it's called, as well as concerns about coordination. And so those are two different frameworks laid out in these prima facie tests. And then there are also guidelines that pull together different frameworks in specific contexts. And so some example of that is labor, where our concerns, all right, very good. Our concerns about labor market competition or may implicate more than one concern. There could be horizontal or non-horizontal concerns. There could be entrenchment concerns, but for some of the different topics, we felt it was useful to pull together those applications because they have some complexity, or because we wanted to further highlight the special issues of those cases. We have a section on market definition and then a section on rebuttals. And so today we'll have a panel about rebuttals. And so I'll set that up a little bit in a few minutes. Then we had an appendix, as it was called, about evidence and economic tools. I've put up here a question mark 5. So as I go through my remarks today in this last of our conferences, I'm going to try to pull in some of the key comments we've received and some of the themes that have been highlighted as we've gone along, to elevate some of the issues that we've been thinking about. You know, when we titled this as an appendix, it seemed logical to me, but a lot of people have commented that having the economics tools be labeled an appendix was somehow confusing about the importance of it. Just to highlight, though, the reason that those tools were pulled out is that unlike the 2010 guidelines, which were horizontal guidelines, and so all of the tools about how you analyze markets or how you analyze competition were relevant for horizontal mergers, these guidelines might use those tools in more than one framework. So, for example, if you're analyzing a non-horizontal merger, where you're analyzing a case where one firm is buying another, say, product that rivals might use to compete, the analysis of that will depend on, in part, how firms compete in the downstream market, for example. So if it's an upstream and downstream market, the downstream market competition will be a part of that analysis. And so then you also need tools to understand the extent of competition in that downstream market. And so the same tools would apply to multiple guidelines, and that's why we kind of separated them and from where they were embedded before as unilateral effects in the 2010 guidelines. And in some sense, it's their importance, the fact that they are used in multiple parts of the analysis that led them to be separated. They're also used in market definition, and they would also be used in rebuttals. And that's another aspect of this whole structure that at the beginning some have missed, although in our more recent conferences, I feel that it's become better understood among commenters that we do have a rebuttal section, and we do indeed consider rebuttals. And these tools, say tools of assessing the extent of competition between firms, would be relevant for both the prima facie cases and the rebuttal cases. So in terms of why we updated the guidelines, with an eye towards what we're going to discuss today, we first wanted to reflect modern market realities and patterns of mergers. So I think you'd have to be kind of asleep and or hidden in a cave not to see the impact that digitization, the advent of platforms playing a larger and larger role in our economy, and associated mergers as well as associated antitrust, not to see that that's important. And it's also complicated. So these are areas where over the last 20 years, we've seen more and more cases. So the agencies have learnings. We've seen more and more facts. So we've seen whether or not these platforms' leadership get displaced every couple of years or not. We've seen how those platforms what tactics they use to maintain their leadership as the world changes, as technological shifts happen, and so on. And of course, in those spaces, we've also seen just a lot more mergers of multi-product firms, so non-horizontal mergers, but not necessarily simple vertical supply chains, but mergers that involve more complex theories. And so as someone who's been involved in thinking about that from an academic as well as a practitioner's perspective, it is complicated to do all of that, to think about all of that. That's why there's been an explosion of academic literature, because these things are complicated. So we need to write down and flesh out the way these theories work. We need to understand in which case, so something like a single monopoly profit theory holds, and so that, maybe we're not worried about a merger, and in which cases, like if there's scale economies and other kinds of externalities, that those sort of traditional critiques that there's no concern don't apply. And we've seen an explosion of work on that, and work that's really tailored to the kinds of tactics and kinds of practices we see out there in the world. We also have seen an explosion of academic research on labor markets, and we've seen, more and more evidence that there is market power in labor markets. And I remember when I first got my PhD and I was out there learning about labor, I was really surprised that there hadn't been more research into this, because it's pretty obvious. Like, we look around at our jobs and the jobs of a lot of people around us. We care a lot about our jobs. We find it hard to switch. We think about moving cities, maybe moving cities with a partner is not something that's very easy to do. There's many aspects of working conditions beyond wages that matter. So this seems kind of obvious, but we somehow hadn't fully documented empirically, and we also hadn't fully connected that to the antitrust world. And so that's, we see just by the people that we've brought to these agencies. For example, Ioana Marinescu's here, as a principal economist at DOJ. We had someone in this very high level position whose main expertise is labor markets and labor market monopsony, because we are seeing those issues come up more and more in the agencies. So that's one reason that we needed to update the guidelines to flesh things out. Now, of course, the 2010 horizontal merger guidelines were very, very clear that we care about competition and monopsony as well as monopoly. There's an entire section on competition and input markets. That section also makes clear that we're looking just in that input market, that we don't need to go to look at other markets. We're not doing cross-market balancing. So that section is already, I think, crystal clear that the guidelines apply. But nonetheless, there was still some debate about whether it went as far as labor, although I don't read that in the 2010 guidelines, but I think some did. And so fleshing this out and making it very explicit, and also talking about the tools and evidence and how you would connect those to cases, I think is a very important advance, even though it's not actually a new framework in the draft 2023 draft merger guidelines. Then we also have the platforms, and then one of the other panels today will be about dynamic competition. So I'll spend some of the rest of my time, or part of these remarks, talking about some examples of things we think about in dynamic competition as well. One of the key, I would say it's a very subtle shift, but also a very important shift, and especially a very important shift in terms of enabling the analysis of dynamic competition, is our shift in how we think about risk assessment. So Section 7 of the Clayton Act is ultimately talking about risk. It asks whether a merger's effect may be to substantially lessen competition or to tend to create a monopoly. Now, I don't think it was necessarily, I don't know, but I don't know that it was necessarily the intent of the 2010 horizontal merger guidelines to focus everyone just on the precise measurement of effects, but that might have been an intended or an unintended consequence. That in the 2010 merger guidelines, there was a lot of discussion about effects, and some interpreted that to mean that you needed to measure effects and measure them precisely. And that moves you a little bit away from risk assessment. And it also tends to lead you to focus on the things that you can measure with precision. It might lead an economic expert to be afraid to use qualitative evidence or to tell the story of what's really happening on things that might be harder to quantify. And again, I don't think that's a necessary implication of the 2010 guidelines, but it's something that may have happened a little bit as afterwards. And so this is an area, I think, where we can, where by clarifying our approach, we can reopen our analysis to the kinds of theories, economic theories, that are more appropriate and accurate for the cases that we're seeing. So when you move to think about risk assessment, when you say what we're really interested in here is whether there's a risk of harm to competition, that allows you to, first of all, be more honest about how you consider economic evidence. So most economists, either in a theoretical model or an empirical model, understand in the theoretical model, they've made assumptions. They're focusing on some forces, but not others. Otherwise, you can't write it down as a model. So why do we write down those models then? Well, those models provide discipline. They make sure that we have internal logic that's coherent. And they also can help us understand which effects have to be big relative to other effects in order for your conclusion to hold. So economic models are very useful, but they are an abstraction. So when I say my model tells me that, if this effect is big and this is small, and I see some qualitative evidence that this effect is big, that informs my assessment of the risk of what will happen in the real world. It's not a precise prediction, and it may not even have a specific numerical prediction. But as an economic expert, when I see the model tells me this can happen and match it up with the effects, I feel that I can make a statement about risk. Similarly, with an empirical model, your data is limited. You might only have data from a certain time period, from a certain circumstance. There might be noise in the data, measurement error, all sorts of things that would limit your empirical model. Why do we do them then, even though they're imperfect and they're definitely from past data, they're not perfectly predictive of the future? Well, if I have this empirical evidence and I find results there, that informs my assessment of the future risk. And so, the standard error in the model, I run a regression, I get a coefficient on the effect of prices, something like that. I have a standard error, a confidence interval. I think we can get overly obsessed with those things. Those are important. That's one way if you don't find statistically valid evidence, if your findings could be from sampling variation, that certainly affects how I interpret the evidence. But I also know that the entire empirical exercise is limited. It's only getting part of the harm. It's only from a certain setting. And so why do we do that? We do that because it informs our assessment of what would happen in the setting we're thinking of. And so I think it might be very helpful for economists and economic experts to be able to be more honest about the impact of what they're doing. Now, that's going to be especially pronounced when we come to think about things like dynamics, because they are going to be the hardest things to quantify. So it's much easier to quantify a short-term effect than a long-term effect. And it's much easier to know exactly how competition will play out in the short term than in the long term. So by moving to this risk assessment framework, it allows you, I think, to not be afraid to tell the actual economic story of what's happening, even if you can't quantify it perfectly. Now, I should mention that this is not that looking in the long term is not necessarily only beneficial for enforcing, because firms also frequently it's merging parties who want to talk about the long term because they want to talk about how entry will occur in the long term, how innovation will occur in the long term, and so on. So taking this dynamic aperture is not simply a pro-enforcement aperture, but in my view, it's a more accurate aperture. If the reason for this merger is to affect future industry structure, then we need to be able to talk about that. Otherwise, the evidence will not match up with the documents, and they won't match up with how people think about the industry. So even though it's complicated, even though it's hard, if it's right, then that sort of simplifies the story. And I think that in the end, true stories can be comprehended if you tell them correctly. In terms of rebuttals, I've put up a little bit of an outline of a piece of the rebuttal section here. We have a lot of the familiar frameworks from 2010 in the draft merger guidelines. if we look at rebuttals, the rebuttals are going to be about rebutting the whether or not this merger actually broke the law. That is, the rebuttals will be about what is going to show evidence that this merger does not substantially harm competition. It doesn't create that risk. So the prima facie case will be there is a risk, and the rebuttals will be there is not a risk of substantial lessening of competition. So that's how the rebuttals would work. And the same kinds of evidence that would be made for the prima facie case can also come in the rebuttal. So some of the things that have been fleshed out, we need to be sure that whatever efficiencies parties are claiming, we don't care about the efficiencies for their own sake. We care about the efficiencies if they make the market more competitive. Say if two firms merge and they get lower costs and that makes them a more effective competitor, and all of the benefits of competition that customers or trading partners might experience, that's the kind of efficiency that would matter here, because that efficiency would show that there's not a harm to competition. Indeed, this merger is going to increase competition. So just as an example, there might be two firms who their products don't have features that most customers want. So right now they're only serving a smaller market segment, but if they merge, they might be able to have the features that would serve a larger set of customers, and that would increase competition for the customers who would enjoy those products. That's a way that that could happen, but the path through to competition is spelled out here. Another thing that's spelled out carefully, which I think is really important, is barriers to coordination unique to the industry. So you might have a case where technology has changed, economies of scale have gone up, and so we're seeing a lot of consolidation because the minimum efficient scale has gone up and firms are merging to get those scale economies. And that indeed could pass through to more competition on that path. But at some point, as the number of firms gets smaller, you're going to get more and more of an ability for the firms to coordinate. So just because there are lower costs, and if the firms were acting unilaterally, that you might see better outcomes for trading partners and more competition. If you have a small number of firms, they're going to try to find a way out of that. They might do market segmentation, market division. They might do capacity discipline. They might tacitly collude on prices. They might engage in price fixing. It's easier to communicate. It's easier to think about the strategies of your opponents when there's a small number. And so that's an additional effect that would come in, even if there were cost efficiencies that might, with firms acting in a short-term profit maximization way, would lead to lower prices. So some of the big important comments we've gotten here, that first of all, people really wanted us to flesh out more how rebuttal work in cases where it's ambiguous. So the horizontal merger guidelines, it was more straightforward. It was, there was just one type of theory that two competing firms merging. And so they laid out a list of possible rebuttals and examples, but they had fewer theories to rebut. In the 2023 draft merger guidelines, we have a broader statement of how to rebut. It talks about other pertinent factors that might show harm, that there's not a risk of harm to competition, but also a little bit less guidance about these non-horizontal cases. So one theme that's come up in a lot of comments is, how do we know what the limits of these guidelines are, and how would we know what it would mean to rebut them? So that's a comment that came through from a number of people, and that's something that we're thinking hard about. Again, I think it's easier. The answer is easier for horizontal mergers. We have tools about unilateral and coordinated effects, and those same tools would be used in rebuttal. For some of the non-horizontal frameworks, we can think about how to make that more precise. One specific comment that's come in is the idea that, we didn't, in the draft merger guidelines, did not talk about the elimination of double marginalization. Of course, there's an inefficiency. When a supplier and a retailer, say, are acting independently and they are setting prices in a certain way, then they may end up with higher prices to the end consumer, essentially due to a conflict of interest between the supplier and the retailer about the overall size of the profit pie. And the prices end up too high because each one is trying to get a bigger share of the pie. It's a little bit of a prisoner's dilemma type problem between the supplier and the retailer. Now, that can sometimes be solved by contracts, and firms do solve those by contracts. So one one question, then one comment that people have put in is, well, why don't you explain more this problem and then also explain more why it might be hard for that to be merger specific? Because there may be other ways that you can solve that problem other than through a merger. And indeed, we sometimes see those in practice. So I'm going to talk briefly now about a couple of more dynamic theories. One is entrenchment. So the entrenchment section is new in the draft merger guidelines. It wasn't covered in 2010. There's a statement in the 2023 draft guidelines that says we're interested in artificial competitive advantage, but not simple improvements in efficiency. But one comment that we got was that we should be more clear, give more examples about what are artificial competitive advantages, so that we can distinguish this from mergers that might especially be non-horizontal mergers that could just be making a product better. Another comment that came in was how to define a dominant firm, and some commenters have noted that we really might be very likely to use this entrenchment guideline in a case where the market power of a firm is high. Therefore, it might make sense to kind of narrow the aperture of the guideline a little bit to really focus on the more market power on the part of one of the merging parties. There's a question has come up about, well, isn't it hard to predict entrenchment? Like if a firm is buying a complement, might be really hard to know whether they're going to use that complement in an anti-competitive way. So maybe the policy should be to let the merger happen, and then if they engage in anti-competitive conduct, let's go after them afterwards. Now, that seems like a very academic comment, because if you count the number of conduct cases, the number of conduct cases that are won relative to the sort of anti-competitive conduct that even a relatively conservative person might see in the world around them, we realize that going after firms later is not a super effective strategy. And so that is one of the reasons that we have this merger policy. It's prophylactic. This is before the opportunity has emerged, and there's a risk assessment. So we might block a merger due to a risk, partly because we know later it's pretty hard to come back and go after conduct. So this has been one of the policy debates we've seen on panels. Of course, we've also seen people wondering about the impact on innovation. Is it going to be bad if dominant firms can't buy up all the small firms, and will venture capital die as a result? There's of course counter arguments to that about the fact that sometimes, while it matters that a dominant firm can buy small firms, it also matters that those small firms can acquire customers, can get low cost advertising, can get low cost payments, and so on along their growth path. So merger policy is certainly not unambiguously bad for venture capital or venture capital investments, but those discussions have also occurred. Finally, a question has been, why do we need this guideline at all? Aren't a lot of the theories about, say, a firm buying a complement, aren't they covered in the part of the guidelines about a firm buying a product that their rivals use to compete? But those have also been frameworks that have been relatively difficult to use in practice, and relatively difficult to win. In the case where the acquiring firm has market power, that can, I think, really change the conversation around the facts. And also it makes it a little more clear what the incentive would be to engage in any competitive conduct. If I have monopoly power and I'm enjoying that monopoly power and getting those profits, and the complement is something that my rivals might use to compete, something that that might help be a complement to competitors as well. If I can buy that complement as the dominant firm and make it exclusive, then I may be able to maintain that monopoly power. So that incentive and ability both can be informed by whatever the forces were that gave this dominant firm power to start with. They may also relate to the ability and incentive to bring in the complement, keep the complement in-house, keep it exclusive, and erect greater barriers to entry. So one way to think about this is that we're thinking not just about the consumers of today, but also the consumers of tomorrow. And the consumers of tomorrow will be harmed if a dominant firm buys a complement and erects barriers to entry. It might make the monopolist product better today, But why would they continue to invest and innovate tomorrow if they've got huge barriers to entry? And why would anybody invest in competing against them if, you know, they have both multi-level barriers to entry, and also if, you know, they worry that all their complements will be bought up and made exclusive by the dominant firm. So that's going to affect the consumer of tomorrow. That's a more dynamic theory. And then let me just sum up with, you know, the final thing the panel is going to talk about today are trends. One of the things that we've also got comments about, you know, how to interpret whether we were precise enough about how we were thinking about trends towards concentration. One way to think about this is if there is an industry trend towards concentration, it's going to affect your risk assessment. So if the industry has been consolidating and you make a mistake by allowing this merger, it may be less likely that other firms will enter and fix the problem. There's something going on that's making that's every merger in the past hasn't been corrected by further entry, and so we certainly should take into account that context when we evaluate a merger. And we also need to, if we see this trend, there's something happening and it highlights the importance. It's sort of evidence about some of the factors that affect industry structure and affect competition in this industry. So it's a very important set of facts and context to take into account when you're evaluating a merger. And finally, one of the comments we've gotten around this is, well, what if this trend is driven by technology or efficiency? Again, how would you rebut that? So one way to approach that would be, you know, one rebuttal is, okay, there's lower costs. So you might have more effective competitors, which would predict pass-through and low prices, high quality for customers. So you would rebut this, the theory of harm of a trend towards concentration by saying, well, no, it's actually going to be good for all the parties. But again, you would have to also rebut the concerns about coordination. And you would also need to make sure that this was going to be passed through to customers, both in the short and the long run, in the context of the factors that were leading to this trend. So with that, I will hand it over to the panels today. Thanks everyone for being here. Thanks to the panelists for coming. And I'm looking forward to a really robust conversation today. Thank you.
Morning, everyone. As folks are getting settled here, just want to introduce myself. My name is Andy Foreman. I am Deputy Assistant Attorney General at the Department of Justice. I work on civil enforcement matters, and I am honored to be here today. We, as Susan said, rebuttals generally are the second step in mergers, but we have a panel here that warrants kicking off today. So let me introduce them first. I'll say a few things and then we'll get right into it. So beside me here is David Ettinger. David is a partner in the antitrust and trade regulation practice at the law firm Honigman. His vast litigation experience includes successfully challenging and defending mergers in the United States versus Mercy and the St. Luke's case. So welcome, David. Next, we had a little bit of a switch here, but next, Jennifer Steriali, did I get that right?
Yes.
Okay. Is an assistant professor of law at Widener University's Delaware Law School, where she researches intellectual property and antitrust law. Her writings have been published in the Alabama Law Review, the Utah Law Review, the University of Illinois Law Review. A lot of law reviews. And she's a forthcoming publication with Steve Salop in the Antitrust Law Journal. Next, Bill Rogerson is the Charles E. and Emma H. Morrison Professor of Market Economics and Director of the Center for Business Institutions at Northwestern University. So he made the long trip across town. He is the co-director of the Center for Study of Industrial Organization and the Research Director for Competition, Antitrust, and Regulation at the Searle Center on law, regulation, and economic growth. He's also a fellow of the Econometric Society, easy for lawyers to say. His research on industrial organization, antitrust, and regulation has looked at the telecommunications and defense industries. Welcome, Bill. Next, Margaret Slade is Professor Emeritus at the Vancouver School of Economics at the University of British Columbia. Thanks for coming to the States. She is also a fellow of the Econometric Society, the American Economic Association, the Canadian Economic Association, and the British Academy. She has written extensively about industrial organization and horizontal and vertical relationships. And last and certainly not least, Diana Moss is the Vice President and Director of Competition Policy at the Progressive Policy Institute. From 2015 to 2023, Dr. Moss was president of the American Antitrust Institute, an economist. Her work spans the economic policy, legal analysis of antitrust enforcement and sector regulation, with industry expertise in digital technology, energy, agriculture, airlines, telecommunications, media, and healthcare. So we've got a great panel set up here today with both lawyers and economists, and look forward to it. So, today, as Susan said, is about listening for us, and just want to reiterate, thank you so much to the public and to all the panelists for raising their hand and participating in this important process. The comments are going to make the final drafts better, and so we appreciate your engagement. So this is the first panel on section 4 of the draft guidelines on rebuttals. The first paragraph of that section reads, Supreme Court precedent also examines whether other pertinent factors presented by the merging parties nonetheless mandate a conclusion that no substantial lessening of competition is threatened by the acquisition. This statement is directly connected to the Clayton's Act incipiency standard, as Susan said. The Act prohibits mergers that may substantially lessen competition. May, for the agencies, means that we're doing a risk assessment. Firms may demonstrate that there is minimal risk that a merger may substantially lessen competition by rebutting the presumption of illegality. And section 4 details 4 rebuttals specifically that would rebut a finding that competition will be lessened. First, failing firms. Second, entry and repositioning. Third, pro-competitive efficiencies, which I suspect we'll be talking a fair amount about. And fourth, structural barriers to coordination unique to the industry. So today we'll discuss these and dig into efficiencies specifically, as I said. On efficiencies specifically, some commentators, of course, wrote that if the agencies want to maintain fidelity to the law, we should remove the efficiencies defense, whereas others have argued that the draft is a little bit too permissive, or should be more permissive rather on the efficiencies rebuttal. So we'll try to get to the bottom of these weighty factors here today. So first, and again, I'm gonna throw questions out to all of you and prompt, but please, if you have something to say, just raise your hand and we'll get the dialogue going. So first, to Diana. So as Susan indicated, the 2023 draft merger guidelines are structured to reflect the Baker Hughes framework. Each of the prima facie applications in section 2 focuses on competition and a concern that a merger may result in a substantial lessening of competition. The rebuttal section, section 4 that we're talking about, uses the same approach, recasting the analysis in terms of effects on competition. Focusing on the rebuttal aspects, do you think the structure of the draft merger guidelines is useful for the enforcers and the public, or should there be changes?
Thanks very much. And,
The button with the first.
oh, with the green light. Yeah. Shocker. It's a delight to be here, and I really appreciate the invitation to join this group of phenomenal lawyers and economists. To answer the question, I think what we see in the structure of the guidelines is some ideological compromise. we see 13 guidelines that I think reflect real progress, but they do have a commandment sort of feel to them. Thou shalt not do this, thou shalt not do that. And that's fine. And I think, again, there is benefit there, but I would note that the economics are awkwardly relegated to distant appendices and sections. So there's this bifurcation of the legal, the legal doctrine, elevation of legal doctrine from the underlying economics. And we know that law and economics go hand in hand. So I think the reason why that's important is it breaks the rhythm of an effects-based analysis. So in other words, here comes a merger. What happens when you combine assets in any kind of merger, right? Vertical, horizontal. How does that enhance market power? How will that market power be exercised, say through unilateral or coordinated effects? What effects will that have on consumers? Higher prices, lower quality, less innovation. And then how would a rebuttal claim push back against a claim that a merger is anti-competitive? So there's this whole daisy chain of law and economics that creates a logical stream that I think judges have to understand very carefully. And this structure, this bifurcation of law and economics in the guidelines, I think really affects rebuttal arguments. Again, there's no mention upfront early in the guidelines about market power. We see market power referenced in footnotes, but not in the guidelines. No mention of adverse price effects early on in the guidelines. That all happens in Appendix 2. So I think this is really likely to confuse judges. Judges are going to need a logical sequencing of events. Here's a merger. Here's how it enhances market power. Let's dig into that a little bit more with competitive effects. Here are the adverse effects of that. And then at the very end, you know, what rebuttal evidence is there to show that, in fact, a merger will not substantially lessen competition? So I think the risks here are very real that judges will not be given the popcorn trail and they will become confused. We have a lot of generalist judges in the federal courts, right? They're not all antitrust heavyweights. And they will, I think they will be prone to dismissing the guidelines, which I think would be a bad outcome. There's a lot of very good stuff in the guidelines. And they may just revert to the 2010 guidelines concepts or just the case law itself and base their findings on past cases. So I'll leave it at that, but I do think there's some restructuring that would be helpful in addressing this concern.
Yeah, before Jennifer kicking over to you for your thoughts, just following up on your last point there, do you have any specific recommendations on restructuring?
You know, I think it would boil down to this, right? Law and economics go hand in hand. There is a lot of economics in the guidelines, a lot of innovation, a lot of improvements and clarifications. That's all good. I think we have to put the economics into buckets, right? The economics should absolutely make it into the first part of the guidelines based on concepts that are necessary to facilitate legal findings. Let's put it that way. That's a really important bucket of economics. And then we can drill down into other buckets of economics that become more specific and more esoteric, but are nonetheless still very important, and figure out how to insert those economics into the fabric or the structure of the guidelines. But I do think we need some basic economics up front.
Okay, one last question, just to keep pushing a little bit. So specifically as to rebuttals, the rebuttal section, is there anything structurally on that you would recommend? Yeah,
I actually think you should go back to the 2010 guidelines and explain very clearly that what an effects-based analysis is and how very important it is. How does a merger enhance market power? You know, what form will that take? Coordinated versus unilateral versus other effects. What will the adverse effects be? Until a judge can understand what the adverse effects of a merger will be, they will not be able to fully understand or appreciate how rebuttal evidence can show that a merger will not substantially lessen competition. So I think providing that logical sequencing is going to be really vital for judges.
Thank you. Jennifer, your thoughts?
Yeah, so the Green Man. So I generally agree that the economic part of the analysis could be better integrated into the other components to primarily to give judges a roadmap as to how to do an analysis. In part because, well, in addition, I should say, the guidelines are restructured to follow the Baker Hughes approach, but to do that, if you want to follow the analysis of a case through from the beginning to the end, then the economics of that analysis might be better integrated as well. Additionally, though, I think the guidelines could use some illustrative examples, which there were illustrative examples in the 2010 merger guidelines, and their exclusion here in 2023, I think, was a mistake, in part because they can not only provide examples, but they can do a better job of having a narrative that runs through it, explaining how the Baker Hughes burden shifting works. With respect to the rebuttal section specifically and the structuring of that, maybe we'll talk about this a little bit more later as well, but there's a discussion of efficiencies, and there is a difference between the use of efficiencies as a rebuttal versus the use of efficiencies as a defense. And it seems that within that rebuttal section, they're conflated. And I think that they could either be parsed out within that section, or to the extent we want to address defenses at all, then perhaps they should be relegated to a different section. But however they're structured, whether internally or another section, I think it should be clear what the difference is between a rebuttal versus a defense. The only other thing I would add is that it would be nice if the rebuttal evidence was made clear to what showing by the government it pertained, perhaps through a cross-referencing in the rebuttal section. But I just think to make it easier to understand what rebuttal evidence may be used in response to a showing by the government.
Okay. Helpful feedback. Thank you. I do want to touch on the defense versus rebuttal point on efficiencies. But before I do that, does anybody else want to talk about have anything that they want to add on the structure of the rebuttal section vis-a-vis, other parts of the document? Okay, hearing nothing. So let's go on to that point. So, as the document itself said in Philadelphia National Bank, the Supreme Court said efficiencies cannot be a defense to an illegal merger. And the concept of the rebuttal, though, is when the agency refer to efficiencies as a rebuttal, they're saying something different than it's a defense. The difference is that efficiencies are a part, right, of the competitive analysis, which means they cannot defend against a merger that is illegal because its effects on competition, the efficiencies mean that the merger itself is not illegal. So it's a technical legal distinction. What it means between a rebuttal point suggesting that the merger itself is not illegal versus a defense to a merger that has been found or otherwise is illegal. So Jennifer, you've already talked about your views on that. So Margaret, maybe we'll turn to you to get your reaction to this distinction. And
yes, thank you. I find the wording to be extremely confusing. I can't really understand how a merger can be illegal if you haven't considered efficiencies. I don't know, does this just mean market structure that makes it illegal, or what makes it illegal? And I think that the efficiencies have been drastically reduced. Rebut means to refute or to discredit, and they're in a section where you're discrediting things. So the I don't understand why it's this way. People often say that standards of harm in Canada and the US are different, with Canada having a total welfare and the US having consumer welfare. Canada just recently dropped its total welfare. And it seems like the US is dropping its consumer welfare because market structure is taking the spotlight. It's all through the beginning. and consumers are taking a back seat. I also find that not just in this section, but in many sections, there's a move comparing 2010 and 23 from likelihood to certainty, whereas the 2010 would say it's highly unlikely that something harm will occur. The new guidelines say no harm can occur or no substantial lessening of competition can occur. I don't see that as being operational. Efficiencies are uncertain and they may not occur. So it's not possible for no harm to occur. So, you can say that it's highly likely, but you can't say. I mean, even if the probability that the benefits exceed the costs is 0.9 times, there's still a positive probability that it won't happen. Other conditions seem too strong. Efficiencies cannot result from worsening of terms for trading partners. Trading partners are both customers and suppliers. Does that mean that no volume discounts can be attained because the merged firm is better off? Is bigger. Can it not get more efficient suppliers? Suppose there were two firms merging. They bought the same product, one from an efficient supplier and one from an inefficient. Does the merged firm have to continue to buy from the inefficient firm? What about if bargaining strengths improve? Is that bad that you get better terms, even if sellers or buyers are strong? You might have a monopolist seller or a monopolist buyer. You think worsening the terms of trade of those trading partners would be good. So I would like to see a more balanced treatment of efficiencies. And sometimes I think that what I read is not what was intended. And therefore, it would be very helpful throughout to have examples that says, this is what we do mean, and this is what we don't mean. Thank you.
Are there any specific areas in the efficiency section, Margaret, that you feel like would benefit from examples?
A lot. Yeah, I think there should be examples in each one of the sections.
Okay.
I agree.
It sounds like it's theme. All right, David, turning to you as a litigator, obviously, there's a lot of law cited throughout the draft merger guidelines, including in the efficiency section. I mentioned Philadelphia National Bank, what that says, and then and the like. So as a litigator, how do you see this issue play out in practice and the like?
And I'm glad you phrased the question like that, because I had some trepidation about appearing today because there are all these deep thinkers thinking about what the right answers ought to be. And I'm just in the trenches trying to argue a case based on whatever the rules are. So I do want to focus on kind of what I've seen and what insights or questions at least that raises. The issue where this rebuttal notion becomes most important in my experience is when you have mergers where the obvious anti-competitive effect is on price and the efficiencies are claimed to be on quality. We saw that, for example, in the St. Luke's merger, where my client was a co-plaintiff with the FTC. We both brought cases. We litigated the case together. The claim was that hospitals buying doctors' practices would improve the quality of care. And we won the case in part by saying these were not merger-specific efficiencies, but we also said, I remember I argued, this doesn't rebut the claim that prices will go up, and therefore it doesn't count. I argued that to the district court. He ignored it. We won on the other issues. The Ninth Circuit picked up on it and said, this is a serious issue, but we don't need to resolve it because it's not merger specific. You could argue that kind of quality defense is really not about competition and ought not to be considered. You could also argue that what somebody is saying there is that a merger may harm price competition, but simultaneously increase quality competition. And then I guess one might say, well, it doesn't matter if there's harm to competition along any dimension. That's a problem. Is that what the guidelines are saying? I don't know. I don't know if that's clear. But the contrary view would require you to somehow weigh these benefits and costs in different dimensions. And I don't know how you do that. Having said all that, and consistent with the notion that I'm just going to throw out questions for you and not do the hard job of fixing them, let me give you some hard cases the other way. So in healthcare, again, I do a lot of work in healthcare. It's well established. There's a lot of literature that says that for many kinds of surgical procedures, quality is much greater when enough procedures are done at that facility. The doctors are better, the nurses are better, fewer people die. So suppose you have two institutions that merge, and so they only do open heart surgery at one place. They do other difficult surgeries only at one place. And as a result, they say fewer people are going to die. Is that something that ought to be ignored if somebody believes there may be price effects? Is that something that ought to be ignored? For example, if one of these hospitals may not meet the failing firm defense, but it's going to cut back on services, there's going to be less access. People are going to have to travel farther for care. That's another quality defense. Should it be irrelevant? Or another quality defense I've seen outside of healthcare pretty commonly. This will allow us to provide one-stop shopping across a series of products and services our customers want. That's another dimension, I guess, of quality competition. Ought that to be ignored? And to put kind of a finer point on it, with the very tough requirements in the draft guidelines in terms of concentration, as I read it, a 30% company buying a 3% company would violate the guidelines. Would you prohibit a merger between a 30% and 3% company with some of these benefits there? I mean, I think those are hard policy questions. I would submit that in reality, in practice, the agencies consider these questions all the time and make decisions not to prosecute based on them. And one thing that bothers me a little bit, because I've argued similar things. And even though technically a merger may have been problematic under the guidelines, maybe more clearly problematic under these new guidelines, the transactions were approved, and I think appropriately so. And one thing that worries me a little bit is with these new guidelines, there will be an even greater divergence between the guidelines and the practice. And I don't know if that's a good thing.
Can I add a small thing here?
Absolutely.
I certainly agree with you that quality should be part of the assessment. And I think the spirit of rewriting the new guidelines was actually very consistent with that. The old guidelines used to say, we're going to look at price, and then they put in parentheses. Price is just a metaphor for many things. Yeah. But then they only always talked about we're looking at price. Now, originally as an economist, I find it a little irritating in the new guidelines that they say more competitive is the thing we want, right? Because that isn't really, an economist would say we want efficiency, taking quality, price, everything into account, and perhaps maximize total welfare or some measure of welfare. But, I think they purposely tried to make a step forward in these guidelines by not using price all the time, and then occasionally saying, this is just a metaphor, we consider quality too, right? I agree with you. There probably should have been an addition, specific addition, saying quality has to be traded off against price.
Well,
but I do think the guidelines, the overall structure, the way they're written, they tried to move in that direction by not saying that just using the word lower price is what we're looking for all the time.
Well, just to be clear and avoid having this quoted against me by people where I'm a plaintiff and I'm trying to stop deals, I'm not sure I'm saying that quality ought to be traded off. And
yeah.
The problem is I don't know how you trade it off. What do you do, a survey and figure out what how much people would value these quality benefits and then to apply that quantitatively to price? That's not going to happen in the real world. So it's a hard problem to say you consider quality as well, I think. I don't have an answer. Again, I have the easy job. I'll just raise the
except that to the extent, you acknowledged that there's prosecutorial discretion used, which was in the 2010 guidelines in a footnote, but at least acknowledging that prosecutorial discretion, for example, is exercised, acknowledges that there are trade-offs to be made, and whether that has to be explicitly mentioned in a more direct way. Maybe that's the issue, right? Rather than, as it did in the 2010 guidelines, delegating it to a footnote or otherwise into some sort of subtext. But I think acknowledging it directly is the way to address it.
Well, I'm not sure that one should relegate quality decisions only to prosecutorial discretion. I think quality really is an issue, and you described a really compelling example of that when you talk about number of surgeries, and so that probably should be allowed as a defense, in the guidelines that could be made in court and acknowledged. Now, I agree it's going to be hard to figure that out, but I wouldn't say, well, there are some things that are obviously important, but we don't really talk about them, and they just privately use that ahead of time to decide whether to bring the case. I think they probably should mention quality.
Yeah, just following up on that, I mean, is there anything specific? This is very, helpful and a great discussion. Is there anything specific, and, now or upon reflection, pass through to us that you feel like would address some of what you're talking about, that there may be a gap in what is in the current guidelines in terms of what is being communicated that we would consider?
Well, I thought our first speaker really said, a lot of people here have said they love the examples in the old guidelines, and I'm one of those too.
Okay.
And I didn't even really know I loved them until I read the new ones and they went down. Right? I thought, oh no, these are for people who can't think clearly or something, right? But they're really helpful, I think.
Okay.
And maybe just an example that said a hospital is going to dramatically improve the performance of its surgeries, but there'll be a small price effect too, and acknowledging this would be difficult to evaluate, but certainly ought to be taken into account. Perhaps
Yeah, Diane,
I just want to, I wanted to add that just to reinforce what Bill is saying, but also what I mentioned earlier, all the discussion of price effects, quality effects, innovation effects, it's all in Appendix 2. It's at the end of the guidelines. So anyone reading the 50+ pages of guidelines is not going to encounter a substantive discussion of how mergers have price and non-price effects on price and non-price dimensions. They will not encounter that, until they wade through 50 pages of guidelines. That's why I think this sort of fits in the bucket of essential economics, right? To link up essential economics with early in the document, either in the guideline section or to whatever rearrangement is necessary to give judges that roadmap, which they really, I don't think, are going to get under its current structure.
helpful. So I want to switch to out-of-market efficiencies. A question about that, and Bill, throw it over to you again. But does anybody else have anything broadly on this topic before we go on to that? Hearing nothing. Okay, so the draft merger guidelines say the agencies will not credit out-of-market efficiencies. I think it's footnote 106. And Bill, I know you have some thoughts on this that you want to share. So
yeah, I think you're not quite correctly summarizing what the draft merger guidelines say.
Okay.
I think they talk about input cost savings, and they say that they won't credit input price reductions if they, and I'll quote this, if they result from the anti-competitive worsening of terms for the merged firms' trading partners. And in a footnote, they specifically mention the case where a horizontal merger causes input prices to go down because of an increase in buyers' market power. And they state that these type of cost reductions will not be, unambiguously, will not be credited as an efficiency in black and white. Okay, so what they're saying is lower prices due to cost reductions of, let's say, we're really talking about maybe arguably just volume discounts, right? Just to, be a little more concrete. They're saying if a volume discount is based on actual cost reductions in providing larger volumes, then we would count that as an efficiency. However, if a volume discount is based on the fact that guys that buy more are more important to you, and you somehow have to give them a slightly better deal when they threaten to walk away, that they won't allow those, roughly speaking. Okay. Now, so they do allow a certain kind of input cost savings, but only a certain kind. Now, I think what this is, this has always been a very gray area in the antitrust law, that to do with buyer power, that there are two kinds of input markets, you might say, or two kinds of markets, right? One kind of market is a market where all the sellers are small, atomistic, and little guys, and they're all the same. And it's appropriate to think of there's a supply curve, and there aren't individual deals or anything. There's a price, and that determines how much is supplied. Okay. But a lot of input markets, especially these days, are very large buyers facing very large sellers. And the deals they negotiate are individual deals between the two of them. Now, in the former case, where there's really just a supply curve, if market power, buyer power causes prices to go down, there really will be less supply. And when there's less of that input supplied, there's going to be less of the output supplied too. And consumers in the downstream market are going to be hurt too, right? And there's also a sense, even if you talk about inefficient use of inputs, this input that's now not priced properly isn't being used in an efficient way anymore, right? So there's a real efficiency justification going on in that case, okay? But the other case, where you have large entities negotiating personal, kind of pricing deals that apply just to them, especially when they're restricted to using linear prices, perhaps just by the transactions costs of other sorts of things, it can work out very, very different, okay? And it can be the case that reductions in input prices due to kind of more bargaining power have really no efficiency effect on the input market at all, and actually improve consumer welfare. Okay, so let me give you an example that I was involved in. I was the chief economist at the FTC. This occurred after I left, and they brought me back occasionally to work as an outside expert on mergers they were considering. They were considering a merger between DirecTV and AT&T, which were at both pay TV providers, okay? And so these guys buy programming from people like Disney, video programmers in an upstream market. And usually what they do is they agree to a per subscriber per month fee. So they say with Disney, we agree that you're going to count up how many people see this channel, and you get X dollars per subscriber per month based on how many see it. That's the nature of the deals they sign. And then there are also, they sell pay TV in the downstream market, okay? In this market, larger entities get better prices. And it's probably not because of any cost efficiencies. What it really is bigger guys say, if you lose me, you're losing 30% of your sales. You're going to get fired if you lose me. And a little guy who's 5% of the sales can't say that. And that ends up in the real world, meaning that the larger buyers get lower prices, okay? Now, in this particular case, DirecTV was much bigger as a pay TV provider than AT&T. Right? And what that meant is DirecTV might have been paying Disney $1, but AT&T was paying Disney $1.50 per subscriber per month before the merger. Okay, what was the merger going to have happen? Immediately after the merger, it was a legal fact that the way the contracts were written, that AT&T would begin paying $1 a month per subscriber. It would get DirecTV's fees. And these are real marginal costs to people, right? And monopolists pass through real marginal cost savings, even if they're a monopolist. So likely a lot of this was going to be passed through. In the longer run, next time that DirecTV and AT&T come to negotiate with Disney, you can bet that if anything, they were going to get lower prices than DirecTV would have got by itself. Okay. So what you have in this case is the merger was going to cause lower prices for the video programming. And what that meant is that video program pay TV prices in the downstream market would likely drop, passing through some of that. And actually more people would be buying video programming than before. So it's true there was a welfare transfer, but there's really no efficiency loss of any kind. And this has always been a very gray area in antitrust. And I think what really happened here is, and I agree completely, you know, Susan's first remarks were so lovely in 100 different ways. So it was just a treat being here to listen to how she described everything. And I agree with her completely that people were overlooking market power in labor markets, right? These are markets where there's an upward sloping supply curve, right? And I think really topmost in people's minds were, if two hospitals that are the only two major hospitals in a local market want to merge, they do not want those hospitals to be able to say that paying nurses less is an efficiency. And I agree with them completely, okay? But I think they went a little overboard when they kind of came out in black and white and said, I think there used to be much more, they left it kind of hazy, but they kind of left it more clear that input price reductions are definitely a problem if they cause a reduction in the amount of input used. And it's a more open question if they don't. And you guys went one step further in the direction of saying, no, those would never, that's completely irrelevant. And I think that's a mistake, probably, but I know the rebuttal probably would be that, oh, these aren't that common, and that's such a complicated thing, and we were making nice prima facie guidelines right up front that anyone could understand, and we said it. But I actually think there's going to be cases where people might really misuse that clear factual statement, in ways that would be harmful. So maybe it was a mistake to have such a clear guideline that's not completely correct.
Thank you for that.
Yeah, but I promise to hardly talk at all.
No, this is why we're here, and this is great to hear perspectives. I will say I agree with you on one thing, which is it's always great to hear Susan speak, and that's one of the best parts of my job. So
it was a real treat, I must say.
So David, a lot there. There's also, you've talked about your experience again in the litigation world on efficiencies. Obviously, I think the DC Circuit's opinion in Anthem maybe touched on some of actually what Bill said too in the healthcare context. But I wanted to turn it over to you to see if you've got any other thoughts on.
Sure. Two thoughts. One on piling on with Bill on the footnote. What the footnote doesn't address, and what in some ways is an even harder question, is what about pro-competitive efficiencies that occur in a second market? In healthcare, doctors and hospitals are complementary, and something that may harm competition in a physician market, somebody may argue reduces costs at the hospital, and therefore maybe lowers prices in the hospital market. Again, how do you handle those trade-offs? Do you exclude that or not? I think that's an open question. One issue, if I could just take a second on something that's not kind of something we talked about discussing, but Susan's comment stimulated it. I'm all for the idea that efficiencies have to be verifiable. I will say I have had more than one, experience in my career where CEO and management of a very large company doing a very large deal based their decision on efficiencies based on little more than back of the envelope calculations. It was amazing to me. I won't characterize how often that's happened. At the same time, when you're now talking about, as Susan did, longer term effects and risk and how we don't have certainties, we can't easily quantify it. Is it really as appropriate to say that because efficiencies are speculative, we're going to apply such a high standard if we're not going to apply that to the prediction of anti-competitive effects? Shouldn't they be on the same, should the same standard apply?
Love to talk with you about that over coffee, but a good thought. Yeah, Diana, you wanted to.
I just wanted to jump in on this because I think the concept of not crediting out of market efficiencies could really have very deep implications for certain sectors. So take airline mergers, which we have on deck right now, obviously. But, a typical airline unpacking of an airline merger would be, well, where does the merger eliminate head-to-head competition on nonstop routes? Okay, so a competition is eliminated. Typically, in airline mergers, the defendants come back with analysis that shows, well, look, our merger is going to produce all sorts of benefits in the form of increased connectivity, new service to new destinations, more frequent service. That's all out of market stuff. That's all out of market stuff. I would also argue in the case of, say, an electric utility merger, which I spent 10 years only doing electricity mergers at FERC, same idea. A merger between two utilities would eliminate head-to-head competition, but the benefits of improved reliability or relieving constraints on a transmission system would occur out of market, right? In other parts of the system. So what do the guidelines think, these proposed guidelines think about those kinds of mergers where a ban on out-of-market efficiencies would basically make the merger presumptively illegal? Because there is no way to make an argument that those efficiencies will reduce incentives to raise prices, restrict output, lower quality, all those kinds of things. I think they're anomalous cases, but they're important enough to be considered in this context.
If I could say just a bit on that, I think that's a great point, and it's particularly compelling when you're talking about narrow geographic markets where you're complaining about anti-competitive effects. And there are lots of other geographic markets in which the same parties play, and your examples are exactly like that. Airlines, you're talking about city pairs. You say, well, competition is going to be less from Detroit to Chicago. Well, it's going to be greater from New York to Detroit and Syracuse to Detroit and Hartford to Detroit. And the answer is we don't care. We only care about Detroit to Chicago. Now, nobody's going to sue them if it's only Detroit to Chicago, but still, there seems to be something a little peculiar about worrying about certain narrow geographic markets and excluding others. I don't know what the answer is, but it does seem to be kind of anomalous.
Well, if I may, the trouble though is that if you have out of market efficiencies that are considered, then you're preferencing some consumers over other consumers, right? You're preferencing the consumers who are benefiting over those who are harmed, and they're not going to make any exchanges of deals with each other such that they're going to have any wealth transfers between them, right? So I think the reason for not considering out of market efficiencies is because there's still a subset of consumers who are harmed.
Yeah, and I'll just note, obviously, there's some I don't want to comment on anything ongoing, some relatively recent law on this with the Northeast Alliance case, which talks about this issue in airlines pretty squarely. So anything else on that before next subject is double marginalization. So anything else before we move on to that? Okay, so as Susan talked a lot about, that we've gotten a fair amount of comments on the fact that EDM or lack thereof, the discussion of EDM or lack thereof in the draft merger guidelines. And Margaret, let me start with you. I know you mentioned this a little bit too, but did you want to augment some of your comments and drive anything else home on how you think it should be treated?
Oh, okay. I do think it should be in the guidelines, but I don't think it should be in the rebuttal. And that is because it's not, efficiencies we usually think of are cost efficiencies. And traditionally, a merger has a market has a supply and demand side. Traditionally, the agencies have the demand and pricing effects and so forth. and the merging parties are responsible for the supply cost reductions and so forth. Well, clearly EDM is a pricing effect, it's a demand effect, and it can't be done in isolation. It should be done with the rest of the pricing that's going on, probably with the cost as well. But that would mean that it has to be in the beginning, I mean, it's for the agencies to present rather than to rebut. I actually feel that EDM is often overemphasized. Often it's the only efficiency that's considered, and there are lots of other efficiencies that have to do with risk reduction and coordination and investment and so forth. But it is, I mean, like in AT&T Time Warner, it was, I think, pretty much the only defense. Well, we have to quantify it, and one can't really just use there's a simple model, textbook model, that's very easy to understand and to quantify. It has a monopolist upstream and downstream. The first produces a single product and the second sells that single product. And you can show easily that the total surplus is one of the EDM effects of the markup is eliminated, which is good. However, if you relax any of those assumptions, the predictions change, and usually in the direction of limiting the amount of efficiency. In fact, prices can even rise due to ETM and multi-product settings. So if you want to quantify, and I think in many cases this has been done, but you have to take seriously the technology up and downstream, the link between the two, the up and downstream. Is it bargaining, take it or leave it? Are there multiple products up and down seed? And with that, it becomes at least as difficult to do as other types of efficiencies. People say, oh, we can't look at these other things, quality or something, because it's too difficult. But this is a difficult problem too. It's much more difficult than just looking at the unilateral effects in a horizontal merger. I think that's about it for me.
Okay. Bill, maybe you first and then Diana, just maybe a minute or two on the EDM stuff. We're going to do a few lightning rounds here at the end to finish.
So I agree with everything that Margaret said, because I'm another economist, I guess. But to me, this it's unrealistic at this point to tell the drafters, I wish you had done horizontal by itself and then other kinds of mergers separately. But the fact that they didn't talk about EDM, it really is a complicated subject. And I agree with Margaret that people's idea that EDM always happens really depends on this very, very naive idea that upstream firms charge linear prices to downstream firms. So those of you who know what that means, know what it means. And those of you who don't, we don't have a half hour to discuss it, right? But it may not happen at all, right? Right? And given they had this one set of guidelines that was supposed to talk about everything, I think they probably made a reasonable decision to say, there's no point mentioning it. But I think this shows the problems with this idea that we have a Swiss Army knife that, that has like almost like a dishwasher attached to it, among other things, right? And you can barely carry the Swiss Army knife around because it does so many things. And I think a lot of these even calls for clarity and stuff, if they had only done horizontal by themselves, I think integrating the economic, the economics isn't as clear in vertical mergers or when somebody's buying a complement, and there's all these disputes about even what the theory says. And so I think in a way, if horizontal had stayed by itself, then they could have talked about EDM in a more substantial way. And they should have said, and I think the guidelines should have said that there should be no presumption that vertical mergers are always have efficiencies compared to horizontal mergers. This is just a completely neutral question. And also, it's a EDM could happen, but it depends on issues too. And it's not clear it will happen or won't happen. You know, but it was hard to do that, given you wanted to produce a Swiss Army knife that had everything.
I'm not sure I'm ever gonna get the Swiss Army knife dishwasher.
Well,
thing out of my head. But the,
It's convenient.
No,
to
no, no,
have
I'm
one
saying
with a
out of my
purpose
head.
tool,
I'm gonna
but,
think.
you can't, you decide you can't put big things on it, but maybe you'd really rather have a big thing.
I think you should,
But you-
I think you should talk to somebody at Northwestern or Chicago to trademark that or intellectual property it or something. Okay, yes, Margaret.
I just
and
want to
then-
add
and then
something, 'cause
Diana.
Bill mentioned compliments. That's a simpler, when it's just compliments. And there, the problem is that many of the demand systems that people use, everything is presumed to be substitutes. There is no, but if you're going to consider upward pricing pressure, why don't you consider downward pricing pressure in the same model? So you have to have something where the diversion ratios can either be positive or negative. And then you can do complements exactly in the same model that you do substitutes.
Do you have a minute on this?
Yeah, I have a minute. So I will be the third to agree that EDM is super sketchy and we should, really downplay it for all the reasons given. But I wanted to add some other dimension. Even if you believe in EDM and you're a big EDM fan, we are well served by turning to the strategic management literature, which I think IO economists should really pay more attention to, and the marketing literature coming out of business schools, which really talks about the difficulty of mergers, just generally. Managers have trouble integrating divisions post-merger. They often have to be spinning off assets while they're integrating. This is tough stuff. It's kind of a bounded rationality problem. And this all goes to the concept that non-cost efficiencies, whether it's economies of scale, scope, or coordination, those should be facing an even higher hurdle. They're very, very elusive. In fact, the strategic management folks have done studies showing that 70% of mergers fail to produce revenue synergies, which are these non-cost, more dynamic, longer-term synergies associated with pushing out the demand curve. So we could take a big lesson from the business school disciplines in industrial organization economics. And we have great examples of this, right? AT&T Time Warner, less than 3 years post-merger, they decided, we really didn't mean to vertically integrate. This wasn't a good plan for us. The action's all in ISP distribution. So they spun off Warner Media to Discovery. So much for all of those claimed efficiencies that sucked up, hundreds of hours of time in a federal court. So I think we've heard this before. The guidelines would really benefit from more examples on the economic side. We've got all the case citations to case law. That's all great. But let's even that up. Let's balance it up with some really nice examples from cases, not only on efficiencies issues, but also what are the market power scenarios we're trying to avoid here with these new merger guidelines? What are the Armageddon scenarios, the 4-to-3 mergers, the acquisitions of smaller rivals by dominant firms? I think the guidelines would be very well served in speaking to the public, to courts, to practitioners by providing those types of examples, along with all the great legal citations we see.
Gotcha. Excellent. Okay. So I think just given timing and whatnot, I want to finish with 2 lightning rounds. One is we've talked a lot about efficiencies, but I do want to give each of the panelists a chance to talk about any of the other sections of the rebuttal part of the guidelines, whether that be entry, whether that be failing firm, whether that be the coordination or anything else. And then I'm going to end with just giving everybody an opportunity to say whatever they want for a minute or two. So, but let's focus, I guess, do a lightning round on anything that's not efficiencies related in the rebuttal section. David, want to
Sure.
start?
Failing firm. I really don't like the first sentence of this section. I think it's wrong. It says, quote, when merging parties suggest the weak or weakening financial position of one of the merging parties will prevent a lessening of competition, the agencies examine that evidence under the failing firm defense established by the Supreme Court, close quote. What that says in English to me is financial weakness cannot matter unless you satisfy the failing firm defense. I think that's wrong in terms of how the agencies actually practice. It's wrong as to how the courts look at things, and it's wrong as to how the evidence ought to be analyzed, because a firm's financial weakness can matter a lot in terms of its inability to invest, its inability to maintain its staff, and all those things can affect its competitive condition in the future, both immediately and in the longer term. And that's relevant to competitive issues. I could say I've raised financial weakness at least a half a dozen times in arguing mergers before the agencies over the years. And with one exception, I specifically said I wasn't arguing the failing firm defense because I didn't want to get embroiled in all those technical requirements. But everybody acknowledged that the financial weakness of the company was a relevant factor. And I think it's important that the guidelines not suggest that it isn't.
Jennifer.
Thank you. So I think that the guidelines would do well to provide further details about both serial acquisitions and potential competition. So with respect to serial acquisitions, the primary concern seems to be a horizontal effect in a particular market that accumulates over time. So for example, firm A operating in market A acquires first A1 and then A2, which maybe isn't problematic, and then eventually A3 and A4, and then it becomes a problem. But I think an acknowledgement that firm X might acquire A1 and then B1, and A1 and B1's assets can be combined such that now there's a horizontal effect, is also a serial problem. And it also makes sense why it might not first be apparent upon the first acquisition that it's a problem. With respect to the potential competition doctrine, it's typically thought of as a horizontal problem, but there's also a vertical element to it, right? Which is that a firm could acquire an upstream input and have a vertical dimension to it, where they acquire a market in which they could have innovated instead. And then there's the combination of the two, serial and potential, where a firm could acquire serially upstream inputs that could be combined. And so I just think acknowledging that, and maybe this is making the Swiss Army knife too heavy, but I think that those permeations, or at least a tip of the hat to them, may be worth it.
Jennifer, is there anything specifically on any of the other rebuttal categories that you wanted to talk about?
No, but I thought you were giving me another opportunity to add. So I'll add one other thing, which is,
I will.
Thank you. That I think this problem is particularly acute in where the acquisition is of something like patent portfolios, right? Because it might not be apparent how technologies can be combined initially, but once it becomes apparent, then the agency should have some recourse to review the entire series of acquisitions, for example. But no, I have nothing else on the rebuttals.
One quick addition on the failing firm. To put this in context, I don't think the draft guidelines substantially changed from the previous version on the issue of failing firms. So the issue that you brought up, has been a long-term issue that people talk about. But I think, that you made radical, you really took huge step forward on platforms and all sorts of, truly pressing things. And I don't blame you at all for just maintaining the status quo on this issue. This was an issue at the old guidelines, and you just maintained the status quo. And it's not like we're criticizing like a new thing you're doing. It's just I think you had bigger things to work on, and you did.
So am I to take it that we're not going to have a separate discussion?
No,
on
you will.
entry?
I'll give everybody a chance. So is there anything on I think, Margaret, maybe we were thinking entry and repositioning. Is there something you wanted to mention on that?
Yeah, I
Okay,
do.
Great. I think that's a good time to do that.
The draft, the way it's written, it says entry no harm can occur in any market. No harm. And that seems to imply that somehow the potential entrants can come in before the incumbents can change their prices. So that's a rebirth of contestability. And it doesn't seem like a reasonable assumption. Entry is by nature costly. It takes time. Entrants have to recoup their costs. And I have a quote here from the 2010 guidelines that says, entry must be rapid enough to make unprofitable overall the actions causing those effects and thus leading to entry, even though those actions would be profitable until entry takes effect. So this is a dynamic view, and entry is by nature dynamic. The costs and the benefits occur in different time periods, so they have to be discounted. Entry is uncertain, so you can include in your discount factor the probability that it'll occur. But at least with that sort of view, I mean, that sort of approach, you can imagine that entry would, I mean, that it's possible for entry to be good. But when it says no harm will occur, that means no, we won't allow entry. That's really mostly what I wanted to say.
Diana, did you want
Just
to?
really quickly, I was, my hopes were high when these guidelines came out that we would see more reference to high concentration as a barrier to entry. Maybe it's in there, maybe I missed it, but I think it's really important, given the sort of general increases in concentration across markets that we've seen in the last 40 years. It's a thing. It's high concentration is absolutely a deterrent for firms to enter. And, take retractable syringes, Becton Dickinson, big market incumbent, retractable technologies tried to get in, and their market share did not grow, right? Look at chips, look at Intel and AMD. AMD's market share remained at a very low level for a long period of time. No other entry into that market. So it would be nice to explicitly acknowledge high concentration as barrier to entry. And then the other thing is more discussion of two-level entry. We've seen so many sectors vertically integrate where we're now dealing with these large vertically integrated systems. Take agricultural biotech, right? Seeds, traits, agrochemicals, digital farming, all fully integrated. And we lost 3 out of our 6 large biotechs in the space of 3 years back in 2016, 17. So we now have these massive systems, and any single firm trying to get in at a particular level of entry faces an enormous barrier because they cannot enter at more than one level. I would have liked to see more on that given recent changes in markets.
Thank you. Helpful. Okay, so we have about 5 minutes left. But I promised that you would each get 2 minutes at the end. So I will take the heat for if we go 5 minutes over, and just really open the floor up. Anything you want to say about again, what is or is not in rebuttals, what you would add, or anything more broadly about the merger guidelines. Look forward to your thoughts. David, why don't you start?
I think maybe I'll be popular in this. I'm gonna punt and leave it to my colleagues. I think I've offered the thoughts that I have strong feelings on, and while I have to say that the tougher concentration standards make me a little queasy, I'm not sure that the case is compelling for making the standards tougher, when in practice, I think the concentration standards have been higher than the existing guidelines provide. Beyond that thought, I don't have a lot else that I feel that I would quarrel with. So I'll let others go on.
Jennifer?
Yeah, so I 2 other things. One is I think that the guidelines might note that they make a note of foreclosure, but they might note the possibility of partial foreclosure, right? So sometimes in response to a vertical merger, the firms will offer that they've made commitments to provide rivals with access to an upstream input. And I think the guidelines should note that they're not going to give very much weight to those sorts of commitments insofar as it enables the firm to partially foreclose by providing those access to those resources on less favorable terms. The second thing I would just note is that, following up on Margaret's comment about entry and repositioning, is that also the guidelines might note the possibility of expansion, right? That and rebuttal, that firms already existing in the marketplace could in fact expand their competitive efforts. So for example, their production, and that could be offered in rebuttal. Thank you.
Thanks. Bill?
I'll pass.
Okay.
I want to say something positive since I've been negative. My biggest, the thing I like best about the guidelines is the increased attention to labor and to workers. And even though I think it was implicit that they could be handled under the existing law, to emphasize it is good. And perhaps even go a little more, because labor is very different from other inputs. people have preferences over jobs. And that gives additional market power to firms, to buyers. Carbon steel doesn't care what firm it goes to. So the only heterogeneity is in the buyer side, but it makes it, and labor markets tend to be very local. And so concentration may be quite high. They don't have to be producing the same products, but they may be employing the same workers. And I think that I think labor is going to become more important, and it's good to have this mentioned.
I see Joanna smiling up there. So, thank you for that. Diana, I wanted to,
Yeah,
We'll
so
leave it
on,
with you.
on a positive note, I think there's a lot of good stuff in these guidelines. We have more presumptions of illegality. We see more comprehensive framework guidelines, applications guidelines. I think the clarification of efficiencies analysis in terms of rebuttal evidence versus more of a defense, which is, oh, well, there was an anti-competitive effect, but the pro-competitive effects outweighed that anti-competitive effect. That clarification is stellar and badly needed. I like that the efficiencies discussion really builds out the specificity, the verifiability, the importance of pass-through. Efficiencies must be pro-competitive. I think that's a real innovation. I think we also have to consider that these guidelines might be adopted by other agencies. When I was at FERC, we officially adopted at the commission the 2010 merger guidelines. We wrote our own merger guidelines based on those principles in the agency's guidelines. That's if you've got other agencies modeling after the guidelines, I think that extends the reach of the guidelines dramatically into sector regulation and oversight. And then finally, the same point I made earlier, hopefully this final version will read as if this is a roadmap for judges. We don't want to confuse judges any more than they're already confused about antitrust. We want better, stronger enforcement, and we need guidelines that are substantive, have a substantive aspect and a process, procedural, structural aspect that makes it easy for judges to put all of these pieces together, because that's where antitrust is decided in the courts.
well, thank you all for such a thoughtful and instructive discussion. Why don't we all give the panelists a round of applause?
All right, so welcome to our next panel on labor market competition. I'm Joanna Marinescu, I'm the principal economist at the Antitrust Division, and I think we've been really nicely set up by Susan's introductory remarks on labor market competition, and also Margaret just mentioned that as an important addition. So thank you so much for mentioning that. We have a really great slate of panelists here that I'm going to introduce to you, and then I'll deliver a few brief remarks, and then we'll get into the conversation. And I encourage my panelists within reason to compete for speaking and make it a lively discussion. So I really look forward to that. So we have here, I'm gonna start from the closest person to me. We have Ellie Prager, who's an assistant professor in the Simon Business School at the University of Rochester, where she researches industrial organization. She focuses on healthcare markets and labor markets, and she has a great paper on hospital mergers and the impacts on labor, which I really love to cite. And Ellie, also from 2021 to 2022, was a visiting scholar with us at the Department of Justice in the Antitrust Division. And then we have Beatrice Marquez, who is an enforcer. She's an assistant attorney general in the office of the New York State Attorney General. And for her work on the T-Mobile Sprint Challenge, she received the Louis Lefkowitz Award and the Rising Star Award from the National Association of Attorneys General's Antitrust Task Force. And Beatrice drafted actually the labor market comments. We're here to comment on the draft merger guidelines, and she drafted the labor market comments on behalf of 15 states in response to the draft merger guidelines, and as well as the comments in response to the FTC's proposed HSR form rulemaking, which also includes labor specs for the HSR. So that's also an interesting development as far as labor market competition is concerned. And then we have Justin McCrary, who is an economist and the Paul J. Evanson Professor of Law at Columbia Law School. And McCrary previously served on the faculty at the University of California, Berkeley, where he founded Berkeley's Social Science Data Laboratory. Then we have Kyle Herkenhoff, who is an associate professor of economics at the University of Minnesota. And he also served as the senior economist at the Federal Reserve Bank of Minneapolis from 2020 to 2022. And finally, last but not least, we have Eric Posner, who is the Kirkland and Ellis Distinguished Service Professor of Law here at the University of Chicago. And from 2022 to 2023, Eric was counsel to the Assistant Attorney General at the Department of Justice Antitrust Division. So Eric and I had the pleasure of working together while he was at the division. So that's been fun. All right, so now let me introduce with a few remarks on labor market competition. So, you know, it's as was said in the last panel, there are some real harms from a lack of competition on consumers and workers here. And in particular, a lack of, you know, when there's a transaction, a merger, it could substantially lessen competition, enabling firms to acquire, exercise, or entrench market power. And here we're going to focus on power in the labor market. And so, you know, there are a lot of aspects that were discussed previously that we're going to also address in terms of quality, for example. What is the quality of a job? So, you know, we'll get there. Importantly, though, you know, it's also good to remark that some people think that perhaps the antitrust law aren't designed to protect workers, that maybe labor market power really isn't a thing, and therefore, you know, we don't need to worry about that. However, interestingly, since 1982, the draft merger guidelines have mentioned buyer power in general. So, you know, this is an old theme that, again, was already present in 1982. And in fact, in the 2010 merger guidelines, there was a whole section on powerful buyers. And that section already mentioned that it wasn't a requirement to show that harm in buyer markets has to also have effects in downstream markets, result in harm in downstream markets. And so with our 2023 draft merger guidelines, we build on this rich history, and we're going to discuss how the agencies review mergers that involve labor markets and workers. So the inclusion, it was worth clarifying, you know, that labor markets are in fact under the purview of what we do, even though it was always the case. But, you know, we want to clarify that and also benefit from a lot of recent academic literature, including literature that I've contributed to myself. And I'm writing some literature reviews in this area showing that, in fact, employers often have market power and exercise it to reduce wages and, you know, otherwise worsen working conditions. So this draft merger guidelines, they affirm that if that's the case, if a transaction is predicted to reduce wages or otherwise worsen labor conditions, we can challenge, and we will challenge it as a standalone basis. Again, there is no need to show an effect on the product market. And the draft merger guidelines, you know, as Susan outlined, we have some general guidelines 1 through 8, and this is focusing here on guideline 11, which is the labor markets, and is an application. All of the above and everything else that is, you know, in the guidelines applies to labor, but this section clarifies some ideas about how this could be done. And in particular, the prior panel was talking about rebuttals. That rebuttal just as well applies to labor. It's just that the rebuttal is going to have to argue that the merger doesn't threaten competition in the labor market that, you know, is the relevant antitrust market in that specific case, right? But the same kinds of arguments are going to apply. So today, therefore, we're going to focus on this guideline and some of the what's at stake with this guideline. So first, let me get to an important issue that actually has come up in the prior panel regarding certain potential trade-offs. And in particular, we say that we're going to consider competition for workers, but some people argue that if there's less competition for workers, wages will go down, so input costs decline, and ultimately consumers are going to benefit, right? So that's a point that has been made, and perhaps therefore the agencies might be trying to put the thumb on the scales for workers and higher wages, even though it could harm consumers. So Ellie, I'm going to turn to you. Do you think that enforcing against anti-competitive mergers in labor markets means that agencies are prioritizing workers over consumers?
I can see how someone would come to that conclusion. I think it's very easy to draw a straight line from, okay, we're going to enforce against harms in labor markets. What does that look like in practice? Well, in practice, it looks like preventing wages from falling below their prior more competitive level. And if we're preventing wages from falling, we're preventing costs from falling, and therefore preventing the merged party from being able to reduce prices. Of course, things are a little bit more complicated than this in practice for at least two reasons. The first is you need pass-through for those cost savings to actually go through to consumers. We can set that aside and say, okay, well, suppose you did have some kind of pass-through, then we have to think about how it is that firms exercise their newly expanded labor market power in order to reduce wages. And, in some canonical models and in probably many markets and industries, the way that this happens is that the newly merged party reduces the amount of labor that it employs. So it reduces the number of workers that are employed in order to hold down wages. This is totally analogous to the way that a monopolist reduces the amount of quantity produced in order to prop up prices. Now, if you're employing fewer people, probably that also means you're producing less output, you are selling fewer units. And now we're talking about quantity declines and potential increases in price that go with those quantity declines that are pretty traditional textbook harms to consumers. I'm going to muddy the waters further, right? This is sort of like the level one argument. The level two argument is everything I just said applies in some, but not all markets. In particular, the need for a monopsonist to reduce the amount of labor that it employs in order to exercise its labor market power is predicated on certain assumptions or certain rules about how labor markets work that hold in some labor markets, but not in others. In particular, in labor markets that have the feature where contracts with workers stipulating salaries and working conditions and so on are hyper individualized. So they're not just individually negotiated, but also individually negotiated without really being tied to any sort of like standard compensation scheme. In markets like that, you can divorce the exercise of labor market power from how much labor you employ. And therefore, that's a case where we really then do come back to this trade-off between consumers and workers. Now, that's level one and level two. I'm going to get to level three, and this is something actually that Bill Rogerson brought up in the first panel as well, and I want to echo here. Both the level one and level two arguments are about short run effects. There's also potentially about a concern about long run effects, by which I mean things that economists would refer to as allocative inefficiencies. This is the argument that if you've got, two hospitals merging and they're able to hold down wages for nurses, well, eventually fewer nurses are going to be available in that labor market because they're going to retire early, or they're going to choose not to become nurses in the first place, or they're going to choose to move away from that labor market to someplace else where they can still command higher wages that are closer to the competitive wage level. That's what economists would call an allocative inefficiency. It sort of moves assets around the economy in a way that reduces the total pie. That is clearly something that's very intimately tied to consumer surplus, but also because of its longer term nature, I think is much trickier to litigate in court, even if we had a very clear-eyed treatment of it in the guidelines, which currently we don't.
Thanks. I'm gonna take this to Beatrice. So from your perspective as an enforcer, what do you think about this issue, and in particular about the special features of labor markets, and how, this issue could be addressed in that context?
Thank you. And before getting started, allow me to thank the DOJ and FTC for organizing this workshop. I'm honored to be here today. And please note that the views I express here today are solely my own and do not represent the views of the New York Attorney General or any member of her office. Antitrust law protects workers and consumers equally. I think we heard this in the previous panel. It does not elevate the interest of one over the other. In this way, the proposed merger guidelines ensure fidelity to the mandate that Congress has given the agencies and the legal precedent on the books by being the first version of the guidelines to explicitly state that the antitrust laws protect competition in labor markets. And as Yona said earlier on, there is a rich history. This principle is not new. In 1890, as Congress was formulating the first antitrust laws, Senator John Sherman recognized the harms caused by restraining competition in labor markets. Almost a century ago, the Supreme Court held that antitrust laws could be used to protect competition in labor markets when a group of sailors sued ship owners for wage fixing. And in the context of mergers, the legislators who drafted and debated the Clayton Act in 1914 were motivated in part by concerns that monopsonists should not dictate the wages of their labor. Wages should be set by competition. Thus, in keeping with Congress's mandate, injury to labor is an independent basis to challenge mergers under the Clayton Act. And as Yona mentioned earlier as well, while previous guidelines, for example, in 1982 mentioned market power by buyers, and then adopted the term monopsony starting in 1992, as evidence continues to grow of how concentration can inhibit competition and degrade wages, as well as degrade benefits or working conditions in labor markets, the need to invigorate merger enforcement in labor markets has become urgent, and thus merits explicit reference in the merger guidelines. Moreover, this update continues with the agency's long history of revising the guidelines to reflect new learning based on, for example, your research and actual agency practice. Concerning the special features of labor markets and the impacts of harms to competition in labor markets, one thing to note in relation to labor markets is that if a merging firm competes in the labor market, the combination of those firms may harm competition whether or not the merging firms are competitors in any product market. So take, for example, the DOJ challenge back in 2010 against 6 technology companies for no-poach agreements. While not all of those firms were competing against each other in product markets, take, say, Pixar and Adobe, all of the firms were competing with each other for software engineers. In other words, while some mergers will harm both product markets and labor markets, not all labor markets will necessarily be symmetrical with the product market involved. There may also be difference in the relevant geographic market for labor markets as opposed to the product market. As such, the guidelines appropriately underscore certain realities. Labor markets exhibit high switching costs and have surge frictions from applying, interviewing to a new job. And also the individual needs of a worker may limit the scope of jobs that may be competitive substitutes. For example, finding the right commute, hours that work with childcare, the right culture fit, or decent health insurance. In addition, finding a job requires the worker and the employer to match. In sum, I think the guidelines are justified in acknowledging that switching jobs is just not the same as switching toothpaste brands.
Thank you. So I'm going to take it to Eric, who actually wrote a book about labor and antitrust. What would you have to add here?
Yeah, I want to respond a bit to Ellie and also to Bill's earlier point about this issue of circumstances in which a merger that harms workers could benefit consumers. And I think the starting point is to remember that workers and consumers are the same people. They're just people who work and consume. And so we should really be thinking in terms of, net wages or net prices and try to avoid just thinking of them as different classes of people. Consumers as the people who we want to benefit and workers as the people that we want to exploit. That's not the right way of thinking about these. And I know that's not how Ellie thinks about it, not the criticism of Ellie. But there's this kind of a weird asymmetry in antitrust law, which treats consumers as more important as workers. This is traditionally, which I believe the guidelines are trying to correct. And I think it's a little bit illustrated by this example, because you can, this example that Bill gave and that Ellie was talking about, I think that was the level 2 example, because you can turn it around and imagine the opposite case where two big firms merge and are able as a result to raise prices in the product market. So they raise consumer prices, and then they justify it by saying that, well, we're going to give some of our those rents to our workers in the form of higher wages. And that would never have flown with the antitrust authorities or any court ever in the history. I don't think anybody's even bothered to make that argument. Because it's not considered. The normal reason is that it's too difficult to do this kind of cross-market balancing, but it just, I don't think, ever occurred to anybody that these are economically the same settings. And this feeds into a larger point, which is that the rules should be the same. That is, we should think about the two markets the same, except to the extent that there are real economic differences with them. I mean, as Beatrice was saying, there are some which suggest that not that we should be giving equal priority, but we should actually be focusing more on mergers that affect workers. And the reason is that, of course, there's almost never been, until recently, challenges to mergers based on their impacts on labor markets, which means that firms have surely realized that they can do a better job extracting rents from the economy by engaging in mergers that harm labor markets rather than product markets, where there's all this policing going on. So there's probably been a lot of concentration in labor markets that has occurred and that is illegal, but there's never been any enforcement against it. And then, as Beatrice mentions, because of the higher switching costs and that workers face than consumers face, it's probably more likely that more harm is caused by mergers in labor markets than mergers in product markets, if you could somehow hold everything else equal. So my actual worry here is that even with these guidelines, the agencies will continue to under-enforce with respect to labor markets. And I think there's some practical reasons why that might happen. The first is that labor markets tend to be local, whereas product markets are very frequently national or regional. And so an agency with limited resources is going to be tempted to go after the bigger mergers, which have the bigger economic impact. And that will lead to a bias toward mergers that impact product markets rather than labor markets. Another reason that I think we're going to discuss is that labor markets are the way that workers are compensated in labor markets is very complicated. It's not just wage, but it's conditions and amenities and all kinds of things. This is going to make it more difficult for agencies to prove to a court that to the satisfaction of a court, maybe, that a merger that affects labor markets is causing some kind of substantial lessening of competition. That in product markets, where goods are frequently, not always, of course, fungible, allowing economic analysis to occur in a kind of a more rigorous and transparent way. So I would say, I hope that the agency, I don't think they should say in the merger guidelines, we're going to put more emphasis on labor markets than on product markets, but I do think that's what agencies should do.
I think it's worth mentioning here, as many of you are aware, but before this new draft merger guidelines, last year, in fact, about exactly a year ago, the Department of Justice was successful in a monopsony case where we argued that the merger of two large publishers was going to reduce payments to authors. And I think that this is a very important precedent, and it wasn't appealed. So it's a decision that stands and will be useful going forward, as we develop enforcement in that area. Justin, you wanted to comment as well.
Sure. I think that I guess I first want to align myself with the view that antitrust has always been about protecting not just consumers, but also workers. I don't think that there's any serious dispute about that, actually. When I've encountered arguments like harms to workers through reduced wages will flow through to benefit consumers, I simply chuckle. So When I teach my students, for example, about the consumer welfare standard, I explain to them that all that really means is that you shouldn't interfere with the competitive process. And that that's actually something that applies both on the selling side as well as on the buying side. And it's not any more complicated than that. So another way of saying that is that the consumer welfare standard is the same thing as a worker welfare standard. So I think I would probably start there. So in many ways, I think what that means is that I always read into the merger guidelines an emphasis on buy-side cases and labor-side cases. And maybe I was reading between the lines, perhaps, but that's in part because I think I agree with Beatrice that it's always been part of antitrust as a matter of the common law, predating the Sherman Act even, as well as jurisprudence subsequent to the Sherman Act. So from that perspective, I'd say there's nothing wrong with the merger guidelines tackling the subject, but it might be right that we've set up a little bit of a straw man to a certain extent. So I think that the more serious questions that we're starting to grapple with when we tackle the question, though, are about these cross-market effects. And when I teach the subject of antitrust labor, I start with the example that suppose that it were true, and this flips Eric's example, actually. Suppose that it were true that two firms combined and then they exercised their monopsony power, but the promise was that they were going to pass on the savings to consumers. No one would countenance the improvements for the consumers. You would simply point to that as an interference to the competitive process. And you would think of that as a merger where I would predict squarely that the agencies would want to block that. And I would also predict that a court looking at that would say, yeah, that's right. We're not going to countenance the benefits on the consumer side. What that means for the cross-market effects and the within-market effects is a more complicated topic I think we're going to tackle later on in the panel. But I also wanted, since these are my first comments today, I wanted to emphasize something that the last panel emphasized, which is examples. So I think the example that I just gave is a good example of how to talk about some kinds of cross-market effects ought to be impermissible. I think other kinds of cross-market effects, and here I want to align myself with some of the comments earlier that David made, it's obvious that we would want to consider the cross-market effects. And I'll hope to say more about that later on.
Thanks. So actually talking about examples before we move on, is there anybody who has a example that, you know, they find particularly hairy? You know, like you mentioned, for example, it was your point 2, you know, what if it's maybe an industry where it's individually negotiated, or, you know, if anybody on the panel has an interesting example where this issue could perhaps become heightened, go ahead. If not, we will proceed and you can think about it. So you don't have to respond, but if anybody wants to take that on. Okay, how about you think about it? You know, if it comes up, you know, let's revisit the issue. All right, so now I'd like to turn to discuss the HHI thresholds in the merger guidelines as they apply to labor markets. You know, we return to the pre-2010 HHI thresholds in guideline 1, and since everything applies to labor market, those thresholds also apply to labor markets. Then one question is, you know, people have looked at this, and in particular Kyle, and I want to ask him the question whether different thresholds perhaps should be applied to mergers in that affect competition in the labor market versus in the product market.
Well, thanks for the question, and thanks for having me. The draft guidelines are very explicit that a lower concentration threshold than 1,800 may be appropriate for labor markets, but the threshold is left unspecified in the draft guidelines. The opening paragraph of guideline 11 states that the level of concentration where competition concerns arise may be lower in buyer markets than in seller markets, given unique features of certain buyer markets. So in our public comment and accompanying working paper, we formally compute worker welfare, which summarizes in dollar terms the changes in consumption and wage and non-wage benefits to workers under various HHI thresholds. If you allow me, I'll turn to 3 short slides just to discuss what we did there. Okay, I promise this will be quick. So we build on this work with that I have with my co-authors David Berger and Simon Monge that was published in the AER. This is joint work with them as well as Eric and Thomas Hasenzagel at Minnesota. And we allow for common ownership of plants. So this is a fairly standard monopsony model extended to have a finite number of firms in many local labor markets where workers can move across markets. So you can think people are mobile across these markets, which many models ignore. Just as Margot was saying, workers have preferences for jobs and for markets, and those reflect amenity differences across firms. And here you can think of commuting costs, and these are akin to switching costs as driving those preferences. Here, critically, a market is a NAICS 3 industry in a commuting zone. So one of the actual markets in our model is real estate in Minneapolis. Okay, so that's an example of a NAICS 3 industry in a commuting zone. In countries where we have occupation data side by side with industries, the leakage rates are very similar across our definition and more complex definitions, like when we cluster using cluster occupations in those countries. Critically here, this market definition passes the hypothetical monopsonist test. So if monopsonists were to control the entire market, they would reduce wages by more than 5%. And lastly, these firms set wages strategically and they differ in terms of productivity. So if we could go to the next slide, or do I control this? Okay. All right. The model is just calibrated as it was in our AER. So it's gone through a peer review process, and we haven't changed any of the parameters to match the merger setting. But in that original AER paper, we estimated monopsony power in the census data using differential pass-through rates of state corporate tax changes to wages and employment in different markets with different market structures. That off-the-shelf calibration, that estimation on the census data, we show the goodness of fit by replicating recent work by David Arnold, who studies mergers in the US Census data, looks at their labor market effects. And we simulate to match David Arnold's summary statistics on the characteristics of mergers in the United States. And our model performs quite well. So we predict something like a 9% decline in employment, whereas in the data it's 14% post-merger. And worker earnings fall by about 1% in both of the model and data. What David finds and Ellie finds and others in this panel, their research find, is that these post-merger effects are larger in concentrated markets. So that's the line that I highlight in blue, which is the effects are something like 3 to 4 times larger in concentrated markets. So earnings losses post-merger are something like 3% in the data and 4% in the model in highly concentrated markets. That's going to be important for the next slide. So we take this model as a pretty good approximation of what's happening in the labor market. A frontier theory of oligopsony can replicate these features. And then what we do is, again, compute worker welfare, which is this dollar metric for changes in both wage and non-wage compensation under various merger guidelines. So we ran this before the draft guidelines were out. So these numbers we're kind of committed to. The first panel, A, is the 2010 guidelines. So what we did is we just took the 2010 and 1982 guidelines and ran them head to head. The first column prevents mergers where the Herfindahl is above 2,500 and the change in Herfindahl is above 200. So that's what we call the 2010 guidelines. That first cell there, the minus 36,000, is the change in average worker welfare, assuming a fairly generous 5% efficiency gain. So among permitted mergers in markets where these permitted mergers affect workers, on average in those markets, aggregating across workers, there's a loss of about $36,000 relative to the pre-merger economy. The number just below it that's close to $1 million, that's if we allow the mergers that we prevented through, there would have been roughly $1 million loss in those markets. The second column is imposing what used to be the moderate concentration threshold. So 1,500 post-merger HHI and a change in HHIs of 100. There, that $42,000 metric suggests that now in the markets where mergers are permitted, actually workers are better off to the tune of about $42,000 on average. We prevent harmful but less harmful mergers, so that average in the blocked mergers number actually goes down a little bit. And then the last column, the 2023 guidelines oppose the 1,800 Herfindahl threshold, the change in Herfindahls of 100. Anything above that, we block. And you also see there that workers are better off. So in summary, our model simulations and the sort of economic models would support the 1,800 threshold, but also suggest that a threshold like 1,500 would be quite reasonable to adopt in those guidelines. So rather than leave it unspecified, we encourage the draft to adopt something like the moderate concentration threshold. One thing I want to say here is that to compute the actual optimum, we'd have to take some stance on merger review costs. And we have very little information on that. And, just as a request, it would be good to have some public information on that so we could go a bit further here. So I'll leave it at that. Thanks.
Thanks, Carl. So I'm going to turn to you, Ellie. Do you agree that we should have different thresholds, and how hard would it be to design different HHI tests for the same merger that might implicate both a labor market and the product market theory of harm?
I have to say, and I don't like saying this on a panel, I feel pretty ambivalent about that question with the body of evidence that we have today. The kind of work that Kyle and Eric and their co-authors are doing is both sorely needed and right now still has contributed to a body of work that remains much smaller than what we have on the product market side for assessing what thresholds might be appropriate for various enforcement goals. On that product market side, I would especially highlight work by John Quokka, Mike Winston, and Volker Noki. And, I think it's fantastic that you guys have put this together. But I'll note, buried in the technicalities there was the fact that in order to define a market for your exercise, you had to use something fairly coarse, specifically an industry code, in this case, a NAICS 3 industry code, crossed with some kind of geographic boundary, in this case, a commuting zone. I'm not actually taking issue with your choices. I think that they are quite sensible, given the constrained data that we have. And in practice, they probably mirror what enforcers would have to do. Right? We actually don't have currently systematic evidence about what the appropriate labor market definition is in any given case. Enforcers and parties spend a great deal of time and other resources coming up with the correct market definition on the sell side. And I imagine that eventually something like that will also happen for cases being litigated on the labor side, but we're just not there yet. So given those imperfections and what we know, and given that we're probably going to end up defining labor markets too coarsely in the short run, what do I mean by too coarsely? Well, these industry categories might be too big. The geographic delineations are almost certainly too big. The Chicago area commuting zone extends from south of here, like all the way to Indiana, basically, and up to almost Wisconsin. Very few people are driving from Indiana to Wisconsin for a job, right? Those commuting costs are too high. Eventually, we'll figure out ways to do this better. I'm working on some of that myself, but in the interim, maybe it does make sense to set HHI thresholds that are lower to compensate for the fact that we are mismeasuring HHIs in a systematic direction. But I don't love leaving it there forever.
To be continued.
Can I,
Yeah, sure,
continue
go for
right
it.
now? Yeah. Ellie, I just wanted to ask, do you think there are just sort of general theoretical reasons, plus, what we know about the differences between labor markets and product markets, to think that the HHI thresholds should, at least in theory, be lower for labor markets than for product markets?
Well, I'll give you a two-part answer. The first is that, as Beatrice already highlighted for us, labor markets are fundamentally different than many product markets on two dimensions that matter a lot. One is that they're matching markets. This also came up in the first panel. That means that not only does the worker have to want to work there, but the employer has to want the worker, right? So unlike buying toothpaste, where I walk into the store and I pick among the alternatives that are available to me at the posted prices, I can't just pick a job that has a posted wage because the employer has to want to hire me too. And that almost mechanically gives employers more market power over workers than sellers have over consumers along certain dimensions. And then the second piece, which Beatrice also brought up, is that labor markets are inherently very frictional, right? It's very difficult to switch jobs. It's very difficult even to learn about the characteristics of another job. Often you have to go through the entire interviewing process and secure a job offer just to know the very basic fact of how much they were going to pay you. Our standard economic models that assume perfect competition assume that there's perfect information and everybody knows everything all the time, right? So these are characteristics of labor markets that I think make them inherently different from many product markets. But it is not obvious to me, and maybe it's because I'm just a poor theorist, which is certainly true. It's not obvious to me how we go from there to understanding whether HHI thresholds ought to be different, right? I think that's ultimately actually going to be an empirical question that we can't answer unless we have market definition for labor markets that is as tight, and I mean like tight as in correct, not tight as in small, as we have in product markets. And I think we're just not there yet.
Justin?
Yeah, so I'd like to hop in a little bit, in part because I would have started in a different place in characterizing why labor markets are different from product markets. And that's something that I think is actually also missing, generally speaking, from the guidelines, which is I agree with both of your statements that there are frictions associated with the labor market. It's also true that there's a matching aspect to it. But the much more fundamental point is that in every, or virtually all, employment situations, there's an employment relationship that is of consequence. And what that means is that it is symmetrically true, and this is the part that I think is missing actually from your comments, Ellie. It's symmetrically true that that gives the firm power over the worker, but it's also true that that gives the worker some power over the firm. So if you think, for example, about an employment relationship that is of serious consequence, both things are true. If the worker comes to the firm with an outside offer, the firm scrambles to try to figure out, oh, is this actually a situation where we want to retain the worker, and how do we want to counter offer, et cetera. Think of, for example, academics, think of lawyers, architects, anybody in the high skill segment of the labor market. There's surplus associated with the match. And that part, I 100% agree with what Ellie said. That matching is very important in labor markets, and allocating workers to the best jobs might be one of the most important things that you could do to get your economy right. But that also means that I think it's right that the definition, and this is why this is relevant to the question of HHI thresholds, the question as to what we do with respect to labor market definitions is actually very complicated. So I think I hear between the lines in Ellie's comments that she and I are on the same page of this. I would characterize that as labor markets are highly nuanced. And I say that in part because I've been involved in several antitrust labor cases where the direct evidence that you're confronted shows extensive substitution patterns that indicate that while I totally agree with Kyle that I probably would have adopted the exact same labor market definition that he did in the context of an academic paper, in the context of cases, it's almost always right that the switching patterns are impossible to anticipate. And that means that if you took any such example of a labor market definition, it would be both over as well as under inclusive. You might, for example, draw the geographic boundary way too broad, but fail to anticipate, for example, that people will switch both occupations within a given industry, and they'll also move from industry to industry, which makes characterizing the market very hard, I think. And so I think I share your ambivalence, Ellie, that I don't know exactly where I would come down with respect to a threat.
Right. So this really gets us into the topic of job differentiation and also worker preferences over different types of jobs. And as you mentioned, one of the dimensions that the research shows is important is distance or commuting time, but there might be many others. So Kyle, I want to talk to you about this. How would you think that the draft guidelines could address potentially the heterogeneity of worker preferences or think about worker welfare within this analysis of competition in labor markets?
Okay, so thanks for the question. Sort of based on the first panel's comments, I'm actually going to remind the audience of where the heterogeneity and worker preferences comes in, because this parallels the quality discussion. I think there was some discussion there that quality wasn't somehow addressed. So in the second paragraph of guideline 11, the agencies write reductions in labor market competition may lower wages or slow wage growth, worsen benefits or working conditions, or result in other degradations of workplace quality. The agencies then go on to write in the third paragraph, the individual needs of workers may limit the geographical and work scope of the jobs that are competitive substitutes. And in the fourth paragraph, they write, workers may seek not only a paycheck, but also work that they value in a workplace that matches their own preferences, as different workers may value the same aspects of a job differently. So with that said, I'm going to make 3 points about this. So the first point is that I believe a lot of this preference heterogeneity will be captured by the market definition. So just as in Penguin Random House case, in which high advanced authors were treated as a targeted group of customers, I believe a lot of the preference heterogeneity for particular work benefits will be correlated with demographics. So Take, for instance, childcare benefits and leave policies. If we think that those are being threatened by a merger, cutting benefits post-merger clearly targets female employees. And so these types of cases probably could be handled in the current framework with the right market definition. The same would be true if we thought, for instance, retirement benefits were to be cut and it would target workers based on age. So there, I think adoption of a tighter structural presumption for the Herfindahl threshold would apply to labor markets and make this argument of targeted customers more effective in courts. For the cases where there is no clear targeting, evaluating those first three statements in the guidelines on preference heterogeneity really requires a quantification of worker utility and worker welfare to assess whether mergers lessen competition amongst groups of heterogeneous households. So in that welfare assessment, I really think there's two key statistics required. The first is the sum of the value of the wage and non-wage attributes of a job for an individual worker. Right now, guideline 11, as stated, does not make clear that changes in wages and benefits can offset each other. And I think in Justin's comment a year ago, that he also made a similar point. For example, lower wages can be offset by more flexible scheduling. So to clarify this issue, I'd encourage the revised draft to adopt language such as total compensation in the opening paragraphs of guideline 11, instead of just treating these as separate entities. There's or statements there. The second issue is that there needs to be some aggregation to evaluate those statements within a market, adding up individuals' heterogeneous gains and losses. To understand that, I pose a question to the audience and the panel members. If one single worker is worse off, would we block a merger? And I think the common sense answer is no, and that no statistical procedure would ever allow you to make that type of conclusion with sort of any accuracy. So we must take some stance on cumulative worker welfare within a market. And there, I think adopting language such as the degradation of total compensation to workers would allow practitioners to operationalize the language in the draft, make it more powerful, and assess whether mergers lessen competition amongst groups of heterogeneous households. We actually add those numbers up. So I'll leave it there.
Great. Oops. Yes. Thank you, Ali. Beatrice, let's turn to you. We just heard proposals about how we might think about in practice, in enforcement practice, how do we go about thinking about this preference heterogeneity and different workers potentially valuing different things, or the same worker putting value on the wage and all these other aspects of the job?
Well, I'll start by saying that I agree with a lot that I heard. For example, I agree that workers have individualized needs when seeking jobs, and that this heterogeneity of taste adds kind of an additional dimension to the search frictions. So in other words, job preferences may not only be differentiated along different dimensions, but also along a wide variety of characteristics. So from wages to commute times to flexible scheduling or other benefits. And different workers may value these dimensions differently. Moreover, workers are also different in their skills and the information about the job market prospects and other dimensions. And I think Ellie was speaking about this earlier. And as Justin also said earlier, in labor markets, both buyers and sellers take great interest in their counterparts' characteristics. While in product markets, a buyer is not evaluated by the seller by its interest in buying a product in the same way that a job is. So I think that the guidelines appropriately acknowledge certain kind of tools that, at least as an enforcer, I see as helpful. For one, that various practical indicia may identify a relevant market in different settings, that a hypothetical monopsonist test would address the worsening of terms along multiple dimensions of competition, including decrease in wages and worsening of working conditions or benefits. That geographic market definition may involve considering workers' willingness or ability to commute, including, for example, the availability of public transport. And that the matching process may narrow the range of rivals competing for any given employee. In other words, these factors may lower elasticity and thus competition. So as to what enforcers can do with this, I think I'd call this, we go back to the basics, right? acknowledging that the unique characteristics of labor markets, number one, is key, I would say, and the fact that these frictions associated with substitutability may be more prominent in labor markets than product markets. So what do I mean by going back to the basics? Well, I would start by looking at the internal documents of the companies. What are they telling me? For example, firms may have ordinary course business records telling me which type of workers each firm hires, or the date and occupation and location of all new hires. Or companies might also have records concerning their recruitment efforts. What did they tell their recruiters, such as the tasks of the job and where the location of the job may be. And then, of course, we'll always benefit from economists and sources of data such as, again, standard occupational classification data or economic research service data on commuting zones, or maybe even, say, LinkedIn vacancy data may be helpful.
So I'm curious, how do others on the panel think about practically speaking, like all these different ways that we can look at this aspect and that aspect and use documents versus trying to come to a overall, say, total compensation assessment? Any thoughts on that?
Well, earlier, I'll pick up the thread. Earlier, Eric was describing something that I agree with, which is that measuring something like total compensation in a labor market context is quite hard. But that being said, I was chuckling when Beatrice was talking, because the lawyers are talking about documents and the economists are talking about data. But Beatrice's comment, I think, especially the end one, was spot on, which is it's hard to measure total comp, but actually it can be relatively straightforward to measure substitution in a labor market context. And that's in part because it's usually true that part of record evidence is actually people's CVs, or, for example, it's LinkedIn. So the career path that a worker has taken is something that you can oftentimes trace out. And in my experience, what that usually gives you is a bit of a headache, frankly, because it means that figuring out the contours of the labor market is just dizzyingly complex. People make all kinds of different determinations about where to go, but at least you can measure it. And so in terms of figuring out what you would want to look at, I do think it's right that looking to substitution is something that can be done readily in a labor market context, even while it might be right that something like total compensation, which we agree is the right metric, might be actually really hard to get. And in particular, a worker's valuation of the non-wage benefits that they're receiving. Good luck figuring out how to do that in a coherent way. I think that's quite hard.
So, I will say that, of course, the substitution pattern very much comes into play in the hypothetical monopsonist test, where we ask, whether workers could defeat a decrease in wage by easily switching to a good substitute. And then the question is, well, what is a good substitute? And, we can investigate what that is with methods and documents and that data that are specific to the case. Kyle, did you want to?
Yeah, could I respond just a little bit to the comments here about difficulty of measurement? I think there's a lot of methods. So I think if you say one individual worker, I'm ever going to value their benefit, how they care about benefits or whatnot. I think there's a lot of methods out there. I mean, I look at Isaac Sorkin's job market paper. I mean, if you aggregate a little bit and you do this at the firm level, I think you can nail it. We've got a lot of methods to compute firm specific amenities. You try to do it worker by worker, I agree, you're gonna have a hard time, which was, sort of my third point there, which is, you have to have some way of aggregating within a market. So there, I think the economic welfare toolkit is very useful. On the measurement of the boundaries of labor markets, I think the labor markets provide, there's some features of, I think, the decline in unions was offset by a large rise in occupation licensing, which created this insider-outsider, same, set of problems as unions. But because of that, the occupation licensing, for many cases, provides very natural boundaries of labor markets. So I think in that sense, the measurement issues are actually maybe less difficult than in product markets for defining the boundaries.
Thanks. I just wanted to tell everybody, and also the panelists, that it's we have emphasized certain aspects of labor markets, like this heterogeneity, that there's a lot of job differentiation and preference heterogeneity, and also the matching aspect. And people said that that's not necessarily true in the product market. And of course, that's true. But there are perhaps product markets that have that similar aspect, like, for example, some B2B, types of services. And so therefore, if anybody has any thought about an example where it's maybe more similar and, you know, how we could learn from that, you know, that would also be interesting to think about that.
Well, platforms are very similar. The early literature on platforms, I think going back to what is the 90s or 80s, talks about the high switching costs. And so if you're on a platform, it's very hard to switch to something else. And it has a bit of a feel of being a worker who has a high switching cost.
I want to pick up something Justin said earlier about, you know, the bifurcation between economists who only want to talk about data and lawyers who only want to talk about documents. I will, you know, put in a vote in favor of documents, particularly in cases that primarily implicate what economists not very nicely called low-skill labor typically. And what economists mean by this is types of work that don't require a lot of investment in specific training. So these are jobs that often don't have occupational licensing. These are jobs where people are often not posting on LinkedIn and where we don't have CVs because there wasn't a CV associated with a job application. And I think, you know, economists are very quick often to jump to the conclusion that because there was no specific training, that means that for this worker, all jobs are pretty good substitutes. I think we have evidence from other literatures outside of economics that that is not true. And that even for those workers, it matters a great deal what job you're doing and where you're doing it. And switching can cause substantial declines in either compensation or quality of life. And so particularly for those classes of workers, I think document review is incredibly important. And, you know, sometimes people will record in their HR records, oh, you know, we went to this kind of job fair to look at these kinds of people. That stuff is incredibly valuable, particularly in these cases don't have good data.
So I want to move to the area of potential cross-market balancing. And in particular, you know, if we have a merger that might substantially lessen competition in the labor market, could this be offset to what extent by some purported benefits in the downstream market? And Beatrice, I'm going to stick with you here. What is your view on the agency's assertion that they're not going to do such cross-market balancing?
The guideline statement that benefits in consumer markets will not offset a substantial lessening of competition in labor markets is greatly welcome. I think that this principle restates for labor markets the long-standing rule set forth by the Supreme Court in Philadelphia National Bank. Anti-competitive effects in one market cannot be justified by pro-competitive consequences in another. This holding follows the text of Section 7 and the legislative history of the 1950 amendments to the Clayton Act. As Philip Arita and Herbert Hovenkamp have observed, the statute plainly contemplates that mergers may involve more than one market, yet it bases legality on a separate market-by-market appraisal. And the Supreme Court in Brown-Shue underscored the same, stating, because Section 7 of the Clayton Act prohibits any merger which may substantially lessen competition in any line of commerce, it is necessary to examine the effects of a merger in each such economically significant submarket to determine if there is a substantial lessening of competition. Moreover, as underscored by the court in Philadelphia National Bank, which I'll refer to as PNB, the balancing of harms and benefits across groups really is the proper domain of the legislative branch, not the judiciary. And I'll add that I think that this rule against cross-market balancing of harms also governs Sherman Act enforcement. And this was recently applied to labor markets by the Seventh Circuit in the des Landes, I cannot say it in English, which the Landes opinion in the Seventh Circuit, which found that treating benefits to consumers, increased output, as justifying detriments to workers, monopsony pricing is, and I'm actually quoting here, not right. It is equivalent to saying that antitrust law is unconcerned with competition in market for inputs, and the Supreme Court has held otherwise. In sum, based on the current law on the books, offsetting between product versus labor markets, and I would say even labor versus labor markets, is inappropriate, as the merger guidelines correctly state.
Justin, did you have a reaction to this? Perhaps going back to some of your introductory comments.
Yeah, you could tell we were all heading here. So on some level, we could all point to examples where cross-market effects would feel as though they ought to be not permitted. And we could also point to examples where it seems, this is again, the last panel gave us a great example of saving lives based on getting to a higher level of scale. It's very hard to imagine that you would want to ignore such a fact. And I guess for me, that underscores a central theme really of antitrust, which is everything is contextual. So I have a very hard time coming up with a blanket rule. But if it's right that I would say, do you want to embrace the idea that you should never look at cross-market effects? I'd say for me, that's way too strong. And part of the reason why I say it's way too strong is that it will always be true that there are going to be complicated effects on one side of the market. For example, suppose that it's right that there's a merger, which, and I put this question to the panel in some of our earliest meetings. Suppose you have a merger, and that merger actually has deleterious consequences for one segment of the labor market and very positive consequences for another segment of the labor market. That's not necessarily a cross-market effect unless you adopt a market definition that segments them out, et cetera. Most people would have said, well, this is just segments of the labor market. And I think it's obvious, actually, that in that context, that a court would find itself in the position of trying to evaluate, is it right that some of these effects are big? And is it right that some of these effects are small? And are they sufficiently different that I am willing to actually say, overall, this seems like this is a good thing, not a bad thing? To me, that actually is something that is inconsistent with coming up with a hardline rule that we would want to codify in something like the merger guidelines. Not that it's binding upon any court, but simply I feel as though it's a better approach to actually acknowledge that the merger guidelines are trying to summarize what the law is. And so I find myself in evaluating the merger guidelines, trying to predict what kinds of information a court would want to rely upon. And in that context, I'd say the bright line rule, I think it's a little bit hard for me to defend.
Eric.
Justin, is this your view about product markets also? I'm asking because it's, ubiquitous in product markets. Just imagine a merger of two chain stores, and in some markets prices go down and in other markets prices go up. And the conventional view has always been they have to the merging parties have to divest where or they can't go through with their merger where the prices would go up. And so the question is whether you're okay with that, but you think there should be a different rule when labor is involved, or whether you think the same rule should apply.
It's a great question. I think the proposition of divesting when you think that there might be an issue is something that seems like it's already fixed on the product market side. I don't have any experience with there being anything analogous on the labor market side.
Right. I mean, if you can divest, then you're allowed to merge the rest of your company. But if you can't, you're just blocked. So in those product market settings where divestment is not an option, it's just blocked. And you think that's a mistake then, is that right?
No, I think what I was saying before is that I think what would be a mistake is to take a hard stance that there's no role for cross-market effects. I think it's very clear that in some contexts, the court would want to consider them.
Great. So why don't we get in the final, pre-final section, which is about, let's talk a bit about rebuttals and risk assessment. So the guidelines are structured under the Baker-Hughes framework, and we have these 13 rebuttable theories of harm, and this includes the labor market theory of harm, which would be here, how a merger may risk to substantially lessen competition or tend to create a monopoly, or in our case, a monopsony. So, Justin, do you think that the draft merger guidelines adequately address the efficiencies that could come from mergers of competing employers?
Talk about giving somebody a hard question. So I think it's a complicated thing to assess overall. I don't think I have a problem with the way in which the draft merger guidelines are handling efficiencies overall. I think the main thing that I detect in the draft merger guidelines in connection with labor is that they ought to embrace the idea of nuance, and in particular ought to embrace the idea that the employment relationship is something which makes analysis of each of these cases quite complicated, I think. In particular, I think the employment relationship is something which gives rise to something which is rarely present in product markets. I guess you could come up with specific examples where it's present, but it's not the usual circumstance, and the last panel talked about that too. But for example, here's a relatively complicated aspect of a labor market that is, however, quite common, which is the firm and the worker both want for the other to have the incentive to invest in the employment relationship. that increases the value of the match, that increases the surplus in the economy, and it's good for the firm and the worker alike. And weirdly, that also means that a restriction actually on your own labor mobility might be something that you're willing to agree to, because it could increase the value of that match for you. That's just something that's not present with respect to the product market example, and I think makes the analysis very complicated, actually. So I would say that's the main thing that I see as being perhaps in need of some modification in the merger guideline, but not necessarily something on efficiencies alone.
Ellie, would you like to comment on this?
Sure. I'll pick up Justin's last point about workers potentially agreeing deliberately to restrictions on their own future mobility so that the investments in the match can happen. I think there's a set of occupations where this is a plausible story. You see this, for example, very commonly in sort of what I'll call high finance, where investment bankers, VC employees will agree to pretty onerous non-compete clauses that bar them from working for similar firms for some amount of time. That usually comes with something called garden leave, which means that they are basically drawing a salary for the duration of the non-compete after they leave their original job. There are, I think, many more cases where compensation doesn't actually happen, right? And I think in being nuanced in the guidelines, we want to make sure that we don't provide an opening for these kinds of relationships that curtail future mobility, because there are some cases where there is an economic efficiency rationale for that. We don't want to provide an opening for other cases where it's actually just abusing the ideas, right? So a clear example of that is the Jimmy John's case from a few years ago. People might remember Jimmy John's was claiming that it taught employees to make really good sandwiches and that was valuable, and therefore the employees shouldn't be allowed to leave and go work in food service anywhere else. So, I appreciate your pressure toward nuance, but I think too much nuance can be dangerous.
And can I just add to that this is, as Ellie says, I mean, most workers are not like most workers, like the chicken processing plant, low skill workers and the people in Jimmy John's and so forth. The vast majority of them are not. This is not the case, but it is an empirical question. You're right. And the question is, what do the empirics say? And the non-compete literature looks at high skilled people as well as low skilled people. It looks at executives, for example. And the evidence, such as it is that it's not at all clear that the restraints actually are appropriate for the amount of investment that presumably is being solicited from them. That in fact that wages often go down as a result of non-competes. So my only worry is that this becomes a kind of fallback argument by defense lawyers to justify their mergers. And I guess if this is, part of the rebuttal and they have the burden of coming forth with the data to show it, that's fine. But otherwise I'd be worried that it would become a kind of a general principle.
So actually, Beatrice, as an enforcer, you're well familiar with this burden shifting framework. Do you have any thoughts on how this efficiencies rebuttal may apply in the case of labor markets?
I think I'll stick to what I really like about it, which is, the guidelines again expressly stating that they will not credit efficiency claims outside of the relevant market. And I think that the criteria that the agencies underline regarding cognizable efficiencies really bolster the same rule. So the DMGs underscore, as we heard earlier this morning, cognizable efficiencies are only those that satisfy each of the four following criteria. One is merger specificity. I think this is quite like the 2010 HMGs. And the one thing is that it does underscore that they're only cognizable if they could not be achieved without the merger under review. Then the second criteria, verifiability. Again, I think this is quite similar to the 2010 HMGs, but one difference is that they place a special emphasis on reliable methodology and evidence for verifying efficiencies. Though I'll note that they don't necessarily say what counts as reliable. So one possible reading is that evidence meeting the reliability standards of Dovert and Federal Rule of Evidence 702 might be deemed as sufficient. And this, for example, recently came up in the labor market merger case, bearing expert testimony on efficiencies in Penguin, Random House, Simon & Schuster. However, because courts may vary as to how they scrutinize Doebert and Rule 702, the DMGs might consider actually defining what they mean by verifiable methodology. The third criteria is pass-through. And I think this is different to the 2010 HMGs in that they will require parties to demonstrate that within a short period, the benefits will improve competition in the relevant market or prevent that threat that the competition might be lessened. And what I understand this to mean in a labor market context is that the types of efficiencies that would need to be proven would include in-market offsets, such as, for example, worker surplus implications, like improvements in wages or benefits or conditions for the workers that remain at the firm post-merger. And this could have a potential domino effect on workers at competing employers. So I think following my comments on offsets, this is certainly appropriate and welcome. And the last criteria is that any benefits claim must be pro-competitive, and the agencies state that they will not credit efficiencies if they decrease competition in a separate market. And regarding the separate markets, I think, again, this underscores a no cross-market offset rule. And to cite again the most famous footnote, I think, of the day, footnote 106, which states regarding decreases of competition in a separate market that, for example, if input costs are expected to decrease and the cost savings will not be treated as an efficiency if they reflect an increase in monopsony power. So, as you know, to date, the vast majority of courts hearing a merger challenge have rejected the parties' efficiency claims. So I think the DMGs very appropriately subject efficiency claims to this high level of scrutiny, following the requirements of General Dynamics and Baker Hughes. And I'll just say in terms of litigating these cases, as there's only been one case to date, it would certainly be very interesting to see what we learn as all of us gain experience on this front.
Thanks so much. So we are nearing the end. We have about 6 minutes to go. So, if you have some final comments, either what you would definitely want to change, even if maybe other people like it, but you really want to change it, or conversely, maybe there's something that you really want to keep, maybe other people don't like it, or any other comments you wish to make, I'm giving you each like 1 or 2 minutes as your final words. And I'm going to start with Ellie, and then we're going to proceed this way. Ellie.
Well, I don't think at this point there's much of a risk that the labor section will get thrown out entirely. So I will assume that that's staying. I would encourage, I think, the agencies to clarify what's going on in Guideline 9, which is the guideline on serial acquisitions. Probably it's because I'm not a lawyer and I don't know how to read legalese, but I was left uncertain about whether what the agencies mean in that guideline is to say that earlier transactions in a series that's being examined under this serial acquisition guideline are up for potentially being unwound by the agencies, or whether they are taken as given and only the transaction on the margin is actually being scrutinized. And I think doing the former would be a pretty big change in how the agencies approach enforcement. So I would encourage them to just clarify what is meant.
Beatrice.
Well, this won't surprise you. Please keep offsets. That's very important. As to any changes, no changes, only suggested additions. But I will say in this connection that because the HSR rulemaking complements the merger guidelines and the state submitted comments to both, one change that we do suggest in the HSR comments in relation to labor markets is that the FTC consider looking beyond just the standard occupational classification and commuting zone data, which may inform the same analysis while reducing the burden on parties who may not collect this information in the ordinary course of business. So firms may, again, have more easily accessible ordinary course documents on new hires or recruitment efforts. And we also make a comment that in certain industries where remote work accounts for the vast majority of jobs, commuting zone data may actually not be that helpful.
Justin.
I guess when you are on a panel and you're asked to talk about merger guidelines that are in draft, everybody's a critic, but I think we so far haven't actually said thank you. So I think one of the things we should probably note is that while it's true that context matters in every case, the merger guidelines, of course, have to be abstract, and that's incredibly hard. So I'd say bravo in the main regarding the draft merger guidelines. I would say that on this point regarding reliable and verifiable, I took reliable to mean the exact same thing as the Daubert standard, but I was puzzling over verifiable. I couldn't quite figure out what that was doing in there. And so actually maybe clarification along those lines might be helpful. Otherwise, I've said enough.
Okay, so I just got a little minor comment. Nobody's talked about the appendix, so I don't know if people, in our group have like it or dislike it, but let me discuss Appendix 2 discusses upward pricing pressure. This can echo some of the public comments I think Justin has made. And suggests that the concepts can be mirrored to monopsony markets, but they don't make that explicit. And, in Penguin Random House, there's a simple mirroring of that to downward wage pressure. In that context, it makes sense because they're not employees of the company. But many contexts, I think that would be a mistake. And just simply being clear, adopting the language of downward total compensation pressure, right? In that just extra sentence in that appendix would make the interpretation clear in labor markets. And other places there's this implicit translation of monopoly language to monopsony, like as if it's easy to do. And I think it leaves out important factors if they're unspecified. So thanks.
Thank you, Eric.
Yeah, I just a general comment. There in the guidelines, there's this enormous tension between the desire to provide, guidelines, clear guidance, and the instinct, I think, among economists especially, to get the right answer in the particular case. And in the actual 2010 guidelines, there's a complete contradiction because it has these HHI thresholds, but then buried in the efficiency section near the end of it, it says the agencies will not challenge mergers where, as a result of efficiencies, prices will not go up. And that just makes it sound like they're going to do a cost benefit and whatever structural model, blah, blah, blah. And it's not even clear what the HHI thresholds are doing anymore, if that's actually the policy of the agencies, which I think it might well have been. And so I want to just say that getting right the balance between clear rules and nuance or complexity is extremely difficult, but that the balance should be the same, whatever it is, for labor market effects as for product market effects, unless there's something quite systematically different about the two, at a broad enough level that it should be incorporated into a rule. So I think there are arguments. I mean, Justin makes an argument, and there are arguments that there might be differences. I think they could go in either way, but I do think that should be kept in mind.
Thanks, everybody. And now it's lunch on the first floor. Thanks again for the whole panel.
All right. Thank you so much, Eric, for the really kind introduction. There was one part he got mixed up, which is that we all actually worked for Eric during his time at the Antitrust Division. But it's a real pleasure to be with all of you today. Candidly, I was looking forward to this program all week. And around Halloween, I started thinking about travel, and I checked the weather. And I was dismayed by the weather in Chicago that day, and even saw a Twitter post, Twitter X, whatever it's called now, that said something like, Chicago dressed up as January for Halloween. And for all of you watching at home, I'm happy to say it's actually quite lovely here. And thank you, Eric, and thank you to the Coase-Sandor Center for hosting all of us. This is really wonderful. So this terrific program marks the third and final workshop that the DOJ and the FTC have hosted about the draft merger guidelines. The agency staff have been hard at work for 22 months. After launching the merger guidelines RFI in January 2022, we received more than 5,000 comments. That's a 50-fold increase over prior calls for comment.
About that time, the drafting team really rolled up their sleeves. At the antitrust division, that team was led by the indomitable policy director, Dave Lawrence, and our chief economist, Dr. Susan Athey, who did the painstaking, important work of reading through the comments. They consulted thoroughly with the career staff. The lawyers read nearly every Supreme Court and Court of Appeals case that assessed a merger or an acquisition under Section 7 of the Clayton Act. And I know firsthand the value of that work because both the Assistant Attorney General and I did the same exercise, and we found it incredibly useful. At the same time, the economists brought the best of modern economics, strategy, and related disciplines to bear on how we answer the core question in every single merger review. How does competition present itself? After more than a year of careful work, the drafting team put pencils down. We released the draft merger guidelines for public comment in July. Since then, we have received more than 43,000 individual comments, including those submitted to regulations.gov and individual emails that came into the agencies. The vast majority of them were strongly supportive of the draft merger guidelines. We also received, by our count, 232 comments with in-depth discussion of specific substantive antitrust issues. These comments comprise thousands of pages of really thoughtful feedback. The drafting team read each one of them. By the numbers, approximately 105 were strongly supportive of the draft merger guidelines. Roughly 60 were critical of changes to the draft, and approximately 67 were mixed. So what are we doing here, hosting a workshop like this after the comment period has closed? The answer is simple. It's because we know the value of continued public engagement. Engaging critiques of the draft merger guidelines with thoughtful academics and practitioners and policy experts makes all of us at the agencies better. It helps ensure that the final work product will be clear, accessible, and above all, faithful to the law and benefiting from the best insights and analytical techniques available. So thank you to all the participants at today's workshop. Your insights and engagement are invaluable to all of us. I'm grateful to the staff who organized today's workshop, including Karina Lubell and Sarah Scheinman, who are in the audience, and we owe a special debt of gratitude to our friend, Professor Eric Posner, who is also our colleague at the division. So a growing body of research and writing, as well as direct feedback from the public itself, has suggested at least two things to us. First, harmful mergers have hastened the accumulation of market power. Abuse of that power has led to higher prices, reduced quality, and less consumer choice in products and services that Americans rely on. Unchecked mergers have reduced some industries to persistent oligopolies that suffer from tacit coordination and less innovation. Second, it suggests that Americans increasingly cannot challenge harmful corporate power on their own. From farmers and agricultural workers who face retaliation to families that are paying more for prescriptions and cannot afford what I will call the American style of healthcare, individuals have few, if any, options to counter the power of dominant firms. Perhaps that's what makes our charge so special. As antitrust enforcers, we know that our law enforcement efforts are critical to preserving free, open, and competitive markets. And we know that our work can go a long way towards helping to vindicate our collective economic liberty. An important part of our rule of law tradition is engaging openly and transparently about how we enforce the law. Our merger enforcement program benefits when we listen to each other and learn from each other, when we make our approach clear and rooted in the law as Congress wrote it and as the Supreme Court interpreted it. Workshops like this are one forum to promote that kind of feedback. We benefit from your legal and economic thinking, your real world experience, and frankly, your candor about really difficult issues. All of it helps make sure that the merger guidelines reflect sound thinking. At bottom, antitrust is too important to be limited to the Beltway. Consolidation affects us all. And as lawyers for the entire United States, we know the American people are our client. We know that the people are the objects of the law's solicitude and that our antitrust enforcement ultimately belongs to them. That's why we want our merger guidelines to be accessible and understandable. It furthers the goals of public participation in government as well as access to justice, and it may promote effective government and faith in democratic institutions themselves. I mentioned a moment ago that before we embarked on this journey of revising our merger guidelines, we sought public input. Thousands of people weighed in, and as you know, after we issued the draft merger guidelines, we again asked for feedback. Again, our inbox was flooded. The discussions we are having today about our draft merger guidelines are informed by many of the public comments that we've received throughout the process. Simply put, we've been blown away by the public response. People across the country wrote to the agencies to share their firsthand experiences about consolidation and their views on antitrust enforcement. The vast majority of commenters advocated for increased antitrust enforcement. This process had made something clear to me. While markets can be complicated and transactions can be complex, the American people ultimately understand what competition is. The public experiences firsthand how a merger can threaten harm to the competition that we all value. They feel the pinch of anti-competitive mergers that cause higher prices, degraded quality, reduced wages, and limited choices. They see it at the grocery store. They see it in the doctor's office. They see it on airplanes and on their phones. They see it reflected in their options for entertainment and news media. They also understand how consolidation affects their industries. We heard from farmers and food distributors who have seen costs for seeds and fertilizer rise. They've been forced out of industries that we as American consumers depend on. We heard from doctors, nurses, and other healthcare workers that complained of how mergers have made it harder for them to treat their patients with care. People know that when employers merge, they may have fewer options to switch jobs or earn a decent wage. They might even see worse conditions of employment and benefits. Because the American people are on the front lines of so many of these mergers, the draft merger guidelines expressly state that merger review will consider the market experiences of consumers, workers, and other affected individuals. Today, I want to talk just a bit about what consolidation means for one of those groups, and that's workers. Nearly every administration, since that of President Johnson, has released merger guidelines in one form or another. But these draft merger guidelines are the first to connect the dots between buyer power and labor markets. While the text in the draft merger guidelines on labor may be new, the underlying concepts and legal authorities on which we rely are not. Employers are buyers of labor. They're incentivized to keep wages low unless there's competition in the market for employee services. Adam Smith himself recognized this reality in The Wealth of Nations centuries ago. He wrote that, and I quote, "Scarcity of hands occasions a competition among masters," end quote, by which he meant employers who, quote, "bid against one another in order to get workmen and thus voluntarily break through the natural combination of these employers not to raise wages," end quote. Smith's theses have been recognized by the United States federal courts. And I'm very proud to say that the Antitrust Division at the Justice Department has been on the front lines of developing this thinking in this area of law. Some of you might remember the Silicon Valley no-poach cases. You probably remember that we issued HR guidance about how we were going to think about no-poach and wage fixing and information exchanges affecting workers in 2016. We developed second requests and civil investigative demand specifications in 2018. We prepared analytical memos for our internal staff to understand how we should be thinking about competition in labor markets. We hired labor economists. We brought on Dr. Ellie Prager, who is in the audience as a visiting scholar who helped sharpen our thinking after writing a terrific paper about how hospital mergers affect some kinds of workers. We brought on Eric Posner, who helped us think about labor issues and expand our thinking there and in other badly needed areas for improvement in our enforcement. In the last 3 years alone, we've charged 6 criminal cases affecting workers. We have resolved an esports league information exchange and salary cap case via consent decree. We have a chickens industry information exchange case that we resolved also by consent decree. We filed more than a dozen statements of interest and amicus briefs about no-poach and non-compete cases, including in the Supreme Court's landmark case in NCAA v. Alston. Recently, in DeSlandis versus McDonald's, which is about no poaching agreements and McDonald's franchise agreements, the Seventh Circuit ultimately agreed with the Antitrust Division that detriment to workers is a core concern of the antitrust laws. Suffice it to say, as an institution, we have learned a lot about factors that create or enhance monopsony power. Just last year, a court blocked Penguin Random House's $2.2 billion acquisition of Simon & Schuster because of potential harm to a certain type of worker, authors, who sell publishing rights to anticipated top-selling books. Again, we are incredibly proud of this trial victory. It's a path-breaking case that was built on years of a strong foundation of work and labor competition issues writ large. So we speak from experience when we say when firms merge, this critical competition for labor can be softened, and it's incumbent on all of us to study it. The shift from two firms that compete against each other for workers to a single firm can result in lower wages, fewer benefits, and limited workplace flexibility. These concerns are not abstract. Mergers affect people's real livelihoods. Of course, I'm not talking about the fictional Roy kids on Succession being denied the ability to keep their jobs after their father's business was acquired. Consolidation affects people's real ability to earn a living wage, put food on the table, raise their kids, and pursue the American dream. This issue affects workers across income classes, nurses, doctors, fast food workers, tech workers, and college athletes. For that reason, the draft merger guidelines make very clear that we will review all dimensions of competition, including the effect that mergers may have on workers. And in focusing on protecting workers, the draft merger guidelines recognize something we all know to be true. Americans are three-dimensional human beings with careers, families, and communities. The public needs the antitrust laws to work for them, and the antitrust laws need the public to ensure that competition is being protected across all markets alike. So thank you very much for having me. Thank you for traveling for many of you to be at this workshop, and thank you for your participation. I know firsthand that it will make our guidelines better than they would have been without all of you.
Hey, my name is Aviv Nevo. I'm the director of the Bureau of Economics at the FTC, and I'll be moderating our third panel, which is going to focus mostly on the topic of dynamic competition, but we're going to jump around kind of different topics. But before we start, I'd love to thank the organizers and Eric and University of Chicago for hosting us. It's been a great event so far, and we'll try to stay up to the standard of the previous two panels. We have a great panel start. So let me just start by introducing the panelists. I'll actually keep the remarks short because I feel if we go down the whole CV, we'll bite into our time to actually say comments. So going down the list, we have Rebecca Hall Allensworth, who's the Associate Dean for Research, and the David Daniels Allen Professor of Law at Vanderbilt Law School. She researches tech platforms and is currently writing a new book entitled Bored to Death on Professional Licensing Regimes. Love the title.
It has a new title, actually. The editor next Bored to Death.
Okay. All right. Well, I still look forward to it. Next, we have Gwendolyn J. Lindsay Cooley, who serves as the chair of the NAG, that's the National Association of Attorney Generals, Multi-State Antitrust Task Force, and as Wisconsin's Assistant Attorney General for Antitrust, a role which she has held since 2005. She has worked on numerous high-profile cases. I'm not going to list them all here, but it's next, we have Joe Farrell, who's a professor of economics at the University of California, Berkeley, an ex-colleague of mine. Joe has held several positions in government, including the director of the Bureau of Economics at the Federal Trade Commission, Deputy Assistant Attorney General for Economics at the U.S. Department of Justice, and the Chief Economist at the Federal Communications Commission. So Joe, I believe, is the only person to have held all three of those jobs. I think there's several of us that have held two of the three, but I think, Joe, you're the only one to have held all three. Next to Joe is Chad Severson, who is a very distinguished service professor of economics at the University of Chicago, Chicago Booth School of Business. I'll give you your money. Extremely, not just very, highly, extremely, very distinguished. His research focuses on firm structure, market structure, and productivity. And then finally, last but not least, is Tom Woolman, who's an associate professor of economics at the University of Chicago Booth School of Business, where he studies industrial organization economics and competition policy. Okay, so with that in mind, I think we actually have to start. I'm tired already. So I'm going to ask the panelists a few questions and invite each of them to respond, and then we'll kind of leave some time at the end for kind of more general closing comments. So let me start with noting that an important theme, and I think Susan touched on at the very beginning of the speech, and has been present throughout many of the panels. So an important theme of the draft merger guidelines is that they stress kind of and sometimes underemphasized part of the legal standard, namely the may or maybe and the may substantially lessen competition. This raises the question of the role of uncertainty, and obviously is especially important when we talk about dynamic competition and looking into the future. So the question is how to best balance the need to be able to act in the face of uncertainty with the need to support our evidence or support our actions with analysis and evidence. That's kind of a big overreaching question. Let's sort of kind of break that down. So agencies in court have long used structural measures. By structural measures, I mean concentration measures, HHI and change in HHI, as hopefully straightforward ways to cut through uncertainty and arrive at a decision about horizontal mergers. Indeed, as we've already kind of discussed before, Guideline 1 of the draft merger guidelines has the same structural presumption as 2010, though with lower thresholds. So has kind of the same idea, but the thresholds have been lowered. So, Joe, over a decade ago, when you were actually in my position as a BE director, I recall the speech you gave, and I'm paraphrasing here, so I hope I'm not mischaracterizing it. If so, please feel free to call me on it. That you talked a little bit about kind of, I think it was a lessening of competition is a little bit like dark matter. Okay, we know it's there, we know it has an effect, but we can't always see it, and it's definitely hard to model. So is this kind of a way to sort of thinking that, yeah, sometimes it's hard to model things, and can a structural presumption be an effective way of making horizontal enforcement decision under uncertainty faced with that difficulty?
Yeah, thank you, Aviv. I remember that speech, not in great detail, but I enjoyed it. It was Bill Rogerson's annual antitrust conference, which is the event of the year for antitrust economists. Unless, of course, there's a hearing like this taking place down the street. So what I had in mind in that speech was not that competition was hard to observe, it was that the effects of competition might be hard to observe. And so it was putting in a plug for valuing competition almost for its own sake, and not only because we can sometimes prove and document and quantify economic effects of competition. Having said that, though, just using the word competition and the phrase lessening of competition isn't necessarily helpful, because people have gotten wise to this, and so they will say that whatever it is they want to do is enhancing competition. So I think it's helpful to clarify, I hope it's clarifying, that the ultimate goal is to prevent the harmful economic effects of a loss of competition. But, and this was in my speech, and it has been in the guidelines previously, we will look at indicators, not proofs, not quantifications, but indicators that a harm to competition is taking place, and there are likely to be adverse economic effects. Now, there has been discomfort in the antitrust economics community that I've seen in the last month or two, particularly with Guideline 1, that the agencies might be saying we're not interested in effects. And I hope that's wrong. And if it is wrong, I hope you'll clarify that it's wrong and that the ultimate goal is a risk of harm to trading partners from a loss of competition. I think that would go a long way towards bringing a lot of people on board. But as Aviv stressed, there's uncertainty. David Gelfand, then Deputy Assistant Attorney General, talked about the CSI effect, the fallacy that if something is going to happen, you should be able to prove it. That's a fallacy. And it's particularly a fallacy in antitrust economics. So I think, you know, the draft says this, but you could say it more strongly and more explicitly. The agencies apply state-of-the-art techniques for predicting the economic effects of mergers, among other things. But those techniques, state of the art though they are imperfect. You get left with some uncertainty. You are taking the view, and I think rightly so, and has been taken before, but you're being more explicit about it, which is great, that if there is residual uncertainty, having considered all the evidence, then that makes the merger not perhaps illegal, but actually illegal. And that's an important point because, particularly when it comes to unilateral effects, we economists have learned to be relatively, I'll say, quasi-precise. We haven't done that with respect to coordinated effects, but with respect to unilateral effects, we have. And so there's a temptation for some people to come to expect that level of precision. I don't think it's there typically in a unilateral effect calculation, really, but it can be seen to be that. So I would also say, if you look at the logical structure of guidelines 1, 2, and 3 in particular, guidelines 2 and 3 are theories of harm, as we sometimes say. Guideline 1 is a leading, in the sense of popular, indicator for the risk of those harms. I think that logical non-parallel structure needs to be brought out and made explicit. And then why concentration? Well, partly for legal reasons, that it's the indicator that the Supreme Court has endorsed, but partly it's actually a pretty darn good preliminary indicator. It's not perfect for unilateral effect theories. It's not perfect for most coordinated effect theories. And the academic literature has tended to focus on those facts, but it's actually a pretty good Swiss Army knife for a variety of theories. And you should say that. As it is, you say the agencies have found it to be a useful and reliable indicator. I think you should say the agencies recognize that it's not a perfect indicator, but we still use it because it's a hard predictive task. Okay, I've gone on for too long, but I wanted to say all those things and I have more I need to say, but I'll stop.
Okay, well, you will have more opportunities, I promise. Tom, do you want to add anything to that?
Sure. I think just briefly, the other thing I would add here is that if you put aside even the substantive legal issues, I think there's a practical consideration for antitrust today, in particular at the DOJ and the FTC, and that is budget constraints. So that's a practical problem. And I think one of the values of having the guidelines so clearly lay out what the agencies consider is and is not illegal, is that through deterrence, that oftentimes is going to have a big reduction in the amount of expenditures that the agencies need to make. Which is to say, just to make sure everybody's on the same page, you could imagine two separate worlds, one where almost everybody is in agreement about what is and is not illegal, and also what the agencies are and are not going to litigate. And in that world of almost perfect deterrence, you would basically see no bad mergers ever come to market. The agency would be guaranteed to investigate them, and therefore individuals would not propose them in the first place. So they wouldn't need to be even reviewed at the pre-merger notification level. In an alternative world, you could imagine one where the agencies provide no guidance whatsoever. And so maybe you'd have to take a stand on the risk tolerance of the firms, but you could imagine almost every questionable merger coming to market, forcing the agencies to review them at the pre-merger notification level, and then afterwards even go through the steps of issuing a second request, depending on how much disagreement, I guess, there is also then litigating it. And by my recollection, I think about 80 to 90% of the agency budgets are probably in that very last step of actually litigating the merger. So I just want to emphasize the importance of this in a budget constrained world.
Okay. Thank you. Does anyone else want to add anything, or we'll talk more about structural presumptions in a slightly different context. So in guideline 6, the draft merger guidelines have a structural presumption, but for vertical mergers. They're based on the input shares for vertical mergers. And this is a departure from the 2010 vertical merger guidelines, which had no such presumption. So that's definitely one of the new elements in the draft merger guidelines. Reactions to this have been mixed. On one hand, some people like it, see it as a way to simplifying the analysis of vertical mergers. On the other hand, there's quite a few people who are skeptical about how informative market structure input is to the effects that we would see or potentially would see in a vertical merger. So before asking you about it, what I want to do is I want to suggest a slight reframing of guideline 6. So it has the elements of there, but let me add a couple more elements to it. So let me ask you the following. So what if the draft merger guidelines, instead of talking about a 50% share in the input market, would have talked more directly about the relevance of finding that a merged firm would have monopoly power over a critical input that its rivals need to compete? Suppose I use that language, right? And the idea is that Joe and I are competitors, okay? There's something that he critically or is very important for him to compete, and I'm now, through this merger, going to get control over it. Okay? Would, in that case, kind of framing it that way, would that justify a presumption that the merged firm had the ability to make others less competitive if they relied on that input? Rebecca, do you want to start us on this?
Yeah, so my short answer is no. I think that that sacrifice is something very important that the draft merger guidelines are doing. And to explain my answer, I want to back up a bit. So, you know, we had for 40 years, we had very heavy emphasis on static models of competition in antitrust law. And the idea was that, you know, we can sort of look at the way that the firms are situated, look at their incentives, and figure out whether or not consumers are going to be harmed. And we called this the consumer welfare paradigm or consumer welfare standard. And then you have the rise of the neo-Brandeisians, who came along and said a bunch of different things. One of the things that they said is that markets and competition are not just for consumers. Markets and competition are for democracy. We have smaller firms, then that's better for sort of political discourse. It's important to protect little guy producers, not necessarily consumers. Maybe a market that's less efficient is good as long as you have a more diverse set of producers. And so then those people got in charge of the FTC and the DOJ. And then that FTC and the DOJ came out with the draft merger guidelines. And we were all on the edge of our seats as to whether or not these draft merger guidelines would talk about democracy. Now, maybe some of you think this is unrealistic, that this was ever going to happen, but, you know, I was curious, is there going to be a talk about little guy producers and democracy? And the answer is no. So what we see throughout is actually what I would call the old consumer welfare standard, but with a different timeline. There is still a commitment to the idea that markets and competition are for consumers, but there is a reduced kind of focus myopically on the consumers of today. In some cases, we prioritize the consumers of tomorrow by looking in part at the structure of how these markets are put together and how that structure potentially is changed by a merger. So in other words, this argument that antitrust can be for all things turned out to be more bark than bite. I think this is important because that idea that markets are about so much more than consumers is revolutionary, and it's going to be very hard to get courts on board with it. I would like to see courts get on board with what actually seems to be the policy at the DOJ and the FTC, which is this longer time frame on consumer harm. It actually seems like the kind of things courts could and would go for if they believed that they were doing the same consumer welfare standard, but in a more realistic and longer term way. And so this is one of the changes that I'd like to see in the guidelines is more of an explicit commitment. And I understand there's a lot of opinions in the room, and there's a lot of compromise, and maybe this will never fly. But I think to the extent that these guidelines are going to be sellable to courts, which I think is essential to their success. I think this document cannot just be internal document within the agencies in order for it to be successful. Nor do I think that it should only be about providing notice to the merging parties. I think it needs to be instructive on courts for this to really make a difference. Anyway, I would like there to be an acknowledgement that we regulate markets and regulate competition for the name of consumers. And by the way, I also include workers in this, right? It's just a monopoly power. I'm not making an argument about how really everything needs to be about the literal consumer paying his money. Okay, so what does all this have to do with with verticality and the difference maybe between the 2020 vertical merger guidelines and these? And the answer to that question is entry. If you're really taking a dynamic view of competition and you're really trying to figure out how mergers are going to harm or help consumers long term, you have to think about how they make entry more difficult. And nowhere is this kind of more on display in as it is in the way the merger guidelines treat vertical mergers. So if we look at guideline 6, the one you asked me about, structures that foreclose competition. I'm thinking here about ecosystems. So we might put the meta within merger in this category. Harder and harder to enter the metaverse, unless you're Spider-Man, if you don't have the kinds of technology and the companies that within represented. The merger guidelines talk about a dual entry problem. The dual entry problem is real, but it's not a dual entry problem. It's a multi-entry problem. It's a 5, 10, 100 market problem when you're talking about ecosystems. Vertical or at least non-horizontal mergers can really amplify that kind of barrier to entry. Okay, so yeah, I think that reducing guideline 6 to a point about, do you presently or in the very near future have control over an input, a critical input for your competitor, is an important question, but we cannot reduce the guidelines treatment of verticality to that sort of syllogism. Otherwise, we collapse this back into the sort of static econometric models on which we've been relying too heavily so far. Okay, so I have a lot more to say, but I will focus on one quick thing, which is note that if we are going to say that this vertical merger is bad because it creates longer term structural entry problems, we have to also be willing to say that we're going to block it even if in the short term it might benefit consumers. That's scary, and it's somewhat scary for courts, but it is an inevitable conclusion. And I'm thinking of next week, you'll be able to get Call of Duty on your Game Pass. That was essentially the holding in that merger case. The court said, well, I think Call of Duty is a good game. People like it. And now it's going to be on Game Pass. I call that consumer welfare. Okay, that is the kind of thinking that we need to try to get courts away from. But I think it will require being somewhat upfront about the idea that there's going to be some breaking of eggs to make the omelet of longer term consumer welfare.
Okay, thank you. So let me just, I know there's others that are eager to comment in, but let me just push you on a little bit, because to be honest, I was a little bit confused by your answer, because you started by no, but then a lot of what you followed, I actually would have said would have been I would have categorized as a yes. So let me try to explain. So what I think this is trying to do, and maybe I wasn't very good articulating, is to actually say, and I'm tempted to use the Microsoft Activision example, but I shouldn't because it's an ongoing case, so I won't. So let me go back and, hopefully you guys can fill in the details of the players. Back to the idea of what we're trying to do here is to move away from a situation of articulating exactly the detail, just saying what this vertical merger may create or can create, a situation where one player is going to have a chokehold over something that's critical for another player to participate. And just going back to your dynamic issue, could be a current player, or it could be that I used Joe before as my example of a competitor. It's not that Joe and I are currently competing, but when Joe is considering entry, he will say, I will never enter this market because Aviv has a control of this critical asset. And we all know what kind of an SOB Aviv is, right? So I will never enter that market. So it directly, I think, addresses, see, that's where my contradiction is. I think what we're trying to do here is exactly what you've just said.
Changing my answer to yes.
Thank
I don't know if I prefer to give that much ground, but I see what you're saying. So, okay, Illumina Grail would be another good example of this, which is there's a critical input to the cancer screening thing. And so that's something that we should merge, even if those two companies are not, head to head competing. Meta within, but I guess the thing I keep going back to is, are you going to have to prove then that virtual reality exercise apps are a critical input to the future of this virtual reality metaverse that Meta is trying to build, and critical that no one else has it. So now we have the only. Courts are not going to buy that virtual reality apps or exercise apps are so hard. It's not lithium for batteries, right? So I guess I do still worry that maybe it goes too far to cabin what it is that we're worried about in vertical mergers. Does that answer make more sense?
Yes, but I know
Okay.
both Gwendolyn and Joe are eager to speak. So Gwendolyn, maybe you can go first and then we'll turn to Joe.
I'd be delighted. We'll have the battle of the pistachios here. So first of all, I'm going to go there on some of the things you said, but not everything. It is important to note that I have to represent all of the attorneys general. You can imagine what that's like. So let me give you a flavor of how they feel about Guideline 6 first. The 19 states. Beatrice earlier today talked about the 19 states submitting comments. Those 19 states, including Wisconsin, supported the rebuttable presumption in Guideline 6 about foreclosure share in a related market for a related product above 50%, establishing the rebuttable presumption. Tennessee submitted comments on the guidelines, in particular Guideline 6, and said that the 50% presumption as a foreclosure percentage was no longer consistent with law and enforcement practice. So with that aside, right, so you have diametrically opposed positions. I agree with you that courts need to adopt these guidelines. That has to be the framework. And I know that the guidelines are trying to be general, but you need an example here. I would take it out of the metaverse, if you will, and bring it to something much more mundane, something right there, hospitals, right? If a hospital controls a critical input, i.e. a surgery center, and acquires a group of physicians, right? That I think is the much more mundane, that's the much more easier to prove. I think that's where you can, if the question is, can the agencies change the law, then I would do it in that space. Because I think that when you go to a judge and you say, hey, here's this new and dynamic industry, they are going to say, Your Honor, all of the analysis is bad because of innovation. Don't look at the vertical merger guidelines. These guidelines are great. My opinion is if you want to do this, you might want to consider doing it in an industry that has much more of an established framework.
Joe?
Well, I have to say I don't get it. Guideline 6. I think if you have a pure monopoly at one level of a value chain, then a vertical merger is probably apt to be good and unlikely to do any harm. 50%, of course, is not a pure monopoly, but above 50% would include that case. And so I don't really see the analytical basis for saying that's an indicator that the vertical merger will be harmful. I see it as an indicator that it's apt to be important. If you had a 1% share in a related product, then probably nothing you did would be either noticeably good or noticeably bad. But I don't really see the economic logic behind it. Now, maybe that means that I'm operating in too static a framework, but I'm left a little puzzled by the guideline, honestly. And in general, I would say, we are better at understanding horizontal mergers than at understanding vertical mergers, but I think that's not a reason to try to include the vertical merger analysis in the same document. I think it's perhaps a reason to have a more easily developable as opposed to frozen, semi-frozen. Guidelines last a decade or so, it turns out. So I don't think it's necessarily wrong. I certainly don't think it's necessarily wrong, but I don't think it's convincingly right either. Whereas a general approach with regard to horizontal mergers, I think, is sound. So I wouldn't necessarily combine them.
Okay. Chad?
Thank you. First, I'll mention, just for the sake of disclosure, I'm currently serving as an expert in an antitrust case privately brought that, broadly speaking, has some vertical issues in it. I think it's useful to recognize first, at least in the physical goods space, half of vertical ownership in the United States, where a company owns establishments that make something that the company also uses, of the type the company uses, but the company doesn't actually supply itself at all. Okay, so a lot of vertical ownership structure is not actually tied to movement of goods along the supply chain. And that can cut either way for antitrust policy. I think one is, if the theory of harm is about control of some key physical input, then, you know, a lot of the time that's not going to apply. Of course, in any given case, I think the agencies will be able to sort of look at the situation and know whether that's likely to hold or not. And I don't know what that fact is, if it's also 50% for services, but I do know it is for goods. So that's just one thing to keep in mind. I guess I'm kind of leaning in Joe's direction, maybe a little less. My view is, I don't know where the 50% number comes from. I don't see the theoretical case, formal in the literature, or even just kind of stretching what people have found in the literature to say that setting some threshold at 50% is more likely to stop more bad mergers than good. I do like the rephrasing you offered, Aviv, because I think what have we learned, about the theory of foreclosure? Raising rivals costs can work, but it works under only certain conditions. It's not really a super general thing. A market share test is not, I don't think, a low dimensional way to get at that. I think it's a much tougher problem to nail down, like, this is a likely kind of foreclosure situation. So I would like, while I understand the benefit of hard numbers for a lot of reasons that we already talked about with the horizontal presumptions, I just don't think we're far enough along in terms of what we know to have such a sharp line for vertical stuff. And I'd rather see it focused in a more general context and language.
Okay, thank you. So I'll move us a little bit along from the kind of the structural presumptions to talking about uncertainty and starting to move towards dynamics. So there's generally a lot of uncertainty what will happen with the merger, but sometimes what will happen without the merger is just as difficult. And this is the core issue in cases where the merger may remove a potential entrant, which the draft guidelines tackle in guideline 4. So does the draft get the right balance between being able to act and a standard of proof? Rebecca, maybe you can start us.
Yeah, I think basically, yes. I think that they've doubled down on the language from, may be to substantially lessen. Okay, and so I think that there's basically 3 moves that the guidelines make in this direction. So one way of dealing with uncertainty is to talk about ability and incentives. So we don't really know how these firms will behave, but there's a lot of places where the guidelines talk about, and yet we know that this company has the ability and the incentive to behave in this way, and that is enough to create a presumption of risk of that future behavior. I think that kind of analysis adds some rigor to it, not maybe as much as, econometric modeling would in a more kind of static type situation, but it would at least force the plaintiff to say, this is where we find the ability and where we find the incentive. And then the other way to deal with it is to talk about this statutory language, maybe substantially lessen, says we don't have to prove things to a certainty. And then if you look throughout the guidelines, they have phrases like substantial likelihood, reasonable probability. These are legal terms. All law is done under conditions of uncertainty. All proof is relatively uncertain. And I think, I could go into a longer discussion here of error costs. But the idea that there needs to be some proof, some argument, and some assessment of risk without it being to a level of certainty, I think is totally appropriate. The last thing you can do that the guidelines do with uncertainty is to answer the question a little bit differently by looking at the way the firms view their own situation. So what will happen? Well, we don't know, but what did the CEO think would happen? What did the CEO worry about? What kept Bill Gates up at night? The idea of losing his market power over operating systems made him real nervous. And so he did something about it, to what extent, and then there are some major downsides to relying on internal documents and on their own views. But between these three kind of moves, I think that you can triangulate at this question of uncertainty in a way that is reasonable. Again, though, you have to be able to sell it to courts and to point out that operating under uncertainty is something that they do all the time. Predictions about criminal dangerousness, for example, is something that can't be proved to a certainty, and yet we do it all the time.
Thank you. Does anyone want to follow up with the responses?
I would just say, again, to be boringly practical, to deal with that uncertainty, though, you do have to go through the boringness of the internal documents, which is how they found the Bill Gates document saying that was what was keeping him up at night, right? Like, and again, Beatrice talked about this earlier today, but right, the importance of document review, the importance of direct evidence. I personally have had a ruling against our office in the T-Mobile case, because the judge couldn't see what would happen in his crystal ball, because he thought maybe you would see Dish Network phones.
I do think, I think worrying about potential entry and trying to encourage courts to enforce more vigorously is helpful. One thing that would be helpful, I think, which I don't think is in the draft guidelines, would be to point out that instead of acquiring one of the larger and more successful complements to your own business, you could acquire a toehold and expand it. That sometimes does seem more realistic than saying you could enter completely de novo, but it would be a little revolutionary in the sense that usually antitrust enforcers don't say, well, is there an alternative merger that would be less competitively threatening? And that might be a place to introduce that consideration. I don't see why you shouldn't say that.
Thank you. Chad, I know you've been jumping.
That's right. You're asking this in part in the context of guideline 4, or you
in guideline 4, but
yeah.
Feel free to speak more generally.
No, I'll speak to guideline 4 in particular. Just want to make sure. I think, one of the things we economists have learned since the last set of merger guidelines is killer acquisitions are real. They happen. Not every purchase of a small, young company is a killer acquisition, but there are some. So I think to make it known that the agencies have their antenna up for those sorts of situations, I think is important. I think theory offers some guidance about what kind of acquisitions of young, small companies are more likely to be killer acquisitions than others, but just the general principle of, hey, we realize this is a thing. We want to stop it when it's going to be anti-competitive, and we're going to be looking for it. I think that's an important addition.
Thank you. So moving on a little bit beyond guideline 4, but still saying, so both guidelines 4 and 7 include concerns about a large firm entering nearby markets through acquisition and embody a preference for internal growth over that acquisition. Is that a valuable rule of thumb? Is that something that should be in the consideration? Anyone want to? Chad?
Well, just to almost repeat what I said before, my experience with what I've seen in cases and been told by people who would probably know is it's surprising, I think surprising is the right word, how much harder de novo entry is than expansion in a lot of cases. And so having a preference for de novo entry makes perfect sense. You don't want that to turn into too big a hurdle when you're thinking about it as a toehold acquisition.
Chad?
All else equal, yes, I think you'd much rather see organic expansion than merger, because there's much less likely to be the anti-competitive pricing and other effects of the horizontal merger. You keep an extra actor in the market. But that's an all else equal. That's not how a lot of markets actually work. And, I guess I'm a lot of times I come to the view of industries is there's a lot of misallocation. There are inputs that aren't being applied to their greatest use. We see huge differences in how effectively companies use them. And sometimes the efficient thing you want to happen is for a better, more efficient user of those inputs to take over through merger acquisition, their application. So as a ceteris paribus, yeah, I'd rather see organic expansion than a merger, but it's rare where we actually get to choose between that option and merger and nothing else changes.
Okay, anyone else on this topic? So often the agencies can focus their assessment on the transaction in front of them, but sometimes there are broader trends that could affect that have effect on competition. These issues are tackled in guidelines 6, 8, and 9. We already talked about 6. We talked about the first part, but also a second part that we'll touch about in a second. So let me start with guideline 9. Guideline 9 is the one that talks about evaluating a series of acquisitions together. I think we've already talked about it in some of the earlier panels, or some of the earlier panels touched on it. So the broader trend in this guideline is the series of prior transactions by the merging parties should be looked at together. What do you think of the idea of looking at a series of acquisitions? Tom, do you want to start us?
Sure. So just again, so that we're all on the same page, the sort of canonical example here would be a very fragmented industry where you have maybe, say, 100 different players, each with 1% market share. And you could imagine a firm which is perhaps consciously going to go firm by firm and roll up the entire industry, or at least a subset of it, through markets, and eventually get to the point where they're monopolist. But among the problems that you'd have is that the HHI change associated with any individual merger along the way would never get anywhere close, perhaps to even 100 points. I think at one point, maybe 5 years ago or so, concerns about this would have been viewed almost pretty far-fetched. I mean, I think in a way, perhaps like a sort of conspiracy theory. I think today, this is reasonably well accepted. I think it's viewed as commonly occurring. I'll give you maybe one archetypical example. This comes from a recent, somewhat novel, I would say, lawsuit from the FTC, where they are suing Welsh Carson, which is a private equity firm, and the portfolio company here, which is U.S. Anesthesiology Partners. And the agency is alleging here that the private equity sponsor, rather consciously again, rolled up the entire, more or less the entire state of Texas, most of the major cities. And in those cities, subsequently, as they gained market power, raised prices dramatically, like on average, maybe on the order of about 60 or 70 or 80% following an acquisition. Just to give you an idea, I think, as to the consciousness of the portfolio company or the private equity sponsor here, the internal way they describe this, and this is highly technical, they called this ka-ching. That was literally how Welsh Carson was describing the strategy. I think I should also add, maybe now would be a good time, that Guideline 9 clearly relates to the substantive legal standard here, but also you're going to run headfirst into a procedural problem, and that relates to merger reportability. So the agency oftentimes is not going to learn about these transactions in their incipiency, which could be a pretty serious problem. Just for those of you that don't know, typically, at least in the United States today, no merger is reported if the value of the transaction is below about $100 million. In many cases, tech-related pharmaceuticals and so forth, that effective threshold is closer to $440 million. When private equity is involved for strange idiosyncratic reasons, it could be perhaps as much as an order of magnitude higher. And while that reportability doesn't impact the legality of the merger in any way, the agencies really can only injunct what they see, typically. So you could get into a situation where, and I think this is true in a lot of industries, where even though they should really not be related at all, the contours of the pre-merger notification program, the reporting requirements, are really pretty much the same thing as the contours of the substantive legal standard, all of Section 7, because they can only attack what's seen. So fortunately, there's been unrelated changes recently to the reporting requirements, or at least there very well could be changes to the form. And I think that's going to be helpful in the agency seeing a much broader span of transactions, which could be anti-competitive.
Thank you. Gwendolyn?
I would just add, I mean, I think the traditional way that the states and the agencies have gone after roll-ups is through conduct cases, right? After the fact, after everything's been rolled up. If you think about Indiana Federation of Dentists, it was the early roll-up of Delta Dental. And so, I mean, when Congress made the directive to take on mergers in the incipiency, I think that's the idea, right? So it's good that you're looking at it.
Can I ask for a clarification in writing again? There are several guidelines or sections that talk about trends. Some, but I think not all, can be put in the following category. Merger analysis looks at what will happen with and without the merger, and the reality in each of those cases is not a snapshot, right? And so if there's a general trend, then what seems as a snapshot like a 5-4 merger might actually be a 3-2 merger. But I think that's not what you're saying in the trends sections. Similarly, failing firm, I mean, that's always separated out, I think, as a result of some court case. But really, that's just an aspect of reality. If this firm is not going to be an independent competitor next year anyway, then it's not a 4-3 merger, it's a 3-2 merger, or perhaps a 3-3 merger. And you got to recognize that. I think there are some more subtle and more interesting things going on in your trends sections, but I think it would be helpful if you said explicitly what those are.
So what kind of things do you have in mind?
Well, for example, that the trend might illustrate the importance of economies of scale, or alternatively, a trend towards vertical integration might reflect an arms race, or it might reflect real efficiencies of vertical integration. So you might learn something from the trend. You might regard the trend as endogenous or as something that needs to be stopped at some point. You may not be sure exactly what point, and that would lead to perhaps conventional enforcement difficulties. But I think it would be worth separating out the simple non-snapshot reality, because that's conceptually very easy. And then these other things are maybe more interesting and more novel.
Okay. Anyone else on this topic? Although I guess we're moving to guideline 8, which directly talks on this. So guideline 8 is addressing settings where a merger is a part of a broader trend towards horizontal consolidation, while in guideline 6, or the second part of guideline 6, a trend to vertical integration is treated a factor that reinforces concerns. Okay, kind of directly speaking, Joe, to what you've just mentioned. What role should these trends play in the agency's assessment? Should these trends always be a signal of heightened concern? Should be part of separate guidelines as in the draft, or are these better addressed as kind of overall considerations, you know, along the lines maybe of what Joe just mentioned? So Gwendolyn, maybe you can kick us off here.
Sure. I mean, so I think the question is it the end game or is it the initial screen? And I think the Supreme Court has said that it's a highly relevant factor. And so that it should be a factor, and my read of that is that it should be in the initial screen. In my opinion, or in my experience rather, for a merger to be challenged, it is often a combination of many factors that lead to a challenge. I think now that we've got these all lovely numbered guidelines, I think we'll see it's a 1, 3, 5, and 8 when we're making our cases. Pabst Brewing says a trend toward concentration in the industry, whatever its causes, is a highly relevant factor in deciding how substantial the anti-competitive effect of a merger may be. And so it is a factor. I think that's how we should look at it. And I also think Pabst itself factually could not possibly be more on point with trends in the industry. If you read the decision, it's from 1966. So at the time, the market, they had 3 separate geographic markets. I like to talk about it because we're in one of them, right? So Wisconsin was one of them, my home state. 11.32% in the tri-state area, including here, and 4.49% nationwide. There, the court comes up with the famous no meets and bounds language that's cited incorrectly in the merger guidelines. Yeah,
okay.
By the way, it's Pabst.
It's up there. You see the lawyers?
Yeah.
Yeah. They're in charge of citation. We're in charge of the equations.
Sorry to publicly embarrass you on that one. So although, right, the it was large, the concentration was large in my home state. The merger took place in an industry marked by a steady trend toward economic concentration, says the court. 1966, that's spot on, right? The trend is there's currently, in terms of brewers, over 1% nationwide market share. There's 4. AB InBev has 40% of the market. Molson Coors has 25. Constellation 9.4. Heineken USA 4%. Whereas Pabst now, it's owned by private equity and brewed under contract by Molson Coors, right? So it has been acquired and acquired and acquired and then dropped. So I think you have to analyze mergers in the context of trends.
Chad?
Totally agree. Trends matter. I think the reason for the trend is important. If a concentration trend is happening because some sort of friction has been removed from the market, that's a sign that the market is working, not that it's failing. So that alone, I'm not a fan of just saying, well, a trend towards concentration lifts the hurdle, unless I guess there's a separate hurdle just conditional on any concentration level. A merger will have more, create more damage given the concentration level. But I don't see pure trends in and of itself per se as being a sign of harm. Now, if the trend is reflecting a roll-up, I think that's a different view, or that should get attention in a different way than a trend towards concentration coming from, again, some shift in the way the market works that's made it more competitive. So trends are completely relevant. They should be taken into context, but it's not just, is there a trend, yes or no? It's why is the trend happening? And is this merger a continuation of an anti-competitive trend or the turnaround from a pro-competitive trend?
Joe, I think you've pretty much spoken to this topic. I don't know if you want anything in response to what you've heard. If not, I actually have a follow-up question for you, maybe. So I hear what you're saying, and some, what Chad is saying, which is, yes, there could be different reasons, but actually, as an ex-enforcer, I mean, you kind of know the difficulty of, well, how do you prove it, and how do you go into the details? And we can't say, well, on one hand, and on the other hand, would that leave us really with really nothing in hand? And so any ideas of something kind of more concrete that we can hang our hat on, except to say, well, trends could be driven by a lot of things? Sorry to put you on the spot with not an easy question.
I think, leaving aside what I would regard as the more novel things like an arms race to integrate with bargaining partners and so on. I think basically it's all part of recognizing that the world for evaluating the merger is not a snapshot, it's a dynamic process, right? And so if you think that another merger is likely to come along and it's going to be hard to block that one, or that one of these firms is maybe going to exit the business or go out of business altogether, that's reality that you want to take into account. I think there's a separate point, which is Tom's point about sometimes you'll have an insidious trend and you won't know where to intervene. And, that does come up frequently. I've heard that mentioned, for example, in the case of cell phone service providers, that it started becoming obvious that there was a trend and nobody quite knew where to stop it. So it doesn't have to be these atomistic roll-ups. It can be sort of oligopolistic roll-ups. So yeah, I'd say if you know what the trend is, then that's just the reality you're working with. If you don't know what the trend is, you recognize that that's uncertain and you err on the side of caution, where caution means preserving at least some significant rivalry against, not exactly worst case, but relatively pessimistic case. That would be nice. Now, whether the courts really let you do that is another matter, but you've got a chance in this document to explain to the courts what you will do and why before it becomes litigation and people get skeptical of everything you say. So I think that's one big advantage of the guidelines over filings in court cases, is that there's some detachment from the incentives of litigation, and you need to take advantage of that.
Okay, so I want to move us on from the issue of trends and dynamics, but if anyone has any last comments. Okay, so I'd like to touch on one more topic and then open it up for kind of more general remarks. So in recent years, the agencies have relied more on concerns about loss of competition between the merging firms, what we sometimes refer to as unilateral effect, and less about concerns that firms and the market as a whole will begin to coordinate their actions more closely. Again, what we refer to as a coordinated effect. And I think, Joe, you talked about, you touched on that a little bit earlier. My view, which I think, again, is consistent with what Joe mentioned earlier, is that this is largely because when it comes to unilateral effects, we might have more models that we can play with, more precise predictions of the interactions. And when it comes to coordination, it's a little bit more difficult, especially kind of to articulate exactly what is it the merger changes about the idea to coordinate. At the same time, I think there's I'd say widespread, but there is a sentiment that the agencies are missing many cases where a merger would lead to coordinated effects. And then on top of that, whether that's true or not, one thing to also realize is when it comes to coordination, in some sense, merger enforcement is kind of our last line of defense. Okay, in some sense, I say, because putting aside very explicit, criminal, what we prosecute under criminal coordination, right? But what we economists usually refer to as tacit coordination, it's something that if it happens post-merger, it's not clear that we actually have something that we can do about it. So with all that in mind, what Guideline 3 is trying to do is to shift the balance, I don't know if back, but to kind of maybe talk a bit more about coordinated effects, despite all the uncertainty in terms of ability to predict it with models. So did we get the balance right? Are we missing anything? Joe, what are your thoughts?
Well, thanks. This is actually a bit of a hobby horse of mine. So if we think about oligopoly conduct, and by conduct, I'll say, I mean, pricing, quality improvements, whole range of things like that. One of the striking things that you learn in examining oligopolies in the context of merger investigations and otherwise is no big surprise. They pay attention to how they think their rival's going to respond. And if I'm thinking about a price cut, I'll be discouraged from the price cut if I think my rivals will respond. And I'll be encouraged about raising my price if I think the rivals are going to respond. So where is that in the guidelines or in the academic literature on oligopoly? The answer, I'm sorry to say, is it's been sort of abandoned in the academic literature for reasons that are understandable but not sufficient. And that's sort of infected the enforcement literature and thinking. So in the academic world, oligopoly is modeled in two ways. One is static models. And by static, it doesn't mean ignoring innovation or anything, but it means not paying attention to responses. And the other is this kind of collusion or near collusive tacit coordination that Aviv mentioned. A huge area, in my opinion, of oligopoly conduct is what John Baker and I have called non-purposive coordination, where if your rival does something, of course, you're going to respond because your competitive environment has changed. And you don't have to be trying to establish a coordinated, profitable outcome to do that, right? That got abandoned in the academic literature, at least on the theory side, when we discovered that there's no perfect way to write down a model of it. And that remains true. But there are imperfect ways. And I think an imperfect way to write down a model or to think about that kind of thing could give us some degree of predictability of something that might be called coordinated effects. Coordinated effects in the sense that they depend on these responses, could give us some degree of predictability of a tendency for reactions to be strong and important to the first mover, which might help convince courts that they should pay attention to this as opposed to, well, anytime you have an oligopoly with fewer than a couple of hundred participants, the arithmetic of subgame perfect equilibrium suggests that you might get tacit coordination. On the other hand, you might not, right? Which tends to be where we're stuck at now. So I think there's a lot that can be done in that direction. The draft guidelines certainly don't rule that out. Optimistically reading them, I think they actually make the point, and they refer to the importance of responses and so on. But I think I would be happier if the guidelines said a bit more about that. It was in the 2010 guidelines. There, for reasons that I no longer remember, we called it parallel accommodating conduct, which is a supremely unhelpful phrase, I'm sorry to say. I probably deserve the blame for coming up with that phrase. I don't remember. But whatever phrase one uses, or whether one includes it under coordinated conduct or in some other category, doesn't really matter. It does matter that we start to pay attention to it more.
So do you view this as a way of, let me call it, storytelling or narrative telling, of saying this is a way to explain to the court or to ourselves why we care about potential coordinated effects? Or do you see anything very practical in terms of, okay, now we go to the court, we're going to do something different, or ask our expert to do something different, whether we have that, whether we call it parallel accommodating conduct or something else?
Yeah, I mean, to me, it's a feature of oligopoly behavior that ought to affect the internal evaluation of a merger, to the extent that you can say, anything at all predictable about it. And you'd naturally want to explain to a court that if the diversion ratios are high, then the effect of a price cut by me on your demand curve is going to be relatively strong, and you'll probably respond to that. And if the diversion ratio in the other direction is high, then I'll care about your response. So it does actually link up with some of the features, diversion ratios in this case, that are shared by unilateral effects calculations. They matter in different ways, but they matter here as well. And I think that's sort of helpful because it reinforces the idea that although concentration is kind of a Swiss Army knife, not exactly right for any theory that we're aware of, it's sort of somewhat right, like a Swiss Army knife, for a lot of different tasks. And this would be one. So I think that could be helpful and could be relatively intuitive for a lot of courts.
Okay, thank you. Gwendolyn, do you have anything to add?
Just to give a little bit of a legal gloss on that, I think the key would be the more. Courts have, well, the Supreme Court has said parallel pricing conduct without more is not an antitrust violation. So you would need to have you would need to have those merger guideline number 1375 kinds of situations. I think the guidelines here are it's really important that we reiterate the importance of us enforcers looking at coordination. My mild foray into academia, I co-wrote a paper on prior bad acts with Professor Michael Carrier at Rutgers about how we might consider both coordinated conduct and unilateral conduct, and a proposed test to look at that. But what I want to talk about is what the AGs said about the guidelines. And I think both sides think, both Tennessee and the 19 states think that we need to make it clear to parties that we're considering the coordinated effects. I know from personal experience that this sounds so simple, but if we have a guilty plea on past conduct and I go to the merging parties and I say, hey, you have a guilty plea past coordinated conduct with this, the other merging party, they act surprised. So I think that it's important that we actually note that this is something we're still looking at. States also have some suggestions for how you could illustrate that. The maverick aspect of increasing the risk of coordination and this guideline, they suggest Southwest Frontier, AT&T, T-Mo, Visa Plaid. Also, how we should discuss how the firm's behavior can be promptly and easily observed by rivals, right? If it's something you can't model, we need a little bit more explanation on how you're going to do that. I didn't write which state said this, but I think that this is probably true for both. We need to clarify, if a firm has different incentives, could we provide examples on what we mean by different incentives? I mean, I'm sorry for whichever group of states I'm misascribing that to, but I think that that's generally true.
Anything else on coordination? Okay, well, we have about, let me see, about 10 minutes left. Why don't we take those 10 minutes kind of for last comments about, anything about the guidelines, meaning of life, or any other thoughtful thoughts, just to, why don't we go in reverse order? Tom, do you want to start?
Sure. One thing I'd say, the end of this is also that I think there could be, in some of these cases, very positive knock-on effects from some of the guidelines here. I'll give you an example. We were talking about coordinated effects here, and I think you could also, Aviv, I think baked into your question in a way was that we do have another way of addressing those, and that would be Section 1 if it was explicit conduct. And I guess what I would say to that is that's fine if we catch them, but sometimes that's hard. And so what you might worry about in a lot of cases is that we're not catching a lot of the explicit collusion that goes on. I'll give an example from the Teva case, and everything here is going to be what the states allege. I should make that clear. But in the case of the, what I think is probably, maybe arguably, the largest cartel in U.S. history, perhaps, how that actually played itself out was an individual username was at a large distributor. She had very strong relationships within the manufacturers. And she came over to one of the manufacturers. She was hired with, her role was literally price increase implementation. So you could read between the lines there. When she got to Teva, the first thing she said was, and I think other people, there's other strong sense that meant what it implied. And so when she got to Teva, she asked the internal staff for two things. One, a list of all the drug markets that they were involved in, and also all the firms that she's competing with in those drug markets. And she scored each of those firms between +3 and -3. +3 was like a close personal friend. -3 was, I don't know this person, they're not going to be cooperative or what have you. And literally, took an average within each of the drug markets. Teva was active in about 350 or so drug markets, took an average of this quality score, sort of relationship score, sorted them. And again, it's all alleged in the case, set a cutoff and took the drugs that were above that cutoff and put them into an Excel file called the immediate price increase document, I think was the name of it. Now, later we find out about this for a host of reasons, but I guess the reason I'm bringing this up is, in a way, if you were to regress on, say, the number of rivals in a particular market, that was extremely highly predictive of whether or not there was going to be, whether or not she was going to be able to cartelize the market. When there was, say, 4 or 5 or 6, you could see from internal documents, she would say too many. This is like too hard to get everybody to coalesce around a single set of prices. And so I think even beyond what we can do with Section 1 explicitly, what this could do in trying to deter in a way the coordinated effects, you could also address a lot beyond that. And I think that extends to other guidelines as well. I'll leave it there.
Thank you. Chad?
My summary, I'm an empirical researcher. So I thought, well, what have we learned empirically about antitrust related stuff since the last merger guidelines? I came up with 3 big things. One is the killer acquisition stuff. I already mentioned that they exist and can happen. The second is the roll-ups phenomenon. And Tom was too modest to mention he's one of the people, if not the person most responsible for the change in people's knowledge about the likelihood or the existence of that stuff over the last 5 years. But a lot of work he's done has really flagged that. And then the other thing is the labor market monopsony stuff, monopsony in general, but especially in the labor market. And my view on the guidelines vis-a-vis those things is each one of them is addressed. So I think that's great because I think empirical evidence should drive policy whenever possible. Now, I think there are other things in here that aren't necessarily supported by empirical evidence, and it's more, we just don't have good evidence, then it leans the other way, which would be more problematic. But I think, and I've spoken to some of that, but I think it's, I would prefer that the guidelines be guided themselves by empirical evidence as much as possible, and it has in these important directions, and that's good. And to be fair, I realize merger policies in the past have changed for reasons not related, changed a lot for reasons not related to empirics. I went back and read Bork. He wouldn't have known a regression if it bit him in the butt. So, there wasn't a lot of empirical evidence driving that shift, but let's try to hew to that as closely as we can. And there are definitely aspects of these guidelines that I think I'm happy about that.
Okay, thank you.
I've mentioned concentration a few times, and of course it appears prominently in the draft guidelines. I've said I'd like to see a reframing of what guideline 1 is about, that it's an indicator of risk for harm of certain other kinds, rather than being logically parallel with guidelines 2, 3, and some of the others. You can't, however, really talk about concentration without talking about market definition. So let me finish my contribution with a couple of points about market definition. First of all, in section 3, the draft guidelines describe 4 approaches to market definition, one of which is the hypothetical monopolist test, as if that were one of 4 options. But if a candidate market fails the hypothetical monopolist test, it is too narrow for there to be competitive effects within the market. And so it's going to be a real problem, I think, if you don't pass, or if you visibly don't pass, provably don't pass the hypothetical monopolist test. I think what happened was that the 92 guidelines version of the hypothetical monopolist test claimed to be an algorithm for defining a market, as opposed to a test, which is the way it's much more frequently used in my experience, for a candidate market that you've come up with in some other way, such as brown shoe type factors. So that needs to be cleaned up. And I don't think it's optional to pass, or at least it's a problem if you flunk the hypothetical monopolist test. But I don't think it's the usual way that a market is constructed. It's a test that's applied when you've derived it otherwise. I'll finish with a slogan about market definition. A few weeks ago, I had the privilege of picking blackberries with my 95-year-old mother. She's doing great. It reminds me of that. Market definition, I forget what wise person said this first, it wasn't me. Market definition is helpful and useful when it's easy. When it's hard, you don't get much out of it.
Yes. Okay, thank you. Gwendolyn?
Well, since you were talking about market definition, I'll start with that first. If it's going to be, just as a practical matter, I think these guidelines need to be easy to use. And I know that you guys have spent a year trying to make them easy to use. But if I'm going to give it to a judge, if this is important, if this is a threshold question, let's put it toward the beginning. You've already heard 100 times, we need to integrate the appendices into the actual document. I agree with that, so that they're not repetitive. How many of the flag guidelines do I need to prove a case? And how many before the agencies will proceed with an investigation? But is that actually true? Right, I mean, and so what about what if you have 4 guidelines in one small local market, but 1 guideline nationally? So I think need some clarification on that. And I'll just conclude with saying, it's fun to be on a panel with economists. Thank you for letting me join you. Mergers are complicated in practice. And there is we talked about prosecutorial discretion now, there's some divergence now. I think the guidelines should be a roadmap, not just for judges, but for us. And so to the extent that you can make our jobs easier by where the guidelines are the same throughout or the same as in 2010, please, pretty please, use the same words so the judges don't think I'm tricking them.
Thank you. Well, Rebecca, you got 2 minutes to take us home.
Okay, so I'm also not an economist, so I'm actually like extremely sympathetic to everything you've said. I think they need to be, one of the nice things about the old guidelines is they were a kind of cookbook. It was like step 1, step 2. I think that these guidelines would be much more useful and influential and seem less tricky if there was, for lack of a better word, a kind of algorithmic way of approaching these things. And I understand that the agencies maybe didn't want to do that because that's how we got into this trouble in the first place. If you make everything so stepwise, then you just create all kinds of steps that can be missed. And then if they're missed, then the plaintiff loses. But you don't actually have to construct them that way. So you could imagine a different way of constructing them where you start with, what's the market in question that we're worried about? Is it a market that exists now? Is it a market that might exist later? Then you might ask the question, what's the kind of harm that might happen in this market? I see 3 different categories of harm. One is head-to-head, present-day competition in this market. Another whole category that's scattered throughout would be the vertical question or the non-horizontal question, something that has to do with entry, something that incorporates dynamic competition more. Does this, even if it doesn't stop head-to-head competition now, does it create a risk that it will in the future? That would make more explicit this idea of future harm. Then you might have the third, which would be coordinated effects. And then you might have a special category for platforms or something. I'm ambivalent about whether or not you do that. But you would make clear that, so you'd avoid the problem that Gwendolyn's talking about how many of these do I need? It's like you need one of those 3. Either your merger in a sort of short-term static model harms competition, or in a long-term, more entry-focused model, it will harm future competition, or it's going to increase coordinated effects. If it does 2 of those, great. I think that would be a much more clear, and by the way, at each of those steps, you would have the stuff that's in the appendices. You would just pull in the economics into those questions, because a lot of those questions are going to be helped by things like the hypothetical monopolist. I know I'm over 2 minutes, but I want to say one thing. I don't read the hypothetical monopolist thing the same way you do. It's not that you fail it with good data and you have great data and you failed. It's that we don't really often have the data to do the hypothetical monopolist test. And so that is one tool, because it's such a limited tool. It's such a, it only works in certain contexts. And so you have to have other ways like the practical indicia where you just don't have reliable data on that. That's the way I read it.
30 seconds, Joe?
Well, I tried to be careful to say it's a problem if you provably or verifiably fail the hypothetical monopolist test. And that was intended to cover the case where you can't actually run the test as a quantitative thing, which of course is very common. It's still an organizing principle that people comment on. And I think that's fine. And, you know, if somebody convinces a court that you probably have failed the hypothetical monopolist test, even though you haven't, the numbers aren't there, that would be a problem. But I think the bigger issue is it's presented in the draft guidelines as if it were an alternative to coming up with a candidate market in some other way. Whereas in fact, I think it's something that either you can do or you can't do once you have a candidate market come up with in another way, which I think is just what you were saying.
Okay, well, apologies for going 2 minutes over, but please join me in thanking the panelists. And thank you, Eric. So first, I want to thank the University of Chicago Law School for hosting us, and for Eric and the staff for putting this event together. I'd also like to thank all the speakers on all the 3 panels, also the speakers in our previous workshop, as well as the literally, as you heard, thousands of folks that have submitted written comments in one way or another, either through sending us emails or engaging with us informally, since we put out the proposed draft merger guidelines almost 4 months ago. We appreciate really the willingness to take time for busy schedules to help us revise and refine the draft guidelines. And as we move forward towards issuing the revised merger guidelines. You know, in many ways, kind of before I go to comments, I mean, and before we even talk about the final product, I think one of the greatest benefits that we get from kind of issuing these guidelines is that we're all talking about these issues. And, you know, we're not going to agree. I mean, you heard of all the different panels, you know, very kind of thoughtful comments that went in kind of different directions. And the point is not necessarily, you know, to agree, although at the end we have to come up with the document, is just to reopen the issues and study and kind of evaluate them, which I think is a natural process to, and a good thing to do always, right? Rather than kind of say something and say we're going to do something because that's the way we've always done it. We should reevaluate what we do. And regardless of where we end up, just that process itself, I think we've already achieved a lot. But then kind of moving on, since these are the closing remarks and kind of the final planned workshop for the agencies, I thought I would use the time to take stock of what we've heard over the past few months and where we might be heading next. Before doing so, let me just remind you of the usual disclaimer. The views I'm about to express are my own. They do not necessarily reflect the views of the commission or any individual commission. Okay, so the main goal of the guidelines, and we heard that from the very beginning when Susan started, is to update the guidelines to deal with the realities of the modern economy. From an economics perspective, this means sharpening existing tools and, you know, the existing tools, methods, and analysis, as well as adding new ones. I think the guidelines go a long way towards achieving this goal. They lay out the various paths the agency should explore when investigating a merger. We heard Rebecca at the end of the last panel saying, well, there's 3. I guess, you know, we don't disagree with that, except we added 1 in front. We think there's maybe 13 ways in which we should investigate. But, you know, other than that minor detail, we're on the same page there. This is important to open kind of these different frameworks because the modern economy where competition and therefore threats to competition can really present themselves in many ways, right? I mean, we can go back and talk about widget economies or so forth, but that's not what we're facing in the day-to-day reality. So as part of that, the guidelines include analysis of both horizontal and non-horizontal effects. And in the process, what we're trying to do is remove labels. Okay, now, this got a little bit of sort of negative comment. I mean, I think Bill called this kind of the Swiss knife, or maybe that was part of the Swiss knife. And I think Joe also said that maybe it's better to separate these. I actually disagree. I think it's quite important in the modern economy to put these together. Why? Because it's hard to take any except for, you know, extreme examples, to take many mergers and say they're only horizontal or only vertical. Okay, so I kind of want to move away from the idea of horizontal mergers, vertical mergers. We should talk about there's mergers and then there's effects. Some of the effects are purely horizontal in nature. Some of them actually are about horizontal concerns because that's the lessening of competition, but involve various vertical elements. Okay, and you can't really talk about that when there's different guidelines. And what you end up is an argument over, do these guidelines apply or do these guidelines apply? Okay, now it's sort of clear. There's one set of guidelines. They apply to anything. And we can talk as to which numbers. Is it 1, 3, or 8? Or, you know, or is it 2, 4, and 7? Okay, that's what we can do. So the guidelines, and on top of removing these labels, and I think that's also important because it gets us away from, rather than labeling horizontal or vertical or conglomerate or this or that, we can talk about the substance. Okay, we can talk about what are the concerns that we're worried about, right? Rather than trying to sort of argue over labels. And when I say this is not a hypothetical situation, I was the DOJ's expert in saber fair logics, where basically the argument was, should we just use a horizontal deal or a vertical deal, right? And you kind of feel like is that really the best use of the court's time? We should be talking about what the effects are. The guidelines also add and expand a discussion of various topics. Again, we talked about this: potential competition, dynamic competition, entrenchment of monopoly power, and mergers involving platforms and labor markets. Susan touched on all of these earlier. Frankly, I could probably spend my time here today detailing the various ways in which the draft merger guidelines adopt the agency's toolkit for the modern economy. But that's a speech for another day, and indeed, I might give it someday. Instead, let me focus on some of the main critical issues that have come up during the commentary period and where we might be heading next to address these comments. Now, given the large number of comments, I need to be somewhat selective in what I discuss today. However, I want to assure you, as again, several of agency folks mentioned today, we're taking all the comments very seriously. We've gone through all of them. There's even the summaries of them, the cliff notes are extremely long, I can tell you that. But we've really have looked at everything. So I can't talk about everything today, but we are looking at everything today. So one comment that's come up quite frequently, and frankly has come up today several times, is the addition of legal references. Some commenters have responded positively to this addition, while others have responded negatively. Some critics complain that the existence of legal references in what was historically been a document that focused on economic principles. The concern is that the guidelines will risk turning into an advocacy piece reissued by each administration and eventually receive little weight by the courts. Others have complained that they're okay with having cases, but the cases being cited are old and that the legal discussion of these cases is incomplete. So let me talk first about this idea of old cases. So just as a matter of principle, and I speak here as someone who's well over his 50s, I refuse to accept the idea that something is bad just because it's old. Okay, let me just set that up front. More seriously though, the fact that the cases are old is not relevant. Okay, and the relevant question is whether the cases represent the current state of law. Okay, and I'm not going to speak to that. I'm going to let the lawyers debate this point, and I can tell you that the lawyers on the drafting team are looking very seriously at this question that came up in the comments. Okay, I'm also going to leave to others to debate what future administrations are going to do and whether or not courts might or might not do. Okay, I just don't think I have anything to add to it. However, I will note that the economic analysis, even though we want it all to be about the economics, is not done in a vacuum, right? When we sort of think of, sort of balancing that we should do, there's a lot of discussion whether we should do a cross market or not. It's not what we necessarily think as economists, right? We have to always be looking at this, at the economics. It's done within the context of a legal framework, right? In the context of the law. Therefore, it seems natural to me to lay out at least some legal principles up front and then talk about general economic principles before discussing specific tools used by the agencies. So for these reasons, I suspect that whenever I use the word merger guidelines, I'm referring to the final ones that will eventually be issued. For this reason, I suspect that the merger guidelines will contain citations to case law, although hopefully we can focus them on general principles, deal with some of the specific issues raised in the comments, and be clearer about why we cite the cases we do. I'm not sure where we'll end up on this, but this is kind of a question that we're thinking about. Regardless, the merger guidelines will be useful to the extent that they embody helpful underlying principles and economic principles, but general principles, and that is what I'm going to focus on today. Okay. We've generally received positive feedback on the economic tools. I mean, even today, there was very little mention of the appendix. I think, one or two of the commentators mentioned that, and most of the comments have been just included in the document, not, change anything fundamental about it. The main concern, and we've heard that, is that the economics have been quote unquote downgraded relative to the previous guidelines. So I disagree with this characterization. Indeed, I would claim, and I think we heard some support for it today, that there is more economics in these draft merger guidelines than the previous guidelines. In part, the concerns, I think, is really driven by the point before that it seems that the inclusion of legal citations, right, seems to kind of downgrade, right? It's almost like, okay, there is a certain part of the pie. If you have more legal citations in there, you must have less economics, okay? Honestly, I don't really get that. I don't think there's less economics. I think there's more. Others have complained, and this is the part that we've heard today, that the economics tools have been moved to the appendices, which somehow makes them less important, okay? So first, this is not entirely true. There is still a lot of economics in the text of individual guidelines, okay? Maybe not as much as we could have, but they're still there. So for example, I haven't done this myself, but I'm told that the word incentive, which let me call, let me claim ownership of it as an economic term, maybe not, but it's, I think it is. I'm told that the word incentive is used 43 times in the main text, okay? So there is at least some discussion of economics. Now, it's true that the content relevant to multiple guidelines is organized in the appendix. As we said, sort of, as Susan said, and I'll repeat again, the move to a separate section was done to improve readability and to really sort of have the idea there is a body of economic tools and we're going to use them throughout. We're going to use them in different guidelines. We're going to use them in the market definition section, and we're going to use it in the rebuttal section. And it's true that we could, cut and paste this or at least parts of this toolkit and put it in different parts of the guidelines, A, would make them significantly longer, and B, because, you know, you have to adjust the wording a little bit to fit each guideline, there's always the threat that, you know, it might be perceived as we're saying one thing in guideline 1 and a different thing in guideline 7 or so forth. Okay, so the fact discussion is in a separate section. I don't think it's going to change. I just think it's too big of a change at this point. However, just to kind of make sure that everyone's clear that these are an integral part, the merger guidelines will likely include the separate section in the body of the text to make it clear that the economic tools are indeed an integral part of the guidelines. If you saw Susan's first slide that had the section, you might have noticed that the appendix, not called appendix, it was a V for 5 question mark. Okay. We'll also try to be very clear in the issued merger guidelines about the economic intuition between some of the newer frameworks. So we'll try to sort of embody some of the general principles, but a lot of the tools are going to remain in a section, or likely going to remain in a separate section. A great many of the critical comments we received raise issues that reveal ambiguities in the draft. This is very helpful for the drafting team, as it identifies areas where we should add clarification. We heard many of these on the panels today. For example, many commentators have concerned that we dropped the paragraph in the 2010 horizontal merger guidelines that discussed how the unifying theme of these guidelines is that mergers should not be permitted to create, enhance, or entrench market power to facilitate its exercise. I think just on the last panel, we heard at least 2 of the participants kind of refer to this in one way or another. Now, commenters have referred to this as a signal that we have somehow changed the objective of antitrust because we focus on substantial lessening of competition instead of the term of market power. Okay, I don't think this is the case. We focus on substantial lessening of competition because that's the language of Section 7. Okay, and throughout we've added references to legal doctrine. It seems just natural to also refer to that in the context of the main goal. Furthermore, focusing on lessening of competitions allow us to make one of my favorite changes. I know probably also Susan's favorite change as well, namely the discussion of how we explore and present evidence, and a topic that we kind of touched on several of the panels today. Specifically, we discussed the gradual presentation of evidence starting from documents, testimony from either the parties or third parties, win-loss data, estimated diversion, measures of upward pricing pressure, and quantitative models, for example, merger simulation. Okay, I kind of listed it in these particular order, almost sort of building up, right, from the, I don't have to call it least sophisticated or least economic to the most economic in terms of the argument. And the idea is there's a whole list of things that we can do, right? So if you want to talk about market power, if you want to talk about outcomes, okay, it seems like, oh, well, we have to go to the full-blown merger simulation. The point is that we're trying to make is that all of these are indicative of a lessening of competition. Now, if possible, we'd like to check as many of these boxes as possible, including, if we can, the agencies might quantify the predicted outcome for a merger, let's say with a merger simulation, okay? But that's not always feasible. And I stand here in front of you as someone who could say, built his academic career at doing this stuff, okay? But there's something very different than what you can do in your academic career versus having to work with very limited data, very limited time, and different resources. So it's easier to make this point that there's gradual introduction of evidence, all of which speaks to the ultimate goal, even if we don't have an exact prediction of what happens when we focus on a lessening of competition rather than directly on the outcome. And that's, I think, the part of the goal of what we're trying to do here. As an aside, we also clarify, and again, this is a point that Susan made in her introductory comment, that one has to be realistic about what we can expect from quantitative modeling, not to create the so-called CSI effect, which I've actually seen, judges sort of say, well, yeah, I hear what you say, but that's kind of Econ 101. Where's the complicated modeling that I've seen you do elsewhere? Why aren't you doing in this case? And the point is, because, we don't have the data in this case, or we don't have the ability to do that. And even when we do, we have to be realistic about what the prediction that we're getting. Some have been commented we need to be clear about what we mean by lessening of competition, and that's especially if we're going to require a showing of no substantial lessening of competition to rebut a concern with the merger. This is a point that came up a lot in our on the first panel talking about rebuttals. So let me try to explain what I view as a lessening of competition. Okay? Mergers can lessen competition when they diminish competitive constraints, reduce the number or attractiveness of the alternatives available to consumers or suppliers, or alter the incentives of market participants to compete. When mergers lessen competition, they increase, entrench, or enable the exercise of market power. They can cause harm to consumers, workers, and other market participants by denying them the benefits of competition, such as better prices, wages, quality, innovations, and working conditions, among other things. For simplicity of exposition, these effects are referred to as the effects of a lessening of competition. Okay? I hope that this clarification, as I've just stated, in the merger guidelines will help ease the concerns that we've heard from commentators and from the panelists today. We've also heard, including again today, many concerns that the draft merger guidelines rely more on structure than their predecessors. So let me be clear up front that removing the language of market power, right, together with this kind of perceived value of concentration or elevated market structure and concentration is not a signal that we've elevated or tried to change the objective. Okay, our objective is whether merger lessen competition or to create a monopoly. Concentration can sometimes be informative about that, but it isn't itself the point of the exercise. Okay, a point that I think we heard from Joe in the previous panel, and I think he asked us to clarify. Hopefully that, is a kind of a step in that direction. But let me kind of drill down a bit further on this claim of a focus on structural or structuralism. The first concern that was raised is with guideline 1, okay, which, as we heard earlier, kind of lays out the concentration thresholds. Mergers that exceed these thresholds are presumed to lessen competition. Okay? In my view, this captures an intuitive idea. Okay? Let me just ask kind of a, hopefully, a question that's obvious, but what merger would we be more worried about? A 10-9 merger or a 3-2? Okay? Without knowing much more, presumably the latter. That's what the thresholds are trying to capture, is this idea. And they're meant to capture both unilateral and coordinated effects. The general idea is that there's more risk of a lessening of competition when the change's concentration is larger. Is supported by, I think, a lot of standard economic models. Indeed, the substance of guideline 1 is not new. The 2010 horizontal merger guidelines say that mergers resulting in highly concentrated markets that involve an increase in HHI of more than 2,000 points will be presumed to be likely to enhance market power. Okay, this is a direct quote from page 19 of the 2010 horizontal merger guidelines. The difference in substance is that the draft merger guidelines relative to 2010 guidelines is that the threshold in the draft merger guidelines are lower. Okay, the 2010 merger guidelines define the highly concentrated market as an HHI of 2,500. The draft merger guidelines, like the guidelines before 2010, define a highly concentrated market as one with an HHI of 1,800 or higher. Okay, there's also a change in the delta. The draft merger guidelines focus on a change in HHI of 100 points instead of 200 points in 2010. Okay, now let me just be clear. People have asked, can you justify this change? So economics in general doesn't give us prescribed an exact threshold, right? Even though I would claim there's this kind of general association between higher concentration and higher change with the outcome, it doesn't give us an exact threshold of where we should cut things off. However, there is some academic work recently, as well as some commentary before we actually issued the draft merger guidelines that suggest that maybe the 2010 thresholds need to be lowered. Okay, and that was kind of the thinking behind it. The other difference between 2010 horizontal merger guidelines was they were also clearer than the draft merger guidelines that this presumption is rebuttable. The sentence following the one I just read says the presumption may be rebutted by persuasive evidence showing that the merger is unlikely to enhance market power. Okay, that's what 2010 said. So it said, yes, there's a presumption, but it's a rebuttable presumption. The merger guidelines need to clarify that concentration metrics are often a useful indicator that a merger will eliminate substantial may eliminate substantial competition between the merging parties and may increase coordination among the remaining competitors after the merger. It can also clarify that these concerns can be rebutted by the factors discussed in the rebuttal section of the draft merger guidelines, or by providing evidence and analysis using the data and tools described in the appendix, current appendix, or whatever that section ends up being, suggesting that concentration measures are not informative to this specific merger, that this specific merger may lessen competition or tend to create a monopoly. Okay, so the idea is that, yes, they're rebuttable. How are they rebuttable? Well, you have to sort of show that all the reasons that there might be concerns are not applicable in this particular merger. Furthermore, the higher the concentration measures over these threshold, the greater the risk to competition suggested by this market structure, and therefore the stronger the evidence need to be to rebut it. So that's a point also that's kind of missed. You know, might think like, okay, there's thresholds, and once you're over it, it's like, that's it, get sued. No, if you're just slightly over it, you know, you're not going to need a very strong evidence to convince the agencies, probably also convince the court that they might not hold. But if it's a merger to monopoly, right, you probably are going to have a really strong uphill battle convincing that, you know, this really is going to be a pro-competitive merger. So anyway, I hope these clarifications will help ease the concerns regarding guideline 1. So let me move on to other parts of the concerns about structure. So in addition, some of the or let me just mention one other point. In addition, some of the titles used in the draft merger guidelines might have fueled some of these concerns about, you know, concentration. I think someone sort of talked about how there's kind of almost a commandment version of this, right? So saying something like mergers should not significantly increase concentration in a highly concentrated market give the impression that concentration is the end of the story. While what was meant really was something more akin to mergers raise concern when they significantly increase concentration in highly concentrated market. Okay, that's I think what we really meant, but the text really did have this should not language. Namely, a merger that significantly increases concentration in highly concentrated markets indicates a risk, okay, that its effect may be to substantial lessen competition or tend to create a monopoly. Okay, that's kind of the goal, and I think we need to find a way to clearly say that. Okay, let me move on to other parts where we had structure. So let me move on to guideline 6, which we talked a little bit at the end of the third panel. In the first part of this guideline, the draft merger guidelines introduces a shared threshold of 50% of the related product markets for vertical mergers. This threshold has received somewhat mixed reviews, with many questioning the rationale for it. I think on the panel, we maybe wasn't quite as mixed, but we have received some positive comments on it. The intuition is rather straightforward. Okay, and let me try to repeat what I said on the panel, so maybe it's not as straightforward because I did get some pushback on that. So suppose that I told you that a merger gave a firm significant market power, okay, and we could talk whether it's monopoly power, but significant market power, maybe even monopoly power over a product or a service that was important, maybe even critical for other firms to compete, including its immediate rivals. And then I asked you how you felt about that merger. Okay, in my view, that's at least a merger that you might raise concerns. Okay, why? For exactly the reason I said, right? If there's rivals that I might get a chokehold over them by control over something that's important, maybe critical, we can decide where the cutoff is, it could raise a whole slate of concerns. So I suspect that many folks would say the situation indeed raises concerns. Namely, this is a merger that raises the risk that competition would be lessened in the market where the firm and its rival compete. The lessening of competition could be because of foreclosure of that rival. It could be raising the cost of the acquired product service, or simply because the acquiring firm can have some sort of a threat or leverage point that it could use to get the rivals to agree to certain demands. Okay, what are demands? Even sort of agree, you know, collude with me in some sort of form, and if not, I'm going to turn off your access or do something of that sort. So that's kind of the intuitive level. But let me sort of step back and say, let me go and kind of phrase out the claim, and it really contains 3 elements. Okay, and it's important to separate them. First, The merger in question gives the firm significant market power. And again, I said significant market power, even monopoly power. Second, this power is over a product or a service that is important, even critical for other firms to compete. Okay, that's the second element. And finally, some of these other firms are indeed significant rivals, right? So if I have a control over something that Bill needs to compete, but Bill is not my rival, like, you know, that whole story of me having a chokehold over a rival doesn't hold. Okay, the 50% share in the related product market is one way to measure the first element. And I get some control over it. I mean, having some significant market power in the related product market. We can think about this in varieties of ways, but, you know, again, maybe the simplest is that it gives the firm a greater ability to lessen competition by leading access to the related product. And again, that's just one way, going back, I think, to Rebecca's kind of comments at the end. There could be other things that we would be concerned about. This is not saying it's the only thing. It's just the whole idea that I'm giving a rival a control over something seems to be something that we should be concerned about. So this element of having the 50% share must be combined with an investigation of the other two, whether the related product is important for other firms to compete, and whether those other firms include significant rival. Okay, so it's not just saying, hey, we found a 50% share in some market, and that's all that you care about. There's other elements that we will need to prove. So the merger guidelines need to clarify this point. Furthermore, we probably want to be clear that a high market share is just one indication of significant market power. It's not the only indication, and we want to look at those other things as well. Putting these together, the merger guidelines should clarify that if market share or other evidence shows that a merged firm would have significant power over a related product that is a critical input for a group of firms, the agencies may presume that the merged firm has the ability to lessen competition from these firms. Okay? Now, let me just say a word here. It wasn't in my written comment. A little bit was a discussion of EDMs. Part of what we're trying to sort of do here, and again, this is the point of unifying horizontal and vertical analysis, is to say it's the agency's burden to first show harm. Okay? I don't know why it is that when people talk about vertical mergers, the very first part that they start talking about is the vertical integration, the benefits. Well, don't we first have to show that there's concerns and there's harms? And that's what we're trying to do here in both Guideline 5 and 6. Is first establish there's a harm, and then say, yes, we will consider all the, other elements, whether there's rebuttal, whether there's the elimination of double marginalization. But that's going to be part of, if you want, the second step, once we've established that there is actually a concern that we have to be worried about. If there is nothing to worry about, in some sense, whether or not there's EDM becomes irrelevant. Okay, so that's the way we approach it in horizontal mergers. Why not also approach that in vertical mergers? Okay, so that's the second part of the structure, and again, kind of hoping to clarify that 50%. The second part of Guideline 6 and 8 discuss trends and concentration. The second half of Guideline 6 focuses on trends towards vertical integration, while Guideline 8 talks about the general trend towards concentration. Commentary on these has generally been lumped together with the other aspects of structure that I just discussed, again, because of the perceived focus on concentration. Okay, so again, when people complain about concentration, I think they lumped all of these elements together. However, I do think the issues are fundamentally different. Both these guidelines, together with Guideline 9, the state that the agencies will look at the cumulative effect of a series of acquisitions by a single firm, rather than just focus on the effect of each acquisition separately, focus on dynamic competition. And that was the subject of our last panel. The idea is intuitive. The agencies should not just focus on industry snapshots, but instead take into consideration where the industry is trending, as well as the underlying reasons those trends are occurring. Okay? Frankly, this doesn't seem to me like a particularly controversial issue. Rather, it's one that allows merger analysis to introduce much of the recent work in the economics literature on dynamic competition. So we definitely talked about that in the context of serial acquisition, but even the other elements, yes, they need to be fully developed, but at least there's the hook there of where we can start bringing these considerations in. So it seems that this intuition does not come through in the draft merger guidelines. Hopefully, the merger guidelines, the issued ones, will clarify this point, as well as clarify that the agencies will view differently trends towards concentration that are driven by efficiencies, a point that was raised by several commentators and of course came up on our panels today. Somewhat similar concerns have been raised about Guideline 7 that talks about concerns raised by a merger that entrenches or tends to create monopoly power. Some have questioned whether this guideline is needed, since many of the theories it covers will be captured by Guideline 5. It is true that the two guidelines are not mutually exclusive, but frankly, that's true for many of the guidelines, right? And that's kind of part of the point, right? Is we're not sort of saying, we want to find all the exclusive theories. It's like, no, there's a bunch of theories. Many mergers will raise more than one of these. And that's actually, I think, a feature, not a bug of the guidelines. However, Guideline 7, unlike Guideline 5, focuses on the case where one of the merging parties already has significant market power, such that it has or is approaching monopoly power in a relevant market. In markets where a firm already has significant market power, competition typically benefits if competitive pressure emerge or strengthen over time. Transactions that entrench or tend to create monopoly power by disrupting this competitive process can raise concerns. And that's the goal of what we're trying to look at Guideline 7. Examples of the type of concerns that can arise include creating or increasing barriers to entry and eliminating a nascent competitive threat. The merger guidelines need to be clear that generally concerns do not arise when entry barriers are increased solely for improvement from the merged firm's own products and services that result from the merger. I want to briefly discuss one change that, in my view, has not received the attention it deserves, although we did briefly, Joe kind of brought it up and we talked briefly at the end of panel 3. And that's the issue of market definition. So quite often the agencies run into issues in defining markets. I mean, there's actually kind of a litigator's view, I don't know if it's right or not, that that's where the agencies lose cases, is on market definition. Okay? And often this is the case just because of simple confusion. Okay, we're just not able to sort things out to courts the way that we need to. And for that reason, the draft merger guidelines added some discussion, for example, on cluster markets, bundled markets, and one-stop shops. However, the issues often are much deeper. It's not just about simple confusion. And therefore, one of the most significant change in the draft merger guidelines is the treatment of market definition. Again, we touched a little bit about that at the end of the panel. So let me discuss some of the changes. So first is one that we didn't touch on, is that Guideline 2 that states that a merger raises concern would eliminate substantial competition between firms. Okay, the logic here, I think, is straightforward. It's a merger always eliminates competition between the merging firms, and sometimes the most direct and straightforward way to assess the merger's impact is to focus on the strength of that competition. Right? So the reason we focus on that is, again, for the reason I said before, because it deprives consumers / trading partners of the benefits of this competition, namely lower prices, more choices, higher quality, innovation, and so forth. Okay? So the point, or I can imagine in many cases, and again, this touches on a point we discussed, that Guideline 1 and 2 would be used together. And indeed, in many ways, this is how mergers are evaluated in practice under the 2010 horizontal merger guidelines. However, in some cases, where drawing the exact boundaries around the market is difficult, and I would say that's actually was always difficult, but becoming even more and more difficult. Okay, so I would say that's quite often the case in modern markets, where firms often offer very different and differentiated ways of meeting a consumer's needs. So what the agencies could do, or what we open here, is a way to say, if we have evidence of substantial competition between the two merging parties, and that's lessened, maybe we don't start fighting about market definition and focusing on what is the HHI and what is the relevant market. Okay, maybe what we do is we go straight to the competitive effects. Okay, so the challenge with market definition with using Guideline 1 is to identify a group of products that is broad enough that a loss of competition in the market would be harmful, but not so broad that the market shares are diluted in unhelpful indications of a merger's effect on competition. Right? That's a real challenge, right? Because otherwise you say, well, why don't we just go broad and we're done? Right? So Guideline 2 basically allows the agencies to define a market that is clearly broad enough, okay, and not worry about whether market shares and concentration measures are helpful. Okay, so the idea is not to say we're going to walk away from market efficient to find narrow markets. Quite the opposite. Let's go broad to a point that it's almost kind of clear that we meet, a certain brown shoe indicia. It's not really controversial, and let's just focus on competitive effect. And again, this could be useful because it gives the agencies the option to focus on the loss of competition between the parties rather than fight over market definition. Okay, so that's one of the change. Even though everyone focused on guideline 1, they want to put more and more elements on structure. I actually think the big change here, again, once we clean up some language that we need to do, is the idea that for the first time we say there is a way to go here that's clearly outlined that's saying we're not going to build on the presumption, right? We're just going to go and focus straight on the economics, on the competitive effects, right? That's it. Now, second change, and that is kind of what we talked about, is when we talk about market definition, we talk about 3 ways to define a market. There's really 4 factors, but one of them really is just about market power. So in terms of merger, it's really 3. And the 3 are direct evidence, brown shoe, and the hypothetical monopolist test. Okay, direct evidence basically says if Chad and I compete, right, we have evidence of us competing, that in some sense tells us we compete in some market. Maybe it doesn't tell us what market it is, so we can't use it to compete market shares, but it tells us there is a market at which we compete. And at that point, we satisfy the legal requirement of showing that there is a market that we've competed. So that's that. The other 2 are brown shoe and the hypothetical monopolist test. So some have wondered, as Joe did today, why we're putting the hypothetical monopolist at the same level as these 2 other approaches. Okay? The idea is to offer an alternative to fighting over market definition and instead relying on the idea that the agencies may evaluate a merger in any relevant market. Okay, any again is the language from the statute. We are building on this to say that we can rely on any market that satisfies one of these criteria. And what we're trying to take off is that there's no such thing as the best market. Okay, and an argument as to which market is better is not an argument to be had. Now, that being said, note that if the agencies are going to rely on concentration measures, then there might be an argument about whether the shares in the market that the agency identify are informative. Okay, in this case, there is a question of which market shares best reflect competition, and in which case one would need to rely strongly on the hypothetical monopolist test and claim that the market being used is the shares being used are indicative. Note that this is the case where the agencies rely heavily on guideline 1. Okay, so indeed, one could actually argue that the extent that these changes are making, reliance on market shares harder, it says that it's a tendency towards having less reliance on structure and more reliance on competitive effects. So let me just conclude by saying most of my talk today was about the concerns raised by the commentators and the way we propose to address these. Now, I don't want to leave you with the wrong impression of the comments we got. So while we clearly have some work to do, we've received positive feedback on large parts of the draft merger guidelines. For example, besides a few mostly drafting issues, the feedback on guidelines 2 through 5, as well as the appendices, has been quite positive. Similarly, the comments on the new material in guidelines 9 through 11, including the discussion of serial acquisitions, platform, and labor markets, have been largely positive, and I think that was reflected in our panels today. So we hope to implement the revision and issue the revised merger guidelines soon, and just keep on watching because something is going to come soon. So thank you very much for your time and your attention. Okay. I did say I'm happy to take if there's any urgent question, but if only have 2 minutes. But okay, we got a few more. Yeah, Joe.
So in order to be happy with going overbroad on market definition when you have direct evidence of competitive effects, you also need to lose the safe harbor for low concentration in the relevant market. And I noticed that you had lost the safe harbor, but you didn't comment in the draft specifically on that. Are there commenters who view that change in isolation and say with presumably great alarm, you've deleted the safe harbor, and that was kind of the main thing preventing the agencies from challenging tons of transactions?
So you'd have to excuse me if I don't remember the 43,000 comments or so off the top of my head. That is not at least a comment that I have gotten on the many panels that we have, but I can't speak, as to whether it came up in one of the written comments, but we can check on that. But I have not received that on the numerous panels that I've been over the last 4 months.
Very interesting.
Well over 20, I would say. Eric.
So you said in your remarks, you said in passing that a merger to monopoly could be pro-competitive. And I wanted to, that recalled to me actually the some lines in the 2010 guidelines that have always puzzled me. And this is the market power sentence that I think you were referring to. It says a merger enhances market power if it is likely to encourage one or more firms to raise price, et cetera, et cetera. And I don't think that's a correct definition of market power, because a merger could not raise prices because of efficiencies. And so normally we would say market power goes up, but price goes down nonetheless because of the efficiencies. But these guidelines are conflating, I think, competition and
Sorry, you're pointing
the
at-
2010 guide.
Okay.
You can't tell. The 2010 guide. So
I could tell. I just wanted to pull on online to tell.
So, but it's not clear, are there, and I think, a lot of the debates online about the guidelines are about this issue, which you kind of danced around, but I don't think quite addressed, which is, it seems to me pretty clear that under the 2010 merger guidelines, despite the structural presumption and everything, that if prices don't go up or go down, the merger is okay, even if it's a merger to monopoly. And is it the case that these guidelines repudiate this view, or do they endorse, or are they subtly endorsing this view? That's my question.
So, a couple of things. First, you start off by saying that I said a merger monopoly could be pro-competitive. I might have misspoken. I don't think I meant to say it, but
Anybody else hear this? It's been recorded. so-
okay, maybe I'll go in. Well, I talked about the likelihood, but I'm saying that I thought what I meant to say was that the likelihood of it being pro-competitive is very low. Maybe you wanted me to say zero, but
That's what I meant. It was non-zero.
okay. I mean, I don't
Yes,
think that
it
as a
could
matter of
be
theory, you want to say that, it could never be pro-competitive, but I'll let you sort of argue with that separately. In terms of, so look, there's a lot in your questions. I'm not going to be able to answer it unless I'm going to miss my flight. But you are correct in sort of pointing out, and look, I'm not here to criticize or comment, on the 2010 guideline, but there is sort of a point that even though the first paragraph of 2010, or that paragraph in that introduction in the second page talks about the unifying theme being about market power, it's a little bit hard to reconcile that than what happens in efficiencies, right? The discussion there of sort of saying, so suppose a case, let's for a second assume that market power, let's equate that with margins. Because let's talk about price, let's just equate that for margins just for the thing. So suppose there's a merger that does the following. It's going to increase margins, but marginal cost is actually efficiencies are going to decrease marginal cost by even more, that it leads to lower prices. Okay, so that's a merger. I would say, again, if we define margins as market power, would entrench or increase market power, yet with lower prices. Okay, I think my reading of 2010 that's a merger that they would say is pro-competitive, even though it did increase market power. Okay, I think that's kind of the reading. Now, I'm sure there's kind of other ways to kind of view this, not as simplistic. So that's in part also, I didn't go into that, but that's in part, for me, part of the reason why I actually thought this idea of let's try to define what a lessening of competition is, rather than say a lessening of competition. Well, we don't know quite that is. So that's market power, and what exactly that market power is not quite clear, like, why not just go directly and talk about what we mean by lessening of competition? I think the best way to define lessening competition is almost to talk about what are the effects of competition, okay, and what happens when those when a lessening competition kind of deprives consumers, workers, trading partners of those benefits. Okay, so I think that's kind of the best way. So anyway, I'm not sure if I answered part of your questions, but again, to fully answer it, I'm not sure that we would have time. All right, maybe I'll take one more question if there is one, and I don't want to stand between us and drinks or whatever is next or whatever is in the back there. It looks pretty good. So, okay. That's it.
No, but,
All
okay,
right,
thanks,
thank
Bill.
you.